I open this hearing of the Parliamentary Joint Committee on Corporations and Financial Services into the oversight of ASIC, the Takeovers panel and corporations legislation. I begin today by acknowledging the traditional owners of the land on which we meet, and I pay my respects to their elders past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples here today. The committee will be conducting today's hearing in person and, if needed, via teleconference. These are public proceedings, being audio streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It's unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as contempt. It's also a contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. I remind any committee members and witnesses who are appearing via teleconference to mute their microphones when they are not speaking. And I want to take the opportunity on this occasion to make clear to those who are listening and those who might engage with the transcript of this hearing, the terms of reference that this committee covers. The statutory basis for our inquiry is conferred by Section 243 of the ASIC Act, and it specifies that the committee's duties include inquiring into and reporting to the Parliament on activities of ASIC or the Takeovers panel, or matters connected with such activities to which, in the Parliamentary Committee's opinion, the Parliament's attention should be directed. Or 2, the operation of the corporations legislation, other than the excluded provisions. Or 3, the operation of any other law of the Commonwealth or any law of a state or territory that appears to the Parliamentary Committee to affect significantly the operation of the corporations legislation, other than the excluded provisions. Or 4, the operation of any foreign business law or of any other law of a foreign country that appears to the Parliamentary Committee to affect significantly the operation of the corporations legislation, other than the excluded provisions. In fulfilment of this statutory duty, the committee conducts an ongoing oversight inquiry for the life of each Parliament. The committee has the power to invite submissions, to question witnesses at hearings, and to require documents to be produced. The committee also has the flexibility to determine how it approaches this ongoing inquiry, including in relation to whether and how to invite written submissions and the frequency and structure of its hearings. The committee, of course, reports its findings and recommendations to Parliament from time to time at the committee's discretion. And it is a pleasure to chair this very significant committee, so important to the fundamental workings of our economy. I'm delighted to be joined here today. I'm Deborah O'Neill, the Chair, Senator for New South Wales, a Labor Senator. Representing the opposition today, Senator Paul Scar, fantastic colleague from Queensland, and Ms Tanya Lawrence MP from Western Australia. We also have Mr David Moncrief, who will be joining us shortly, and I believe Ms Madonna Jarrett will also be with us through the course of the day. Can I thank you all for being here? Chair Longo, can I ask you, if you wouldn't mind, for the purposes of Hansard, to acknowledge that you have received information on parliamentary privilege and protection of witnesses giving evidence to the Senate, and then state your name and the capacity in which you appear.
Yeah, thanks, Senator. I can confirm I've received that information, and I appear as Chair of ASIC, and I'm here with other commissioners. I think they've been introduced before, but when they speak, they'll introduce themselves. If
we
that's
might just
okay.
get them to go on the record straight away so we know who's here.
Yes, that's a good one.
We might start with Mr Gregson, please.
Thank you, Chair. My name is Scott Gregson, ASIC Chief Executive Officer.
Simone Constant, Commissioner with ASIC.
Kate O'Rourke, Commissioner.
Alan Kirkland, Commissioner.
Chris Savandra, Executive Director of the Enforcement and Compliance Group.
And I now invite you, Chair Longo, to provide the committee with a short opening statement, at the conclusion of which there will be questions.
Thank you, Secretary. Just before I do that, for completeness, my Deputy Chair, Sarah Court, gives her apologies. She's unable to be here today because she's attending OECD Market Committee meetings. And I'm hoping she'll be back on the weekend and back in the jurisdiction next week. So good morning, Senator, and to the rest of the committee, and thanks for this opportunity to appear again today. I'd like to first acknowledge that Senator Paul Scar has just rejoined the committee, and of course acknowledge the contribution of Senator Jane Hume. As always, I'll make some observations about our enforcement. ASIC is one of the most active law enforcement agencies in the country. We're taking more cases to court, achieving record penalties and protecting consumers. I'm pleased to report to the committee that through our ongoing determination to build up our enforcement capability, ASIC secured a record $350 million in civil penalties and $583 million back to Australians from July to December last year. That's just half the year. This includes recovery of funds for those affected by the First Guardian and Shield matters. We are holding individuals to account for their actions in civil and criminal matters. They are facing the consequences for their crimes, including jail time. Just yesterday, the Federal Court found two former senior executives of the Star Entertainment Group Limited, the former CEO, Matthias Becker, and the former Chief Legal and Risk Officer, Paula Martin, breached their duties in relation to their handling of the risks associated with money laundering and criminal activity at the casino. The court also found that 7 non-executive directors did not breach their duties in this case. The matter will be listed for a further penalty hearing when ASIC will ask the court to impose a financial penalty on Mr. Becker and Ms. Martin and to disqualify them from managing corporations for a period of time. That matter will be listed shortly. ASIC pursued this case because of the fundamental questions it raised about trust, governance and accountability at one of Australia's largest casino operators. ASIC will always require directors and executives to meet the highest standards of corporate governance because of the crucial role they play in maintaining trust. In October, the Supreme Court of Western Australia sentenced Mr. Chris Marco to 14 years imprisonment with eligibility for parole after 12 years. Mr. Marco was found guilty of fraud offences against investors totalling more than $34 million. The sentence was the highest imposed by an Australian court following an ASIC investigation. We note that Mr. Marco is currently appealing his conviction. In November, Krishna Kumar Agrawal was sentenced to 4 years and 10 months imprisonment with a non-parole period of more than 3 years for dishonest use of his position as a director. This matter related to a property group that collapsed owing investors from Sydney's Indian community of over $20 million. In January, just earlier this year, former investment manager Rodney Forrest was sentenced to 6 years imprisonment for insider trading and procuring others to trade in more than $3 million of Platinum Asset Management Limited shares. We note that in February, Mr. Forrest filed an appeal with the Federal Court against his sentence. This marks the first outcome for ASIC's new specialist insider trading team, which investigated and finalised the case within 16 months of the offending. We expect to make a number of criminal referrals for insider trading to the Commonwealth Director of Public Prosecutions this calendar year. We also continue our focus on pursuing enforcement actions that have the greatest impact on the most serious harms within our remit and that reverberate across the market. On ANZ, the bank was ordered in December 2025 to pay $250 million in penalties for widespread misconduct and systemic risk failures affecting the Australian government, taxpayers and at least 65,000 retail customers. This represents the highest ever penalties imposed on a single institution in ASIC's history as a regulator. Our banks need to get the basics right. We continue to prioritise pursuing misconduct affecting consumers, businesses and the economy. Separately, new ASIC data released just last week shows an increase in the reports of misconduct, driven largely by corporate governance concerns. Between 1 July and 31 December 2025, ASIC received 9,686 reports of misconduct, raising 13,036 issues. Corporate governance matters accounted for 40% of these issues, with financial services and retail investor issues totalling 44%. We believe the figures point to an increase in concerns being raised about corporate governance issues and underscore our enforcement priorities for 2026, which include tackling governance and directors' duties failures. ASIC has a number of active investigations into governance failures and directors' duties. Robust governance isn't just good practice, it's good for business and it's good for the Australian economy. First Garden and Shield is an enforcement priority for 2026. Our primary aim in these matters has been and remains to preserve available money for the benefit of investors. We continue to work with all stakeholders, including government, on this. Last month, ASIC began a widespread communications campaign to those who invested in First Guardian and Shield, including a link to a dedicated consumer website that contains trusted and independent support and options to make a complaint. Our litigation continues apace. Since our last appearance in September last year, we have taken action in court against SQM, the research house responsible for the ratings of the Shield Fund, financial advice firms, Interprac Financial Planning and MWL, lead generator Imperial Capital Group, and Diversa Trustees Limited, alleging failures concerning the First Guardian Master Fund. Around $300 million was invested into First Guardian through superannuation funds, for which Diversa was trustee. I want to thank and acknowledge all the ASIC staff involved in this work, with many working around the clock, after hours and over many weeks. And can I say to the committee, that's been happening for over a year. This is a major, major piece of work by a lot of people at ASIC and with the help of external solicitors and counsel. I would say almost of historic proportions. We will not rest until our work on these matters is complete and those responsible have been properly held to account. ASX. In December 2025, we announced a number of commitments that ASX Group have made to ASIC in response to findings in the interim report of the ASIC panel inquiry. These included strengthening the independence and governance of ASX's clearing and settlement facilities boards, a strategic reset of ASX's transformation program, Accelerate, with clear milestones and accountability for delivery. The imposition of an additional $150 million capital charge on ASX Limited to ensure ASX maintains robust financial resources until remediation is complete. That's an unprecedented step that ASIC has taken. Perhaps we'll have a chance to talk more about that later. The capital charge will remain until ASX Group achieves the milestones identified in the Reset Accelerate program, and ASIC agrees to reduce or remove it. So the charge remains until the change happens. This is in addition to existing capital requirements applying to ASX Group entities, including regulatory capital requirements on ASX's clearing and settlement facilities under standards set by the Reserve Bank of Australia. So that capital charge is in addition to the capital charge or capital requirements overseen by RBA. ASX has confirmed it has enough liquid assets to meet current requirements and will clearly show this in future disclosures. And finally, and certainly not most unimportantly, a commitment to stronger leadership. You will have seen that the ASX are looking for a new CEO as a result of an announcement made only a couple of weeks ago, I think just recently. These measures aim to strengthen confidence in ASX and Australia's critical market infrastructure and provide certainty about the market operator's reset. The inquiry's final report is due to be delivered to ASIC by the end of this month and will be released publicly shortly thereafter. We welcome the committee's questions. Thank you, Chair.
Thank you very much, Chair Longo. And can I thank and congratulate the people at ASIC who prepared the brief for today. It is detailed in a way that I can't say it has been in the long time that I've been on this committee. I think we've developed much more robust processes. And I will come to some questions about the nature of papers that come before different committees as much as they come before boards and what it requires of us in terms of engagement. So congratulations, thank you. It has informed, I think, what will be good questioning throughout the day. Can I go to the very significant finding yesterday? Right across this city, certainly, and across the nation, people have been watching, you know, the shameful story of what was allowed to happen at Star. That required extensive public investment of funding to get to the bottom of what was occurring. And what appears to be a significant culture of willful blindness or determined ignoring of signals and information. In Justice Lee's judgment yesterday, there were quite a significant number of comments that, in my view, go to the ethical disposition of people who are undertaking roles within the corporate sector in their professional capacity as corporate managers, in their professional capacity as legal advisors, and in their professional capacity as members of the board. Mr. Lee said that directors could not be passive recipients of information, that they needed to do more work in keeping management in check and to push back on large volumes of material given to them before board meetings. But he also indicated that there were some serious concerns about the culture at Star as being dysfunctional and unethical. Now, in my understanding, there is a judgment, as you've indicated in your opening statements, against 2 of the management team. I know that you brought concerns about the behaviour of the board. This finding yesterday, I think, is a significant one. As I understand it, the board have not been sanctioned, but there are some very important signals for every board member in every entity that is operating, and I would like to give you the opportunity to put on the record your response to what that reveals, what the finding yesterday actually revealed. What does it mean for people in the corporate sector?
I might just start by saying it's a 500-page judgment, which I'm still digesting myself. I've obviously
I lent an effort, according to Mr. Lee, to read, apparently.
And I've obviously received a lot of assistance overnight to absorb the findings and the judgment. And so I'll do my best this morning, but can I just say I'll be reflecting on this over the weekend. And the first thing I really want to say about this judgment is what an extraordinary contribution to jurisprudence it is. It's over 500 pages. Clearly ASIC is disappointed in aspects of the result. I'll come to that in a moment. But it's an extraordinary judgment. We're studying it very carefully, as is the market. Although the judge said that there was no new law, he went on, I think, to make a whole range of observations and contributions around AI, technology, the significance of directors' duties. And so I think I really want to start with that we're going to take some time to absorb this judgment, and I think the market will as well. I should also say, of course, that the case is still part heard. It will go back before His Honour over the next week or two, where, as he said at the end yesterday, orders will be made that are in conformity with his decision. So let's just go there briefly. I think it's fair to say that ASIC's allegations or contentions against Paula Martin, the General Counsel, were upheld, and most of the alleged contributions, I think 7 out of 10 or 4 out of 7, we give details in our media release, were upheld against Mr. Beckier. Not all of them, but I think it's fair to say most of them. And finally, the independent non-executive directors, and of course there's a lot of interest in His Honour's reasons for not holding that they contravene the law, that they were found not to have contravened the law and not to have breached their duties under the Corporations Act. I think there are a number of observations that can be made they might be better done through a question and answer conversation. But I think the second proposition that comes from this, I think there can be no doubt in my mind and in the Commission's mind it was the right thing to commence these proceedings. There was widespread community concern about what happened at this institution. The judge himself acknowledged that in terms of the circumstances of this company. There was the Bell inquiry. There was a lot of disquiet around what happened at Star. ASIC commenced its investigation early in 2022, coming out of those inquiries and announcements, as we discovered what was going on there. And in the same year, we commenced these proceedings in December 2022. So these are important proceedings. At their very heart is the role of directors, the board, and the role of management. Now, I'm happy to discuss a little bit this morning that fundamental issue, but His Honour really went to some effort and length to study the documents, find the facts, apply the law to the facts, and in a very nuanced way go through it. But I think it's fair to say that his findings were not, although he did not hold the 7 independent non-executive directors that they didn't breach the Corporations Act, I think it's fair to say, and I think the Chair's, the way you asked the question shows that it wasn't a ringing endorsement of the board at all. And I think there's something I would like to say about that. I'm often asked, and let's put Star to one side, I'm often asked, well, why did you go after those directors? Or, why didn't you take action? And I think it's very important to acknowledge that the legal standards around bringing litigation like this are very high. And the fact that community expectations, indeed my expectations, or Parliament's expectations might be, well, gee, that board could have done a better job, or that director could have done a better job. And that may be true. In broadly speaking, it might be true that they could have done a better job. I'm not necessarily talking about Star just yet as a general matter, but that does not mean...
on public record they could have done a better job.
Yeah.
I don't think you're a...
Yeah, but I want to be very careful here, because I want to be very respectful of His Honour's conclusions. They're very carefully considered. What I'm trying to say, Chair, is that the fact that the community might be unhappy with the performance of a board does not mean the law has been broken.
And this is why I wanted to explore this with you this morning, because Justice Lee's reported comments are that directors are under a continuing obligation to keep informed about the company's activities.
Yes.
Their responsibilities are to interrogate, to probe and challenge where necessary. And I'm quoting him directly as reported in this article by, what's from the AFR, must be the editorial. They cannot be passive recipients of information.
That's right.
His commentary that these roles handsomely remunerated, and I'm quoting now, not just tokens or glittering prizes decorating a CV. Also very instructive, before we get to the AI issue. So from that arises a concern that I have with parallel reporting, I believe in the same paper by Max Mason, who quotes a response from a partner, a senior partner at Herbert Smith Freehills Kramer, Rebecca Maslin Stanage, who has advised the boards of many large companies, according to this article. She indicates that Lee's ruling would be resoundingly a massive sign of relief for non-executive directors. Now, this poses quite a question for me. It seems Justice Lee's volume of assessment is pointing to an ethical failure of the board, and perhaps a quality standards failure of doing their jobs properly, but not sufficient to breach the law. And I'm getting the vibe, if I can put it in that way, from Ms Craper's comments that, oh, phew, we dodged a bullet there. It's okay, let's go back to business as usual. That is of grave concern to me, Mr Longo. What reassurance can you give me that Justice Lee's reporting and response to this case will not lead to a relaxation of a sense of responsibility for the corporate boards of the country?
Well, I can't speak for Rebecca Maslin-Stanage, but one thing I can say with certainty, the judge has spoken, and he took some time, some 500 pages, and he has reconfirmed, reasserted fundamental principles supporting the duties that explain and elaborate on the duties of directors. I don't think there's anything in this judgment that should suggest to directors, whether they're non-executive or not, that their duties are not still very high. So one should not confuse the judge was at pains to talk about the ASIC's job was to lead the evidence, plead the contraventions, and His Honour, in a very methodical way, he talked about the tsunami of documents that were in front of him, and the submissions that were in front of him. His job was to look at the pleaded contraventions, look at the admissible evidence, apply the law to that evidence in circumstances where none of the directors were required to give evidence. They exercised their right to remain silent, and that's their right. So I think what's really important here is that there's the legal standards, and then there's the standards that the general community would apply. But I don't think there's anything in this judgment that suggests a relaxation of duties. In fact, just overnight, I've been given a copy of the Australian Institute of Company Directors' immediate sort of take on this judgment, and I don't see any suggestion that this is sort of a backward step for directors' duties. This is a fact-sensitive judgment. It's nuanced. So I think the people need to be very careful about saying, "Oh, it's going to, our duties are going to be pretty straightforward to exercise now." I don't think that's the message of this judgment. The ASIC did not succeed in establishing contraventions of the Corporations Act, but I think His Honour, in a very nuanced, carefully considered judgment, made a substantial contribution to our understanding of some fundamental directors' duties. But let me be very clear about what I think some of that contribution is. Yes. And what lies at the heart of the case is this question of reliance on management. And so you've got directors, and they're entitled to rely on management in terms of, I'm not talking about Star in particular, just as a matter of principle, but Star is a really good, if I may say so with respect, elaboration of the considerations and principles that are taken into account in what I'm about to talk about. So if you're a director, particularly of a larger entity, a complex entity, then you're entitled to rely on the information given to you by management. Now, the critical question is that reasonable reliance? You know, were you reasonable in relying on that? And that's at the heart of what happens in boards. And so so without going into the detail in this hearing, His Honour meticulously went through the evidence as he found it, the facts as he found it, and applied the law to those facts, and he landed where he did. But in doing so, I think it's fair to say, I mean, I'm quoting him now, that, so I can find the issues in this case haven't turned upon any novelty, no new legal principle. In its application, however, it is necessarily contextual. Whether the statutory standard is met is not determined in the abstract, nor by reference to how matters appear with the benefit of subsequent events. It requires evaluative judgment. And I think there's some other statements here where I think he's made it reasonably clear that he had significant concerns about what happened here. So I'm quoting now, I hope accurately, but one cannot fairly review all that material without a sense of disquiet. of directors not actively pressing management with difficult questions as to whether the business was being conducted ethically, lawfully, and to the highest available standard. And then he goes on to say, given some of the lamentable events canvassed in these reasons, the board's self-congratulatory submissions of the non-executive directors are jarring. So His Honour, this is a very complex, very long judgment, and stepping back from it, I think it deserves reflection and analysis. The court held that the law was not breached by these non-executive directors, and in making that decision, that His Honour's made a range of observations and statements that I think are very helpful and insightful about his view about the content and breadth of the directors' duties. But I hope you can take from my remarks that I don't entirely agree with Ms Stanich's characterisation. I think that this judgment is we're still considering it, but I think it's a serious contribution to what's expected of directors in this country, and we'll be acting accordingly.
And the Australian Institute of Company Directors, I'm sure, will be taking this on board. And I guess I always think that critically, the laws are what we resort to when ethics fails. So ethical judgment needs to be applied, and that's a professional responsibility, and we've gone around the table many times on that. Just some of the words that are attributed to the directors in this case for Star were, by Mr. Justice Lee, were incurious, complacent, failed to apply an inquiring mind to those responsibilities, and failed to step in to oversee properly Star's handling of those risks. The law expects significantly more from boards, to put that in summary. So while they retained their silence and they've walked away at this point of time without a formal judgment, clearly this is significant reputational damage to all of those individuals who should have been more curious and less complacent.
Yeah, I'm still studying this judgment. I think I might be assisted by Chris Savandra. His Honour did not find that they breached the law, but they hadn't discharged their duties. So one shouldn't, and I hope Mr. Savandra might be able to correct me on this. It's been a long week. His Honour made a range of very interesting observations and insights and reflections about directors' duties, about the role of AI, about board packs, about what's expected in terms of keeping yourself informed of the business, about the seriousness of casino, of the casino business. But I think it's well to remember that where he landed, was that based on the admissible evidence and what was pleaded against the directors, that they didn't breach the law. And I really want to respect that conclusion.
Yes.
This is a really long judgment. It's very nuanced. His Honour acknowledged the contributions of counsel on all sides, that there's been a skillfully presented case. Some of Australia's leading counsel were before His Honour. I think it deserves some time for us to think about it.
Absolutely, I agree. It's clarifying, though, in quite a...
But I will be speaking to the AICD on Tuesday, so I have the weekend to continue my reflections. I'll be giving a speech.
We might ask you to send that to the committee. I'm sure there'll be interest. Just before I share the call, I will have more questions. I particularly want to come to the AI dimensions. But can I just clarify, and Mr. Savandra, you might have the detail of this, what are the qualifications of the two individuals who have been found wanting by Justice Lee? Do you know?
Chair, I don't know off the top of my head. Obviously, Miss Martin was the company secretary and operated as a lawyer, so I take it that she's a lawyer. Whether she's currently a lawyer, I'm unsure. So if I could take that on notice, we'll come back to you.
And can you yes.
Just for completeness, we sued 11 individuals.
Yes.
2 of them actually settled with us, Harry Theodore and Gregory Hawkins, former Chief Casino Officer and Chief Financial Officer, respectively. So of the 11, 4 were found, well, 2 admitted they'd breached, 2 were found to have breached, and 7, the independent non-executive directors, are found not to have breached the Corporations Act in all of these circumstances.
Okay, and the 2 who admitted?
Yes.
Could you restate their name and what their roles were?
Well, it's in the media release. Star's former Chief Financial Officer, Harry Theodore, and its former Chief Casino Officer, Gregory Hawkins, admitted breaches of their duties as officers of Star before the trial. At that time, the court imposed financial penalties against Mr Theodore and Mr Hawkins and disqualified them from managing a public company for 18 months and 9 months, respectively. And as Justice Lee noted yesterday, that was handled by a different judge, as it happened. But just for completeness, I thought I'd mention that.
Thank you very much. So this next concern that I want to raise goes to a matter that this committee has taken very seriously, which is professional responsibility, professional certification, and the gap between belonging to a professional body and discharging yourself from that body to take on roles that are similar, well, using that knowledge but no longer provide you with scrutiny, but there's no scrutiny over your work in the new role that you take on. So we're not sure if Miss Martin continued to be certified under legal
my understanding.
circumstances.
I've just been informed that she's no longer practicing.
Right.
So
Was she practicing at the time?
she was.
Okay. So I don't know that you can answer these questions, but we will have the professional bodies for the accounting profession before us, given our wide powers and given what we've just discerned about Miss Martin here. I might ask the committee to consider whether we think about getting some of the professional law bodies in as well, because there seems to be a very sophisticated tango, shall I say, going on between lawyers and financial gurus, particularly accountants and auditors, around the way in which some of the corporate activity is being undertaken. And saying you're a lawyer seems to give you entree to a whole series of behaviours, and we've seen the abuse of legal professional privilege in other contexts. So questions are really starting to come to the fore for me about ethical responsibility, the right to call yourself a lawyer, the right to call yourself an accountant, the right to call yourself an auditor, and that professional oversight, the ability to either hang out a shingle or have that withdrawn, the nature of the sanctions. All of those issues, for me, are absolutely coming to the surface again in my very brief encounter with Justice Lee's document so far. So I think that there is work for the committee to do, and I'll be looking for my colleagues and their endeavours to try and get a little more on that. Can I ask, in your inquiries, did you have any interactions with the Law Society under which Miss Martin holds her authority to practice law?
I'll need to take that on notice. I don't believe we would have, but I'll take it on notice.
Okay. And the two who admitted that you've just referred to, Mr. Longo, in your interactions through the course of this inquiry, at what point were the professional bodies advised that there was concern or activity around by ASIC with regard to these individuals?
Well, again, I think we'd take that on notice. But my understanding, the chronology here is there was that inquiry, and ASIC commenced its investigation early in 2022, coming out of the public revelations in a 2021-22 inquiry initiated by the New South Wales Independent Liquor and Gaming Authority into Star's suitability to hold a licence. Alarming evidence emerged during the inquiry of the infiltration of organised crime syndicates in Star and other matters, and that led to us commencing our investigation, perhaps in the same.
Yeah, if you could have a look, because sometimes there's an assumption, if it's in the public, that the professional associations are aware of it and that they will act. Sadly, that hasn't been the case in many of the circumstances that we've discussed to date. And then my question is about, to whom should reporting be done and at what time should it be done? And ASIC, as you have indicated, has received 9,686 reports of misconduct, raising 13,036 issues. What's the standard operating procedure in terms of this person is under investigation? Is there a trigger for you to identify that individual to the body through which they are, enabled to practice in this country?
Well, in this particular case, Ms. Martin was not a director but an officer.
Yes.
And discharging the duties of a general counsel and company secretary, if my memory serves me. But we're happy to come back to the committee on notice to see what, if any, engagement we had with the relevant law society. But as I've mentioned, this investigation was really triggered by the public revelation coming out of that New South Wales inquiry.
Yes.
And indeed the efforts of, even Justice Lee acknowledged them, of investigative journalists. So,
Well, the people of New South Wales had to pay for that inquiry. Yeah. I want to make sure that their taxpayer dollars, as a woman from New South Wales, our taxpayer dollars, that, are actually doing the job that they need to do. We want to get good outcomes for the Australian people out of all of that investment, and you'll continue your further action as well. Can I thank you for the responses, and I'm going to give the call to Senator Scarr, and then I will follow with Ms Lawrence. And 20 minutes, Senator Scarr.
Yeah. Thank you, and good to be with all my friends from ASIC again. I'm not sure I'm allowed to say that in terms of oversight inquiry, but
from the transcript.
I too have been reading the reports of the judgment that was brought down yesterday, as you'd expect, and congratulations to Justice Lee in his inimitable way, bringing his forensic mind to bear on the case. And I acknowledge the comments you've made, Chair, in terms of we need to respect his judgment. He's gone through the evidence on in a very forensic manner, and that needs to be deeply respected, and that includes his decision that the non-executive directors weren't in breach. In terms of process, this is the judgment at the first instance. What's the process for ASIC now after this judgment was brought down?
Yeah. Well, as I mentioned earlier, it's technically part heard. So over the next week or so, if my memory serves me from what His Honour said, a date will be fixed for orders to be made by His Honour in conformity with the judgment. So the technical procedural answer to your question is that he'll make orders dismissing the case against the independent non-executive directors and making appropriate declaratory orders. I'll get some help from Mr Savandra, declarations of contravention where we were successful against Paula Martin and Mr Beckier. And then His Honour will make a decision about what the penalty should be for Mr Beckier and Ms Martin. Now, I've been very careful not to talk about appeals.
I know, I've noted.
And,
That's
so
where
I'm not going to beat her out. I mean, I held out for as long as I could.
Well, there you go.
But seeing you ask me, look, I actually meant what I said earlier. It's a long, learned judgment.
Sure.
I have an immense respect for the court in general, and of course Justice Lee in particular. I'm working my way through the judgment. It's a real, although His Honour rather modestly says there's no new law, the way he talks about the law is very insightful. I mean, his points about documents and the control of information that goes to boards, his observations around AI are really fascinating. He makes a range of other observations that I think directors throughout the country are going to be very interested in, and in fact the AICD overnight's already published some good material. So I think whatever happens, this judgment is is highly significant. Now, I don't know whether there's going to be any appeals. I think my focus at the moment is to understand what His Honour said and to complete the first part of the process, and we'll see. I mean, I don't. The Commission hasn't had a chance to meet together and think about that or take advice or anything like that. I think what I can say honestly and openly is that it's obviously an immensely significant judgment, carefully thought through, and there's something for everyone in it.
So just to tease this point out in
Yes.
terms of appeals, and you said you don't know whether or not there's going to be any appeals. From a process perspective, what is the process ASIC
Yeah, I
will
think
go to in terms of obtaining appropriate advice
Yes.
as to whether or not there should be an appeal with respect to part.
Our normal process in any case where we've not succeeded is to take advice on whether or not to appeal. So I really want to be very clear that we're just going to follow our normal process. So we're going to carefully consider this judgment. This one's a bit unusual because of its length, complexity and significance. But
In the public interest.
Yeah, and in the public interest, we will study the judgment, and the Commission will take advice from its counsel and make a considered decision whether or not it's in the public interest to take the matter any further. Now, of course, there are some individuals that, of course, where adverse findings have been made against them, and they may want to appeal.
Sure.
So we'll have to wait and see what Mr. Becker and Ms. Martin do. But as far as we're concerned, our normal process is we will carefully. This judgment has been unusual because of its length and complexity and significance, but we will carefully consider it. We'll take advice. The Commission will meet, and if we think it's in the public interest and there are grounds for appeal, then we will consider that. But I really want to stress to the committee and to obviously these proceedings are public that we're a long way from that. We are very focused on understanding this judgment, getting through the next hearing. We need to work with the court to make the appropriate orders in conformity with the judgment and make submissions in connection with penalties. So it's not really appropriate for me to talk about this any more than that, really. That's our normal process.
Sure, I just wanted to get that on the record in terms that there is a process to be followed.
That's right,
and what that
yeah.
process is from this point on.
Yeah.
Whilst we've been talking about the findings in favour of the non-executive directors, if I can put it that way, that they weren't in breach of their duties, I should say that I fully support the fact that ASIC took the case on. I thought it was the right thing to do, and I think it was entirely appropriate. Having said that, there were no findings, and Chair Longo, you were very careful to say, based on the evidence that the court had to consider,
Yes.
that was admissible evidence. And,
Yes.
rule of law, that's what the judge is obliged to consider. There were still some disturbing comments made in the judgment that have been widely reported, and including when the Justice Lee was looking at the situation, what happened at Star, he said he couldn't do so without a sense of disquiet.
That's right.
And he said it is not a portrait of directors actively pressing management with difficult questions as to whether the business was being conducted ethically, lawfully, and to the highest available standard, end quote, which is in many ways a disturbing observation for a company of this size, with dealing, as His Honour mentioned, in terms of a very sensitive industry, open to a range of risks. And in this regard, I think something we haven't asked you questions about at the moment was the posture of the directors themselves in terms of how the proceedings were conducted. So is it correct to say that the directors, the non-executive directors, chose not to give evidence, chose not to be cross-examined?
Yeah, I'll try to be very careful in answering that question. Let's just step back for a second, away from Star, just as a matter of principle. These are civil penalty proceedings. So under Australian law, there's quite a body of jurisprudence around what the law and procedure is around running such proceedings. And so we're one of the few jurisdictions in the world where there's public enforcement of directors' duties. So the first proposition is if you're sued for a civil penalty, you have a right to silence. And so there's so when these proceedings were commenced, none of the directors were required to file a defence. So we didn't know what their defence was, which is their right. I really want to stress this.
Under the current law.
Yeah, this has been to the High Court. You know, this is, so it's their right. If you're facing civil penalty proceedings, there are a number of protections or procedural protections that are akin to a criminal procedure. One of them is a right to silence. And so so when we commenced these proceedings, obviously we filed our pleadings, and there was a lot of the aspects of civil procedure are observed. But one of the things that are not observed is being required to file a defence. So we didn't know what the directors were going to say in their defence until we'd closed our case. Secondly, and I may need some help from Mr. Savunda about this, it was the director's right not to give evidence in the particular circumstances of this case. And so I haven't had a chance to study carefully what the judge said about it, but they chose not to give evidence. But I'm not prepared this morning to sort of comment any further adversely about that. They have certain rights, and the standards of proof and process in matters of this kind are very high.
Well,
which is why I said earlier, and I've spent the last 5 years trying to talk about this, is we have such high expectations of directors in this country, and I don't resile from that, and I don't think Justice Lee's judgment in any way diminishes our high expectations. But we have a process, and the rule of law is very demanding. And so
We make rules, right? So we understand that they're important.
Yeah, and the courts interpret them. And
Yes.
the courts interpret them. So in his summary yesterday, Justice Lee talked about the tsunami of documents. So there was a lot of material there. But at the end of the day, the court's job is to look at the pleadings, look at what's actually alleged, look at the admissible evidence, and apply the law to those facts. And and I think that that has to be respected. And as I said earlier, we will follow our normal process as to whether the matter should be taken any further.
Well, I want to make it clear, I respect the right of the non-executive directors to make the choice they made on the basis of the law. That is entirely their right. But I do note Justice Lee did say, and I'll quote, "As it turned out, the forensic choice open to them of not entering the witness box has been vindicated," end quote. It doesn't exactly give you a sense that he's signing off on their conduct, if I can put it that way.
Senator Casale, I hope you forgive me for saying I really can't take the matter any further.
No, I don't.
His Honour obviously put a lot of time and work into this judgment. It's very nuanced. It's very, I think what I'm prepared to say is what I've already said, and that is if one's objective and steps back from this, clearly ASIC is disappointed that we didn't get up, so to speak, on the independent non-executive directors. But I think it's equally fair to say that His Honour's observations and remarks that have been obviously highlighted this morning are not a ringing endorsement of the performance of this board, including the independent non-executive directors. But that's where we are.
Okay.
And Senator, I might just add, and again, not talking specifically about the Star decision, but obviously individual defendants to a civil penalty action have the right to silence. ASIC bears the onus, and I think His Honour in the Star decision referred to it as a heavy onus. And the right to silence doesn't permit, if we don't meet the evidentiary bar to establish the contravention, the court is unable to make an adverse inference against someone who refuses to give evidence. So, and that's the law. The law is that if you choose not to give evidence, the court can't make inferences against you until ASIC reaches that evidentiary threshold. So, that's why both His Honour and Chair Longo have referred to the case being based on the admissible evidence.
Okay. What was and you might be able to answer this question, maybe not, but what was the presumably there was expert evidence tendered by ASIC with respect to what a non-executive director would be expected. There was no...
No, there's no need for expert evidence. And I'll stand to be
I'll
corrected.
check, but I don't believe.
This is not if I may say so with respect, a good question. But in a matter of this kind, the court itself can form its own view about whether these duties were discharged or not under the law. It might be.
There was no expert evidence.
Yeah, there was.
Just confirmed.
And no one should be surprised by that. In directors' duties cases of this kind, that you wouldn't normally expect there to be expert evidence. Now, I suppose we can elaborate on other matters, but certainly not in this case. No.
The reason I asked that question was the comments that are made in relation to the tsunami of documents that were going to the board packs being thrust upon the board at the last minute before board meetings start, and it raises. Well, let me elaborate. It raises the question in my mind as to what you would expect from a reasonably competent director in those circumstances where you have this culture of oppressive, I think you call it oppressive, board papers being produced. And this is a perennial question, right? When I was a company secretary, the issue of board packs, making sure that they were prepared in such a way that flagged the significant issues, rather than the board being deluged in such a way that they couldn't discharge their duties. And in that respect, the board isn't a passive recipient. The board has an ability to say, well, this is unacceptable. This is what I would expect you to do in the context of this organisation, in the context of the risks we need to assess. I'm not just going to sit here passively and accept that you're providing me with extensive board papers that, as His Honour said, no rational person can evaluate all this material meaningfully in the time available, let alone do so repeatedly, meeting after meeting. One reads what appears critical, scans what appears arguably material, and just trusts that anything alarming would have been signalled plainly, end quote. And I must say, when I read that paragraph, it did disturb me to some extent, that it almost indicates that to some extent, and I haven't read the whole judgment, but the board has a role in terms of governance procedures, in terms of the architecture of governance, in terms of how board papers are presented, in terms of QA, QC processes, internal audit processes within companies to make sure the board papers are adequately flagging materials of concern. The board isn't just a passive vehicle, just meekly accepting what's presented to them.
Yeah, I think that's absolutely right. I think the technical answer, though, to the earlier part of your question, this is not a matter for expert evidence. I think this, in running, no one suggested in the course of this case that someone should have called an expert on that point. What His Honour did say, and I think you've made all, with respects, and have made all the appropriate points. I think the key point is that the flow of information to boards is in the control of the board.
Correct.
And so, and His Honour went out of his way to remind everyone of the wisdom, I think he used a word like that, of Justice Middleton's observations in Centro all those years ago, where in that case a similar sort of problem was made, and His Honour in his remarks yesterday in the summary, drew attention to it. And I think that this topic is obviously related to his observations around AI and the use of technology and everything. But the fundamental point is that that boards control the information that come to them, and there's a lot of material there, and it's an issue that Australian boards, I think, are still grappling with, because a lot of the directors I speak to, in the bigger institutions, they all complain about the body of material they're expected to get through for each board meeting. So His Honour's judgment, I think, will I think motivate or trigger another debate about what should go in board minutes. So there's different approaches to that.
No, and there are observations, as you're saying, the judgment about things, conversations had, which weren't included in the minutes, and that again raises the question as to how extensive the minutes should be, which again has been another perennial question.
And if I may say so with respect, Senator, you of all people to understand these issues better than most.
No, absolutely.
Yeah.
Okay, thank you, Chair.
Thank you very much. And I do want to take the opportunity, because I expect it would never arise in my lifetime again, to note Justice Lee's use of the word Brobdingnagian and pay respect to Jonathan Swift and Gulliver's Travels for what that actually does in enhancing the English language and our understandings. I just note that one of the procedures of the Senate that has changed in the time that I've been on this committee is that there is a standing item of declaration of conflicts of interest from our actual member, our committee members.
Chair, can I be excused for a moment?
Yes.
Thank you.
Yes. It's hard to actually declare I don't have a conflict of interest if you haven't read the papers. And I'm assuming there must be some expectation that boards would be required to declare a conflict of interest in any circumstance. Again, how would you make such a judgment and declare that I do not, or I do have a conflict of interest if the papers have not been read? And I say that as a former lecturer, where everything I did was about making sure people did their reading, because it's quite a challenge sometimes. Can I now? I want to ask questions about the AI and the content as well, but I know that Ms. Lawrence has the call now for 20 minutes.
Thank you.
And I think that will get us close to the break time, and I'll come to you, Mr. Moncrief, for 10 minutes of questioning at the end if you seek the call then.
Thank you and good morning. I just want to continue in the same theme, and we'll cover different topics no doubt throughout the day, but just if I continue focusing in the context of the outcome from the Star Casino. My understanding is that under the Corporations Act, auditors also have an obligation to report suspected contraventions. Did ASIC receive any such report from Star's auditor during the relevant period?
I'll need to take that on notice. I just don't recall. It was some time ago now.
Thank you, if you could.
What generated our investigation, though, was arising out of the Bell inquiry.
Right, and so just if I could get perhaps you to unpack that further. So what red flags did come to you to initiate the investigation then into the casino?
Perhaps while Mr. Savundra is considering that, I think we've just been informed that we didn't receive a report from the company's auditors to feed into our investigation.
Do you have a view as to whether that is because the reporting threshold for suspected contraventions are too high for auditors?
I don't think we could speculate on what the motivations for what any decisions the auditors would have made.
That's correct. Do you have a view on what specific red flags you would expect a competent auditor in circumstances like those described by Justice Lee to come to ASIC?
Thank you. So it's Kate O'Rourke. I think it would be worth us reflecting on that question in terms of the sorts of issues. We do have there is a clear obligation, as you've referred to, on auditors to bring suspected misconduct to our attention, and its application to directors' duties, I think, is one I'd just like to reflect on and think to give you a clear answer on.
Thank you. And look, and you might restate that same comment, but I'm just going to continue asking more questions in this line, if you don't.
No, that's no problem at all.
Because, you know, obviously we're all trying to digest the Justice Lee's findings, but that serious misconduct at Star Entertainment Group did occur over several years. If external auditors did not detect or escalate these issues, what confidence should the public have that the audit regime can function as an effective early warning system for corporate misconduct?
Can I just jump in there? There is a part of the judgment, and indeed the summary yesterday, where it's a wide-ranging judgment, where Justice Lee talks about the regulatory architecture around gaming and wagering. And so I think it's well to remember that this entity and in this business has its own regulator. the New South Wales Independent Liquor and Gaming Authority. And His Honour went out of his way to point out there's nothing wrong with the regulatory architecture and the basis on which it's intended to work. So I think the only other unusual thing about this case is that ASIC's not actually the primary regulator of this casino. We decided that it was in the public interest to run these proceedings, and we are where we are today. But there have been other circumstances where we've chosen not to. For some of the reasons that are actually in this judgment because of the high bar. But I do accept that you're focusing on the role of the auditor. But I don't think in these proceedings we had any input. I think Mr. Zavada has taken it on notice, but I'd be surprised if there was any auditor engagement or relevance to these proceedings or their commencement.
So just to be clear, you're not aware of any regulatory action being taken by be it another jurisdiction against the auditors?
No. But what I'm quite clear about is I don't think there's been any auditor engagement or relevance to us commencing these proceedings. We commenced these proceedings as a result of the inquiry done by the Liquor and Gaming Authority, led by, if my memory serves me, Mr. Bell, and other information.
Inquiry, and then there was the Bell review. So
yeah,
it was the
two things, wasn't it?
Yeah, it was the Independent Liquor Gaming and Authority inquiry, and the evidence that was revealed through that inquiry that was going back to your question, was the red flag that alerted us to commence an investigation.
And so do you think the current reporting framework, taking your point that there might be different jurisdictions with accountability in this space for auditors for casinos.
No, for casinos.
But as a broader observation, do you think the current reporting framework is effective in detecting corporate misconduct in large listed entities?
I might make a more general comment, if I may, about the auditor reporting requirements and frameworks, because they are a really important part of the story. I think the point Mr. Savandra is making is that there are other parts as well in terms of where flags are identified and where regulators can take action. But your question is, well, how did this part perform in these circumstances? Because it's an important part of it. So there is that statutory requirement to have auditors, if they see, when conducting their auditing exercise, if they see possible contraventions of the Act, of the Act, Corporations Act or others, to bring that to ASIC's attention. And I think it's fair to say there's been uneven observation of that obligation. I don't want to comment on this one particularly because I think we need to find out some more. We're not aware of any. Whether or not that's a separate question, but more generally, it's something that we explored in the last year when we were looking at the question of conflicts of interest, so ASIC and independence. So ASIC did a particular deep dive last year looking at the circumstances of auditors complying with their independence requirements, both the specific statutory ones about rotation and relationships, but also the general obligation of independence between an auditor and the company they're auditing. So that's something we probably will talk about on the 20th of March and happy to talk about today as well. But the reason I draw the committee's attention to that is one of the three kind of key findings that we made there was an expression of disappointment at the low levels of reporting to us about possible independence issues. So that goes to both, a self-breach, but also issues that reporting framework more broadly being an area that we think auditors could uplift. So we have made recommendations in relation to that go to that importance of reporting coming through to ASIC from auditors, either in relation to themselves or in relation to the things that they see when they're auditing.
So just before you continue, can I just ask recommendations to whom, at what point?
So the report that to auditors.
Yes.
It was in our media release 25228 and the report is 817 and so it was in October 2025.
Okay, so...
But that was on that specific point. I guess I'm drawing a thread that's connected to the wider point Ms Lawrence is making.
And I guess my concern is what is the implementation of that, apart from the, I want you to pay attention, put it out, rely on professional again, reading and then dispositional alignment with what is read and the ethical muscle in place, not at odds with a financial incentive to do the exact opposite. What is happening to ensure that this is actually being implemented? Given the massive concerns I have about ethical disposition, that's been revealed too often to this committee.
We it's whether it's implemented or observed, because they're enduring statutory obligations that apply. And so I think when we've been looking at the number of reports that we get from auditors, we get information about that, and we have seen a significant increase in the number of reports from auditors, but that's at a kind of collective...
Of publicly listed companies or of, smaller entities, because we've had some concerns previously about the burden of paperwork for perhaps insolvency practitioners. Who is reporting? Who is being, if I can put it quite bluntly, herded into such practices, and who is being absolved?
I'd be pleased to take on notice getting some more information for you on that breakdown between the size of entities, because the number I've got in my mind is at the collective level rather than by size or sector, or listed or unlisted, all those sorts of things. But I can see the interest in the issue of that information flow coming through to ASIC is a really important lead indicator, along with reports of misconduct or other means by which ASIC identifies possible misconduct in companies.
And maybe if you can give us some ageing data from maybe even from 22,
Yeah,
23,
no problem.
so we get the sense of the change.
We'll certainly have that available ahead of the 20th of March, where we'll be looking at issues in relation to audit in more detail. And we can also cover that question of liquidator information as well, and the burden of, I think just briefly you mentioned that, how much information does ASIC expect liquidators to provide to us? We've made some changes in relation to that to try and make that a more effective process, less information but more valuable information provided to us. So again, something we'd be pleased to either explore later today or next in a fortnight.
Thank you, and I think you've perhaps answered my next question in part, but just to clarify, so if regulators, inquiries, courts can identify systemic misconduct years later, but auditors can't identify it at the time, are you suggesting or are you confirming that the current audit regime is fit for purpose or not fit for purpose?
I would not reach the conclusion that it's not fit for purpose, because I think the audit function is quite specific. Auditors don't go into a company to explore for misconduct. They have quite specific tasks to undertake in relation to the verification of the financial information, or if they're auditing sustainability information under our new framework. Those are quite specific standards about, is this information accurate? Is it supportable? Is it verifiable? So it is a specific and important, absolutely important, but it's not a wholesale investigation or exploration of the company's activities or behaviours or issues. The statutory requirement to tell ASIC any issues that you've referred to goes to, in conducting their specific duties and activities, auditors, if they encounter something, then that is triggered. But I would be concerned if there's an expectation beyond that, because it's partial. And that's why we describe it as being a partial contribution to other means by which misconduct is brought to our attention, or to other regulators' attention, or indeed to shareholders' attention. I think implicit in Chair Longo's comments earlier about ASIC, it being a little bit unusual for ASIC to be able to commence directors' duties. Of course, shareholders can as well, breach of directors' duties. Like, that's to whom the duties are owed. Yeah. So there's different parts of our system that quite properly fit together in holding directors and officers to account for their behaviours. But this is an important one, the one that you're highlighting.
So can I just ask, though, just as a follow-on to that, given the I appreciate what you're saying, but I still wonder, though, if the audit framework under the Corporations Act is too narrowly focused on financial statements, if it's not capable of detecting broader compliance or governance failures of the kind identified by Justice Lee. And I can appreciate they intersect with the obligation of directors, but if we're also finding now that the directors are not responsible for the same, like then who is? Like how do we manage to get the, whilst there's a clear, perhaps a bit of tension, or there might be a complete demarcation of responsibilities, but I'm just keen to understand, have we got the audit framework too narrowly focused, or can this be something that could be looked at to work in harmony to support the directors in discharging their duties with that assurance from the independent auditor, particularly in the case where we've got an example of a dedicated room for high stakes rolling, which I would have thought would be a high risk, an area of focus, and yet clearly there was not enough focus applied.
I think it's, we're not making that assumption, or assertion that that's an area that's required to change, the role of the auditor in relation to this issue. I don't think that's something that we've suggested, either in relation to this case or more generally in relation to our work in relation to auditors. So,
so there's zero expectation that they should have raised red flags with you, that there is something...
No, I didn't say that. There's statutory requirements. We understand that there weren't any brought to our attention.
Yeah.
So those two things are so. There's statutory requirements and there weren't any that came to us. I think you said there was zero requirement on them. I think, we're not concluding that. I think your prior question, though, posed, well, what do we take from that? Like, are the pieces of the puzzle enough? And what I'm saying in response is there are different parts of that and all need to be working well. We haven't talked about whistleblowers, we haven't talked about other means by which reports of misconduct can be identified. I think there are different parts of the system that all are important.
Okay. So what can we take away from this, though? Because I appreciate you're going to provide some additional information on notice, but what can we take away from, and I know we need time to read the full 500 pages, but what are the early takeaways in terms of understanding, like what message do we want to give to auditors about their obligations to identify where there may be red flags to regulators?
I don't think this judgment has anything to say about that.
No, I appreciate the judgment may not, but I'm asking what does ASIC have what message in terms
at this stage, I don't think there's a whole lot. I don't think this. I think the premise of your question is that the auditor should have said something earlier to somebody about these matters. I just don't know whether that's a takeaway from these facts and circumstances. The casinos have their own regulatory framework in Australia. I don't know whether that affects the duties of auditors. We can take that on notice, but as things stand this morning, I don't think this case or these circumstances raise any particular issue around the role of auditors, but we will give it some further thought. And I think, as Commissioner O'Rourke says, I think it's a good question to take up next time we're with the committee, and I think that we'll take the next 2 weeks to think about it. No.
Appreciate that very much. Thank you.
Thank you.
Thank you. Just following up on that excellent line of questioning from my colleague from Western Australia. Can I refer to an article by Michaela Whitbourne, published April 12, 2022, which reports on Ms Martin being questioned. It indicates that the inquiry was refused a request in September 2018 from the financial crimes watchdog AUSTRAC for a copy of the KPMG report into matters relating to money laundering risk on the basis of legal professional privilege. From what I can read quickly in these articles, KPMG was involved in both internal and external audit work for STAR. An independent report from KPMG, it's reported, found that its anti-money laundering team wasn't adequately resourced and identified the money laundering and terrorism financing risk as high. How might ASIC interact with such a document? What responsibilities would the auditor have in terms of your regulatory oversight, given you've already put on the record today that this is oversight territory for the New South Wales racing and gaming entity? Yeah. Would they be required to send something to you?
Yeah, that's my understanding. I don't know if Mr. Savondra can... The KPMG report was a critical part of the case.
Yes.
The way I took Senator Lawrence's question, I thought it was a broader question about the role of auditors, but there's no question the KPMG report was a critical part of the case. You know, I don't know I can't remember who commissioned that report, but I don't know whether it even went to the New South Wales Gaming Authority. Do you happen to know?
I don't, but if to the extent they're operating as an external auditor, they're under statutory obligation to report misconduct to us that falls within our jurisdiction. But I think we need to remember here that the primary or frontline conduct regulator, both for the casino, the corporate entity, and individuals within that entity, is the state gaming authorities.
Yeah, I
casinos.
don't doubt that. You've made very clear that they're the primary regulator.
So whether it was
I'm
done...
hearing a little bit of a soundtrack from being on a London train. Mind the gap, right?
Yep.
Because there's a primary. Well, there's a reason there's a secondary line of risk management and a third line. There's an integration of these entities. Certainly, we've taken evidence with regard to money laundering that and significant changes have occurred in that area in recent years. That there's ongoing conversations between ASIC and Austrac. On a regular basis, and I'm just following, down the line. I think that has been well delineated here by Senator Lawrence, Miss Lawrence. Who's not watching? If information's being reported, how is it being shared? How is it being identified? How's it being flagged? What is the system response capacity at every point? And it's not just directors who then are responsible for paying attention. It's that regulatory architecture, not one brick, the whole building.
In the case of casinos, it's basically state-based regulation. So New South Wales, Victoria and Western Australia all have their own gaming authorities. Now, obviously we administer and are very interested in directors' duties generally, in corporate governance generally.
And audit quality.
Yeah.
And auditor responsibilities.
Sure. But just sticking to casinos for a minute, that's a highly specialised, very risky business.
Yes.
Which has its own particular regulatory oversight, which Justice Lee went to some trouble to describe and to recall the work of, I think it was Sir Lawrence Street, 1991. So I don't resolve from ASIC's interest in directors' duties in corporate governance in general. But while we're talking about casinos, we are not a casino regulator. We don't have expertise in that area. There are specialised state-based regulators that do that work, that deal with the auditors, that have the duty of approving personnel at these casinos. It's a very specialised area, and it is on a, if I may say so, in a very clear way, spelled out what the issues and risks were of that business right back to 1991. So our interest in this case was the role of the directors in the particular circumstances of this case. But there's a lot to do with casinos. It's just not our area of expertise, and it's not an area that we take any particular regulatory interest in.
But I think it's already been said here this morning that casino in particular is a high risk place for money laundering, for counter-terrorism finance. Our AML-CTF laws took a very long time to actually be implemented. It's happened under this government after many public promises from as far back as 2017, declarations of support for the second tranche of reform. And Australia gave its assent but didn't do the legal work that needed to happen. If we sort of take on board that whole context and mindfulness in the public place, even if there was slow implementation, how could it be that auditors would not be informing the board? How could it be that auditors weren't sufficiently flagging that with the board? Is my question. What do they see as their responsibility? And I am so over the self-absolution mantras that keep coming from, oh, well, we only check what's there. What is the professional responsibilities of people? And in this particular circumstance, which has captured the public imagination and made things that were opaque a little clearer to the Australian people, like, where are the auditors in the middle of all of this is a really important question, I think. So I look forward to the responses to Ms. Lawrence's questions. And I see her and I raise her.
I like to think
To
we're on
use
the
a
same page.
gambling analogy. She use that.
And if I could just maybe I guess my interest there will be a thread throughout the day, because I think there are different sectors, be it in superannuation, I think even real estate, we're seeing some troubling areas of concern around money laundering, no less. And it's just trying to understand, is the auditors a means to at least identify where there are red flags to support that whole ecosystem? And this obviously is bringing it case. I appreciate the point that you made, that it's not something that you have immediate carriage of, but it still seems to be a principle throughout. Have we got the framework cast wide enough, or is it still fit for purpose? Okay. Thank you.
We're just 4 minutes off the scheduled break. I want to come back with some questions around AI, both in this circumstance with regard to STAR, but also within the auditing firms. So we'll take a short break and return at 10:45. Thank you. 5, the committee will resume. I'll come back to STAR in just a moment, but can I go to AI more broadly and just note that Deloitte Australia, I understand, has ordered its audit staff to stop uploading confidential client or firm information into ChatGPT. Deloitte produced a $440,000 government report with fabricated citations, and it's when Australians learned that AI hallucinates. Interesting learning moment for the community. Over 24 KPMG, Australia staff used AI tools to cheat on internal exams. And CTM, Corporate Travel Management, has uncovered potentially years-old material accounting errors, putting renewed scrutiny on the PwC's long-time audits and the company after Deloitte, its new auditor, identified issues while they're reviewing PwC's work. That little snapshot certainly causes me concern. I'll just give you an opportunity to respond in the general immediately.
I'm not sure what...
AI, its intersection with the audit world.
Sure.
Yeah, I think I'll hand over to Commissioner O'Rourke. The AI is obviously a very big, wide subject, transformative of our community, our society, and of the community in general. So, but as it applies to auditors, I'll ask Commissioner O'Rourke to comment.
Thank you, and thank you for reminding us of those recent examples about some of the issues that have emerged in relation to the increasing use of AI. So ASIC did some general work in relation to the use of AI back in, it feels like a long time ago in the AI world now, so it was published in 2024, and at that point we did note the use of AI, predominantly in financial services, but across sectors, and that tipping point, which, you know, it's tried to observe over the last 18 months, it's just been an extraordinary increase in the use of AI in both financial services companies and more broadly within the economy. And I think those particular examples that you cite in audit firms are instances where people, staff and organisations are using AI in different uses, different use cases, and in areas, in those cases that you've alerted to, that can generate real concerns. So what we see is efforts of firms, I think you refer to the response in your first case, to set guardrails. And I think that wider sense in the community that the government's been grappling with, do we have AI sort of bespoke guardrails, or do we use existing guardrails that to control the use of new tools, including AI tools? So where we've landed, I understand from the government's perspective, is the latter, that we're using existing guardrails and identifying if additional safety steps are required. But we certainly have said publicly that there are plenty of rules that apply, the existing rules that currently apply to the use of any tool, including AI tools, and we'll be able to consider how they are used. Responsibility for actions remain with people. Responsibility with respect to, or with the firms in those cases that you're referring to. And so making sure that information is properly protected, making sure that training is done appropriately, the rules that apply to those. So I think we've talked about those being professional accounting body responsibilities with respect to discipline. I think Senator Pocock was keen to understand exactly how that worked at the last set of estimates hearings. Mm-hmm. That's an example of existing provisions that apply, reporting and disciplinary action that can apply. So I hope that's a helpful starting point, but happy to go into any of the more specifics if that would be helpful.
Thank you. So we do know that AI, like any new technology, has potential for incredible good, but also is subject to abuse. There have been discussions at estimates in recent weeks about the productivity dividend that we all hope to get from AI used responsibly, and for improved outcomes in terms of everything from efficiency to governance standards. And of course, it was worthy of comment in Justice Lee's much discussed judgment this morning. What do you know of this alleged email sent to Deloitte's audit and assurance staff ordering them to stop uploading confidential client information into nothing secure but ChatGPT? Their use of personal emails rather than internal systems. How do you know of it? Was it the Tadros article of February 24 that alerted you? Or have the Big Four and other players in the audit space been advising you about what they're doing with regard to professional management of the AI opportunity threat?
Yeah, thank you. So I think, as we've talked about in relation at the Senate estimates discussion in a separate instance, that we do have ongoing discussions and regular meetings at the operational levels with both the firms and the professional accounting bodies at which issues and information sharing can occur. As to whether or not, and I think we unpacked whether that happened and the circumstances in which information was shared in relation to the KPMG issue at estimates. In relation to this Deloitte one, which I understand you're asking me about, I'll need to take on notice whether that's something that was alerted to ASIC ahead of 25 February or after. I don't have that immediately to hand. I'm very conscious of the article you refer to, the 25 February article, as one, and so we've got that information to hand, but whether there was additional or earlier information, please let me take that on notice.
Thank you. In this article by Mr Tadros, to which I'm referring, he indicates that the firm declined to specify the number of incidents or whether they were reported to the Privacy Commissioner. The spokeswoman apparently said, and I quote, that there were robust monitoring systems, end quote, to detect incidents, and email reflected the firm's strong stance on protecting confidential information. Are you confident that the Privacy Commissioner is being informed? And do you have any intersection with that part of professional behaviour?
I think the Privacy Commissioner would be able to more directly assist you with that inquiry rather than ASIC.
Do they talk to you?
We have engagement with the OAIC. I can't speak to how frequently that is, I'm sorry, or whether that information sharing included this particular instance.
In terms of the clients of the large auditing entities, how critical is it for them to be confident that their confidential information is secure within Australian borders? Yeah, I think. And are you confident that that is the case?
I think the response that you've cited, the email that was circulated or exposed through that article, does show the firm responding to and expressing the importance of that issue and reiterating that with their staff. And I would agree it is important for all of the firms to observe those controls. Information provided to auditors is sensitive, is important, is confidential, so those controls are important as well.
Well, we agree in principle. My question is, who's watching this? How involved are you in that role? Whose role is it?
In relation, I think you referred earlier to the role of the Office of the Information Commissioner for Privacy Act breaches, and I think you made reference earlier to in circumstances of corporate activity, whether it be in a casino or whether it be in relation to other issues or matters. There are multiple regulators.
Yeah.
So yes, there's multiple regulators in relation to the provision of confidential
I accept and
information.
understand that, Commissioner O'Rourke, but what's your role in this? What are you doing about the professional responsibilities of the auditors that you are overseeing in terms of this? I mean, I think it's shocking that it's happened. Like, what's the consequences for doing this? Because if it becomes efficient and the whole goal is simply about grabbing every dollar, no matter how that might breach ethical standards or, privacy legislation, then we've got a problem of incredible scale in this sector. So What are
I think,
you doing?
No, and I think we've canvassed in earlier hearings of the PJC and otherwise that we've described ASIC's role in relation to auditors as being reasonably confined. As you know, we register particular individuals, registered company auditors. We do not register or license firms. We do not regulate audit firms. So if your question is, what are we doing in relation to the firms, that is not something that we have regulatory oversight of. We've had that discussion around all of the architecture. It's been canvassed in some policy papers and in other reports. I can't add to that earlier evidence about how the framework sits at the firm level in relation to ASIC.
So I accept all of that. That is now a matter of fact, and clearly there's a very big hole there, right? But the ones that you do have oversight of, the ones for whom you do have the limited number, which I don't recall the number off the top of my head. How many?
There's approximately 3,000 registered company auditors.
Yeah, so for that 3,000, that cohort of 3,000 for whom you are directly responsible, what directions have you given them with regard to AI principles? Is there a note that they are required to comply with?
No, I think, thank you for raising that. We haven't had any direct or specific engagement or communications around to the individual registered company auditors that I'm aware of. And of course, I'll correct the record if that's not so, but I'm not aware of any direct engagement with the individual people registered under the Corporations Act framework with respect to AI. Having said that, our chair and more generally, we have been speaking about AI in a way that I think is of wide application in relation to the careful use of it, responsible use of AI. I think you alluded to the possible benefits associated with its use in terms of economic activity, productivity and otherwise. And I think to the extent auditors have identified use cases about efficiency and the capacity to look at a vastly larger range of underlying documents rather than sampling. There might be ways of thinking about that, positive benefits of AI across the board. And so I'd say that the wider comments that we've made in relation to AI, I hope are apt and relevant to sectors including auditors, but have we given specific guidance to registered company auditors? We have not.
Thank you. I guess I'll be seeking what happens in that space as we go forward. Given that you're not responsible for the large 4 companies that do audit in Australia.
They're partnerships. They're not companies.
Sorry. Entities I've been calling them.
Yeah.
Because the partnership, the very separate partnership structure is another issue which is well considered in one of our reports. But they do auspice the company auditors, the registered auditors that you have. They sit within that. They are partners within that.
Many of them are, and there's plenty of those registered company auditors who are in their own firms or in smaller practices. I should also have added, as well as licensing, registering company auditors, we do register what we call AAC's audit companies, but very few people choose to use that company form. I think, as you've observed, there's predominantly partnerships that are used in relation to these professional services for historical and other reasons. So, yes, there are registered company auditors, plenty of them in the larger partnerships.
Yes.
There's plenty who are in the smaller firms.
And is it your practice to only communicate with those individuals directly, or do you communicate with the partnerships, the CEOs and the leadership team who oversee those particular ones for whom you have direct responsibility?
The answer is all of the above, in the sense that we have a range of different engagement and communication channels.
So you do talk to them. You do write to the CEOs on matters.
I'll draw an example. So we have reports, they're published.
Yes.
We have engagement with the professional accounting bodies.
Yes.
And sometimes who are able, on specific issues or more generally, to do that additional transmission of key ASIC issues and messages. We have engagement with firms, and we have
The partnerships?
Yes.
Right. So that's my question.
Sorry.
Do you communicate with the CEOs who are the heads of these partnerships?
Amongst other communications methods we do.
Yep.
We do also have engagement with the RCAs, but only occasionally directly. So an example was that when we commenced the
Can I
work
just stop you there, Ms. O'Rourke, because I know that you'll give me a very long answer to all of that, and that is worthy of consideration. But my question is, while I understand and accept that the 3,000 that you look after directly, people you communicate with directly, there is the opportunity, and in fact you take the opportunity to communicate with the CEOs of the partnerships under which those company directors, those registered auditors sit. So given that you do that sort of communication on a regular basis, I'm assuming that you do discuss critical issues with the leaders of the big four auditing companies. Have you raised concerns about AI practices, whether it's regarding the cheating on exams, the ChatGPT email information sharing risk?
So I certainly those engagements at the Commission level have not occurred in the time since that Deloitte article or the issue associated with the ChatGPT one that you've had. So there hasn't been any since the 25th of February, nor that I can recall. So I think I might have to take on notice and review the agendas from those discussions.
So could you take on notice
Because I
communications
think
that you've had directly with the CEOs of the partnerships under which the auditors sit, who take the role of partners alongside, and you know, I'm not a lawyer, but I understand joint and several liability, right? That's the argument. They say that they're all in this together. What communications you've had with those CEOs about guidance on acceptable and unacceptable uses of generative AI generally, and then specifically with regard to matters that are now emerging, and what directions have you given to those who are registered with you about their professional responsibilities with regard to AI?
Okay, happy to take that on notice.
Thank you very much. I'll come back for another line of questioning, but I'll go now to Senator Scarr.
Thank you. Chair Longo. It's interesting. I was reading in your opening statement, you refer to the fact that I'm pleased to report to the committee that through our ongoing determination to build up our enforcement capability, ASIC secured a record $350 million in civil penalties and $583 million back to Australians from July to December 2025, end quote. And I think that from an enforcement perspective, that is a pleasing outcome, and I recognise that, and I acknowledge the work of all of ASIC staff and also external law firms and whoever has assisted in that process. However, the flip side is that we still seem to be dealing with issues, including with respect to our banks, that have been the subject of discussion and court cases over many years. So we still have a situation where ASIC is securing civil penalties against some of our largest companies and super trustees in the financial ecosystem, ANZ, NAB, CBUS, RAMS, Australian Unity Funds Management. Why is it that it's still necessary to, of course you have to bring these enforcement proceedings, but why are the same issues arising years and years and years after, say, the Banking Royal Commission, etc.? It's quite disturbing in some respects. So I'd like to give you an opportunity to reflect on that.
I might need some help with those reflections. I think the sort of really stepping back, banks, superannuation trustees, telcos, insurance companies, in particular the banks, these are heavily regulated entities. They are. So the question we should be asking ourselves: are we going backwards? Are the standards of governance and the outcomes for consumers and account holders at these major institutions, are we going backwards? Now, I don't think. My personal view is we're not going backwards. Having said that, I think reasonable people can differ about this, but we actually don't have sort of metrics that say, oh, well, in 2025 the banks behaved better than they did in 2024, or they went backwards. So to be objective about it, I think that those metrics don't exist. All we really have is what the banks say about themselves, the court cases that we bring, the reports that we publish around, so for example, the Better Banking report that Commissioner Kirkland and I were part of, a whole range of reports that we publish. So I think that overall, I think Australians should continue to have confidence in their banks, but we have to be ever vigilant. That there's no history tells us that in heavily regulated institutions like banks that are very complex places, that are very reliant on technology, very reliant on people, things are going to go wrong. And our job and APRA's job, RBA's job, the system's job is to hold these institutions accountable. They are critical parts of our economy. But I personally don't think we're going backwards. Now,
However, in that respect, in
terms of conduct, I don't think we're going back.
Sure, but however, in your opening statement,
yes,
and you are someone who's not prone to hyperbole, and you're very considered, which I deeply respect. However, you did choose to put in big bold print in your opening statement, our banks need to get the basics right. We continue to prioritise pursuing misconduct affecting consumers, businesses and the economy.
Well, I wouldn't draw too many inferences from the bold face, but I think I've learned a lesson there. But if I may say so, with candour.
I suggest you continue with your candour, Mr. Longo. I appreciate it.
No, I do too. I think it's great.
I worked for a big bank.
It takes me to Justice Lee's comments about signalling and flagging for boards.
I worked for a big international bank for nearly 18 years. I'm very, very familiar with what can go wrong in banks, and I think the critical role that ASIC and other regulators play is holding the banks accountable, and I think part of that message is getting the basics right. So, if, for example, we've had issues around promises around interest being paid on accounts and hardship, there's a lot of important things that banks do that they've got to keep doing, and I think the community expectations are rising. The banks have got to use technology properly, AI properly. So I don't apologise. I don't make any apology for saying to the banks, you've got to get the basics right. But that wasn't quite your question, though. If I may say so with respect, I don't think we're going backwards. I think the senior management of our banks are serious people. We have a continuous engagement with the major banks through our institutional supervision team. Commissioner O'Rourke and I have regular interactions with the banks. So I think the banks and the system is very conscious of the responsibility it owes to the Australian people to run a safe, stable banking system. Now, as far as conduct goes, which I think is probably really the heart of your question, I don't think we're going backwards, but
are we going forwards?
Well, I think the Australian banks are widely admired outside of Australia.
Okay.
So it's not for me to be an apologist for the bank, Senator, but for what it's worth, our banks are respected globally. The Macquarie Bank probably has the biggest international platform. But as far as the domestic banks go, I know from my own engagements that some of them are at the cutting edge of the use of AI. They're very curious. They're very conscious of the need to harness technology to serve their customers. So I think in that broad sense, I think our banks have a very good reputation. But having said that, we hold them to high standards. It's a very highly regulated activity, and we expect them to look after our first Australians. We expect them to keep their promises over what interest they pay on accounts. We expect them to take hardship applications seriously. We expect them to provide a service in accordance with the promises they make to the Australian people. So I'd be interested in what Commissioner O'Rourke thinks and Commissioner Kirkland, because both of them, between the three of us, we have a lot of engagement with.
Sure.
Yeah.
No, I think I would agree with the characterisation that the Chair has said as to where we're up to and our sense of progress backwards or forwards. I would absolutely agree with that approach. And for us, it's about holding banks to their conduct obligations and identifying where they might be not doing so through early signals, and then really carefully inquiring of them in those areas. And so we've talked about some of the ones that hardship and better banking, the use of basic bank accounts. But other areas that are really important are scams. How are banks meeting the expectations of and the risks associated
Protecting
with that? So the scam prevention framework rollout and the proposed designations and codes in relation to those are prospective, but there's existing requirements that we're really keen to make sure are held to. Another example of two areas that we're looking at currently are effective linking of offset accounts. Right. So we've heard anecdotally that some of the banks may not be properly linking offset accounts, so people's accounts, their mortgages are offset. Yeah.
That was advertised, yes.
So that's something that we're currently looking at. We're looking at...
Can I just ask on that?
Yes.
How, in terms of, is this something across the industry generally, this linking of offset accounts?
We're doing what we call a surveillance in relation to that. So, like I said, when we hear of emerging issues, we can think about is that best to tackle through sort of supervision, through surveillance, through enforcement. So in this case, what we're doing is what we call a surveillance. So we've chosen some sample banks, trying to get a variety of size and type of banks so that we can have a look into that issue and make sure that it's kind of sufficiently broad from which we can draw conclusions that we hope others can apply. So,
sure. Can I just tease this out a little bit on the public record, because I think this is important for customers to be aware of, so that they can do their own personal due diligence with respect to whether or not they're getting the deal they thought they were getting through the offsetting accounts. What's the particular issue? If you can describe it in very basic terms, in terms of if I'm a customer, I think of a bank, I understand I've got an offset account. What is the particular issue I need to be aware of in terms of making sure, from a self-protection point of view, that I'm getting what I was told I was going to get?
Yeah, I think the particular issue is whether or not the two accounts, so the mortgage account and the account with funds in it, for which there should be offsetting, which adjusts the interest payments, like whether a payment is going to interest or principal, whether that's been effectively linked by the bank. And the reason I think your inquiry is a good one is it's actually quite difficult to know, because predominantly people's mortgage repayments are the same amount and an effective off, so you can't necessarily see, because it's not like it's gone down or it's not gone up, as to what proportion of that money has been offset in a way that changes whether or not each repayment is going to principal or interest and what proportion of it. So that what we're looking at is both have the mechanics been, like have people who wanted an offset been given an offset, have people who think they've got an offset, actually is that mechanics working, but also what information is available to customers so that they can test that question. So your question about sort of self-help is part of the thing that we're looking at.
So what should someone do?
Well, Senator, I think that Commissioner O'Rourke has really nailed it there. It's a classic example from a consumer perspective. How do you interrogate the system that you're actually getting what you're supposed to be getting? Because it's quite a nuanced issue, because your offset account is going to go up and down. Yeah. And the idea is that as I understand it, is that whatever's in your offset account goes against your mortgage amount, and so that the interest levied against your mortgage amount goes down. But at the same time, the real benefit is you don't change your mortgage repayments. So if it all works as intended, it's quite an efficient way of people managing their mortgages. I mean, obviously, but from a consumer perspective, it's very hard, I think, for people, ordinary people, any of us actually, to interrogate whether that's actually working. Now, I might hand back to Commissioner O'Rourke or Alan or Commissioner Kirkland as to how we got onto this as a potential problem, because going back to your earlier question, that's how we approach things. We look for problems and we try to solve them. So so overall, we think bank conduct's going in the right direction, but that doesn't mean things are always working. Yeah.
And I think just that the answer to your question, what should a customer do, is ask their bank.
Okay.
Ask their bank and ask their bank to demonstrate to them that they have effectively linked their...
And you hope the chatbot works.
Well, you've named the problem, haven't you? That, you're working hard, you're putting your money in there, that there's a degree of trust that the bank is actually doing the right thing.
That's right.
I mean, surely it can't be too hard to direct banks to say, you have had this much in your account, this is what you have saved on your mortgage, like that kind of clear information that doesn't involve you 45 minutes on a phone to ask it.
Yeah, and Senator, like so many things with banks, if I may say so, it all comes back to systems, technology and data. And the same goes for superannuation funds, I might add. We live in a digital world, and if those systems and processes aren't working as intended, we're not going to get the outcomes we want for consumers and members of superannuation funds, just as an example. And so, I don't think bank executives get up every morning intending for things to go wrong, but if those systems don't work, then things are going to go wrong. And what we're worried about in the example we're giving now is that the systems that are supporting this promise to mortgage holders may not be working as intended, and that's what we're investigating.
Commissioner Kirkland, did you have something?
I was just going to add, I mean, a lot of our enforcement work against banks, including major banks in recent years, has actually been linked to that failure of basic processes. So my colleagues have both mentioned our work on financial hardship. So we've successfully taken action against ANZ, against NAB. We've got a matter against Westpac that's where judgment is reserved. But in the ANZ matter, which is part of those matters for which the court approved an agreement last year. I mean, there was a $40 million penalty for failure to respond to hundreds of customer hardship notices. In the NAB matter, there was a $15.5 million penalty for failing to respond to hardship applications within the 21-day time frame. So these are matters that come about because it appears banks don't have the right processes in place to guarantee that they can respond in line with their legal obligations to their customers. And that's particularly important where people are facing financial hardship. That's why there's a clear obligation to respond. That's why it has to happen within a certain time frame. So those systems issues that the Chair has spoken about are a key part to all of the problems that we do see and take action on.
Can I move to another subject? And this goes, you could have, I don't want to give you advice on your opening statement, but...
Always open to advice.
Yeah.
Particularly when it comes from a senator who's on the committee.
Sure. But you could have put in big bold print. ASX needs to get the basic rights, especially with respect to the CHESS system. And
I was wondering, Senator, whether I might get some questions from you about ASX.
well,
I've been very patiently waiting.
I left this committee and I come back to the committee
and it's the same old issues.
The problem's still there. This is a concern, Mr. Longo.
So the interim report from the inquiry panel that was established in December 2025,
which is right in front of me,
and which is it's just astounding. You know, I am gobsmacked that in December 2025, given everything that has occurred over the last 5 or so years, we have these findings that A, resilience of critical market infrastructure has been compromised to deliver high shareholder returns, which is quite a damning finding. B, governance arrangements fail to provide the necessary focus on critical market infrastructure. C, and this is a terrible finding, ASX lacks the aspiration to be a steward of critical market infrastructure. D, capability and culture barriers are hindering transformational change at ASX. And E, the current regulatory approach has not delivered the desired outcomes, end quote. And this is notwithstanding the, and I congratulate you on the public comments you've made with respect to the performance of ASX over a number of years, ASIC, the RBA, increasing the regulation. We've introduced new governance arrangements, panels, independence. You referred to the capital charge, additional $150 million capital charge, but still, in December 2025, we're getting these findings. What's going on?
Well, that's a terrific question, Senator. Look, I think that unlike the banks and superannuation funds, ASX has a mountain to climb, and I've said that publicly. We've had, if you step back, when I first started the role, we imposed additional licence conditions in November 2021. Since then, we've had the CHESS problems. We've had to commence proceedings against ASX, alleging misleading the market arising out of progress with CHESS. There have been three independent, these are just the highlights, that there are three independent reports under A25B of the Corps Act that have been audited into various aspects of ASX. RBA have been doing their work. And frankly, it's been really disappointing. I think the thinking behind we needed something that was going to break this cycle. And so the thinking behind the appointment of the panel was to really step back and say, look, the tools we've been using just are not working. We need an independent panel of experts to really do a root cause analysis and really look at ASX as a whole and come back with findings and recommendations. And so what happened, they came up with an interim report, and ASX have now made a series of commitments to ASIC and in some respect to RBA to address these fundamental issues. And as you know, ASX have announced that the current CEO will be leaving, and there will be a replacement of leadership. So I think at this stage, I think we still have a way to go to deal with ASX's issues. Now, they are a unique entity in the Australian economy. They are a public company. They're self-listed. They're regulated by us and the RBA, and to some extent the ACCC in connection with pricing of some of their services. But they have a long way to go. I mean, I think there's been a lot of engagement with ASX over the last few months. I think, in fairness to the ASX board, they have engaged with us intensely arising out of this interim report. And I'll ask Commissioner Constant to comment on some of that, because we're doing a lot of work with them continuously to the reciting of the Accelerate program. I'll ask Commissioner Constant to talk about that in detail. And the other part of this is our regulatory strategy, to be frank. In fact, the committee asked us to review the way in which we supervise the ASX. And so I think it's fair to say we're changing too. We're looking at our capability. We're rethinking our regulatory strategy and supervisory strategy. The letter of commitments itself has a paragraph in it about RBA and ASIC working differently together in the future to look for a better, a more effective regulatory outcome. So I think we have a way to go, Senator. I don't think there's any quick fix here, but I think I'm more optimistic now than probably at any time in the last 4.5 years that we've finally got a grip on these issues. We have public acknowledgement of them by ASX, and we have a strategy for dealing with them. But there's a mountain to climb. I might ask Commissioner Constant.
Because I don't want to interrupt the flow, could I ask you to give some shape and form for the committee in writing to the way in which the RBA and ASIC are working together or separately? What has emerged in the time since you've been on this journey together? You know, are you on the same page? Are you doing different things? Just reveal a little more to the committee about the intersectionality there on notice, if you can.
Yeah, I'm very happy to do that, Chair. In fact, the final report that's due at the end of the month will have something to say about that as well.
Okay.
But very happy to brief the committee on the work we're doing of RBA. I've been in regular contact with the Governor, had a couple of meetings with her. So I'm confident that as between RBA and ASIC, we will make whatever changes are required to provide more effective supervision and oversight. But before I just finally hand over to Commissioner Constant, I've made this point before. This is on ASX.
Yes.
I don't run ASX. They have to make the decisions about how much they're going to invest in their technology. It's their problem to solve.
But Australia needs the exchange.
And we will do whatever we can to monitor and supervise. Commissioner Constant.
Thanks, Paul.
Thank you, and Simone Constant for Hansard. So not much to add, complete of emphatic agreement, perhaps in your bold type, I think, Senator Scarr, with what the Chair has said. But to give more colour, just to restate, we would agree with the premise of the question, which is that all the indications were that something needed to be done in terms of reset and refresh. And there were serious questions. This isn't about isolated incidents. It's not even only about the critically important replacement of CHESS, more comprehensive, hence the inquiry. So that comprehensive risk management, governance and capability scope. We did make use of our powers, including our enhanced powers and responsibilities, to initiate the compliance assessment, which is the framework for this, but this is a broad-reaching inquiry, as mentioned, with 3 experts because of the depth, breadth and importance of the issues. Secondly, I think we'd say so too did the panel in its interim report agree with the premise of your question and the premise of the inquiries that this committee has continued to make, as you say, for the years on which you've served before and after the break period. So panel report came forward that panel and ASIC agree with the premise of the question, so much so that an interim report was brought forth. Now, the panel actually had a short time frame in which to bring forward their report, but having done so much work, I think 140 interviews and read something like 10,000 documents in time to bring forth the interim report, which they did pre-Christmas, which initiated the commitments letter, that was brought forth because of the agreement with the premise of the question, the seriousness of the issues. And finally, I'd say really importantly, so too does the ASX.
So can I just, sorry, I don't want to interrupt you, but I just want to tease out that point. Is it fair to say that the inquiry panel was so concerned about what it found that it made a decision to issue the interim report in December 2025 to accelerate the release of those findings so that action could be taken?
I think it'd be fair to say it's not so much that they were so concerned or changed the level of concern they had going into the process and the gravity of the considerations. I think it's just the significance of ASX being stewards of critical national markets, financial infrastructure, and having done that work and seeing the need for a reset, not just a refresh, but a reset, and ASX would concur with that themselves, that having done that work and being in that position to make that diagnostic that you read out, that it was time to act. You know, time being of the essence and there being a really important year for ASX this year in terms of delivery. It's a really important inflection point, as the ASX themselves have noted in their recent public remarks, for ASX and indeed for public markets. So, and the only final point I was going to make, and thank you for letting me go on with the flow, I think Senator Scarr, you stated, is that ASX, importantly, have agreed with the premise of this themselves. So the 27 February public remarks, I won't spend too much time taking us back to the Chair's remarks, but importantly, that reflection of the need to be stewards of critical market infrastructure held to high standards and acknowledging that they've not always met them. And that commitment that they make in their public remarks about the need for delivery of sustainable outcomes and the importance of this step in both interim report and the forthcoming final report. So take your premise of your question as absolutely understood and just wanted to really reiterate the Chair's remarks.
Okay, so we're coming up to a big day, 20 April 2026 is, as I understand it, the date of the release 1 with respect to replacing the chess system, and that's with respect to clearing. Does ASX, and I note Chair Longo's point, of course, ASIC isn't running this program, but what confidence does ASIC have that this targeted date of 20 April 2026 is going to be met?
Shall
I think Commissioner Constant should answer that question. I just have a long memory. I know you do, Chair Longo, so I'm going to be really careful. So I'll start with Commissioner Constant and then I'll take it from there, if that's okay, Senator.
It's probably only fair because this is a long program with years to run. We won't give you assurances on behalf of the ASX for what the ASX should assure. However, as the regulators, we have confidence that we have the skills, processes, capability and focus internally to hold them to account against the milestones. So, of course, we are into the real crunch time for Release 1, as you note, and across the next few weeks we'll be receiving really important assurance reports and sign-offs that go toward their commitments about being ready for that go-live of Release 1. We've absolutely stepped up our engagement as well at board level down and through, not just on the commitments work, and I shouldn't say just, that's absolutely fundamental, but the specifics of how, from governance down and through, they are assuring themselves that it is appropriate for the release and the readiness on Release 1. Also, importantly, on their rollback capability. So being assured on that in case something does go wrong.
Okay.
Can I ask on notice a comparison, because we had those assurances publicly at this committee before the first effort went belly up. So a compare and contrast, great essay topic, between what was then from ASIC's engagement, because I sense there's quite a significant change, and I'd like to understand what that looks like between then and the assurances and the sense of what needed to be done, and what it looks like now, okay? Because we're going to see the proof of the pudding's going to be in the eating.
Yeah. Perhaps, you know,
on notice, thanks.
I'd like to be quite clear as to what assurances we're talking about. We're not giving an assurance that they're going to meet the 20 April. Yeah. We are giving an assurance that we're going to do our part in holding them accountable for the 20th of April. And I suspect I'll have one more opportunity personally before I go into the sunset to be addressing this, because that'll be after the 20th of April, then before the end of May. Yeah. So, but look, it's obviously a very serious subject. As things come to an end in my term, I have to say to this committee that we're doing everything we can. It's a top priority for me personally as chair, and for the Commission, for ASX for its problems and challenges to be finally addressed in a systematic way that gives the public confidence and government confidence that there's a plan, and that if we stick to that plan, the issues that entity is facing at the moment will be addressed, within a reasonable time. But there's no doubt that this is a top 2 or 3 priority for me personally, to leave the place with a viable plan. And the early indications are, as Commissioner Constant said, I think ASX have stepped up. They've responded to the interim report in a constructive manner, and we're going to hold them accountable to that.
Okay. Just one last set of questions, if I could, in relation to insider trading. And I note the sentencing of a former investment manager to 6 years imprisonment for insider trading and procuring others to trade in more than $3 million of platinum asset management shares, which is a very, very significant sentence. And I note, Chair, that the Parliament has in the past increased the maximum penalty in relation to insider trading from 5 years then to 10 years to 15 years. and I was reading the judgment. The judge actually referred to the fact that the Parliament had increased the sentencing, and 6 years imprisonment is a significant sentence. So I'm interested in your comments with respect to what ASIC is doing in terms of addressing the issue of insider trading. Historically, it's always been notoriously difficult to prove, and yet we have a positive example here, at least in terms of process, enforcement process, that this has been a successful outcome from an enforcement perspective, and hopefully will serve as a considerable deterrent to those who perhaps consider embarking on this unlawful path. So interested in any comments you have, and also the structure within ASIC in terms of addressing insider trading, your investigatory team that's focused on that, and what insights you can give us.
Well, I'm going to pass to Mr. Savundra in a moment to give you a bit more colour, but there are a couple of points you've already made in your question. The insider trading will continue to be notoriously difficult to investigate and prosecute. So the thinking behind this team is to concentrate our expertise.
The team you're talking about,
Yeah,
you
that's
might
right.
just put
and
that
I'll
on
get
the
Mr.
record.
Savundra to
Yeah,
give more
yeah,
colour there,
yeah.
and also to work even more closely and systematically with the DPP. But I really do want to say that these are hard cases to run, and very often I occasionally hear, "Oh, it's obvious that there was insider trading," and it's obvious. It's a little bit like an echo of the Star case. Ain't obvious. It has to be admissible evidence that can secure a conviction beyond reasonable doubt, and so these are very difficult matters to investigate and prosecute. But I'll hand over to Mr. Savundra to comment more, who's had a lot of experience in this area.
Thanks, Senator, for the question. Despite the difficulties that Chair Longo referred to and you referred to in terms of prosecuting insider trading, I think I'd start by saying Australia and ASIC have a strong track record of enforcing the insider trading laws. It continues to be an enforcement priority for ASIC in 2026. We've increased our monitoring of insider trading, and as Chair Longo mentioned, both in his opening and just again then, we've stood up a dedicated criminal investigation team to swiftly progress insider trading investigations, to deepen that expertise through a team which is dedicated. Insider trading happens in the dark or in the shadows. It's firstly phenomenally difficult to detect, and then where a suspicion is identified, it's even harder to prove. And what we're seeing is investigations are becoming, not only the investigations, but the conduct is becoming increasingly sophisticated through a number of means, but in particular facilitated by the use of technology. That means we need to respond in the same way. So as an agency, we continue to invest in our real-time surveillance capabilities, and we've developed our data analytics detection capabilities to great effect. I've mentioned the specific insider trading team. I think really just going back to where I started, I think on any measure, we do have a strong record in Australia. I think relative to many of our international peers, I think we have a strong enforcement record, particularly criminal enforcement record in relation to insider trading.
And this is a very significant penalty. I mean, 6 years imprisonment is a significant penalty. Is that one of the? Where does that stand in the continuum of penalties that have been imposed?
I think it's up there, but I don't think it is the most significant. You may recall the Kamane Hill matter, which involved Australian Bureau of Statistics staff member leaking information. I think that might have been 7 years plus.
Right.
Again, I'm operating from memory. I'll correct the record if any of that's wrong. But I think it's towards the upper end. But really, and I know it's going back a long way, but from 2009, from 2009, 47 people have been criminally convicted for insider trading, and and I think that rates well to our international peers. Also, the proxies or the work that's been done both by ASIC and others to assess Australia's market cleanliness, we score well as a market, and I think that is in part or in significant part due to the strong enforcement posture we have both on insider trading but other market misconduct like market manipulation and continuous disclosure.
Thank you. We'll rotate the call now to Mr. Moncrief.
Thank you, Chair. Just following up on Senator Scarr's line of questioning around the ASX. I know you mentioned that the ASX is keen to resolve it, and so is your team. I just wanted to get your perspective on whether you think the incentive structure is right for the ASX to be doing this in a timely fashion, and whether comparing it to other entities regulated by ASIC, whether you would be giving them a comparable incentive structure to make sure that they're keeping up with the expectations of the Australian market participants?
Thank you, Ms. Moncrief. That's a really insightful question with respect. One of the I sort of alluded to this in my opening, and I will ask Commissioner Constant to give more colour here. The critical incentive, if that's the right word, is the capital charge, the 150 million, because that has a direct impact on dividends, the dividend policy. So shareholders are not going to get what they've been getting historically because of that capital charge, because one of the key findings of the interim report is, and I think this actually does go to the heart of many of ASX's problems, is shareholder primacy. I'm just using that concept. So for too long in the panel's view, the entity was run for the benefit of shareholders, and there was a lack of ambition and investment in the core business of ASX. Now, normally that's none of our business. It's up to the entity what the dividend policy should be. But in the case of the ASX, it's very much our business. And so I thought one of the interesting things coming out of the panel inquiry was sort of confirming that. And so I think a critical part of the commitment is stepping up for this capital charge. And it'll take some time for them to deliver, I think, on that. So I might ask Commissioner Constant to give a bit more colour there, because I think we were all involved that weekend in dealing with this very issue.
Thank you, Mr. Moncrief, for the question, which I expect is informed somewhat by your own background. So it's an excellent question, and just to emphasise what Chair Longo has said, the commitments letter itself and the approach agreed in response to the insights of the interim report, in part really pivot around not just root cause, but incentives as part of root cause. So to just give some detail that sits behind the Chair's statements, firstly, the capital charge. So if you think about that root cause of shareholder primacy being an aggravating factor and not having that level of investment and the stakeholder interests, including customers, being subjugated, the capital charge in that regard is a new tool. It's a tool that is available to us. It's a tool that obviously our sister regulator in APRA uses really effectively, and I'll circle back to that. That capital tool, that capital overlay, is to deal with that incentive, so for getting that balance. It obviously looks to the risk associated with the capital program as well, and got a big few years ahead for the ASX. And it deals to a capital overlay that will have milestones and teeth according to the remediation program. So there's incentives. That's the first incentive there, not just going to that root cause of potential shareholder primacy and don't prioritise dividends over investment, but also teeth associated with this reset remediation program, this accelerate program that's part of the commitments, which also looks like a more traditional, for example, APRA program with the entities that they have prudential supervision of. The second part in terms of incentives would be as part of the reset of Accelerate and their program and their response to us. We've already got the plan for a plan around that, but that plan is due over the coming months. It's a comprehensive integrated plan of response. The allocation of responsibilities for those key outcomes in delivering this complete reset and response to the inquiry's findings, that allocation is going to be clearly with clear accountabilities, executive accountabilities, and that level of board accountability. That's important because executive remuneration is going to be in part, going back to incentives of people who are accountable, linked to delivery against some of those milestones and some of that reset program. And the final piece of incentive that's worth noting is the governance aspect of both what the panel had said and what the ASIC, the response to ASIC from ASX, the commitment is, which is around incentives also of the clearing and settlement entities. So that independence of the boards of the clearing and settlement entities, to get that full independence to ensure the incentives are right there too in terms of the infrastructure that they operate. And just to round out in terms of learning, I think you talked about learning from how others are supervised. We're working really closely with APRA in this regard. Now, this is all part of our supervisory remit at ASIC, but it's always excellent when you can learn from the close work that we continue to have with APRA, and both inside the inquiry team, you'll be unsurprised to hear we've had excellent people from RBA and also from APRA, and in terms of seconded into ASIC as we transition into this period of further enhanced supervision, further on my answer previously, and we'll be coming back with some of that detail, ensuring we're capturing the insight of some really excellent people we've got the benefit of having on secondment and perhaps more permanently from APRA. So thank you, it's an excellent question, and I intend for us to be giving more colour on this when we take that question on notice away and come back with a response.
Well, thank you. Is that something that, have you got the ability to pursue that similar charge with any other entity that you've got, or is that solely with the ASX, or is there any similar power that you've got with any other regulated entity?
We've been given some new powers of supervision over the ASX coming out of the market infrastructure reforms and the competition and clearing and settlement reforms. I seem to be corrected by someone, but I think I think we could have compelled by court action probably the imposition of this capital charge, but it would have been taken us some time. So from a strictly legal perspective, I'm just trying to be careful here because I actually haven't got it in front of me. I think we do have the power now to impose this charge over ASX, but it is a power that we haven't previously had, and it's a power that, if I may say so, is untested. So if there was resistance to the imposition of this charge, we could be keeping the federal court busy for a while.
Right. Okay.
But that's all a bit academic, if I can use that word. The fact of the matter is, we made it very clear to the ASX how strongly we felt about the need for a comprehensive, credible response to this report, and we thought the imposition of a capital charge had to be part of we felt very strongly about it. So really, whether or not we actually had a legally enforceable power, I think we do, and we would have been prepared to test that. But as things played out, it wasn't necessary.
Can I just ask, in what year did you acquire that power, Mr. Longo?
Last 12 months.
Yeah, so in the last 12 months, as you know, partly through the work of this committee, we've got enhanced powers. That's also relevant for the establishment of the inquiry. So in the compliance assessment approach that we took to the inquiry. And so, as the Chair has said, we're quite committed to the importance of dealing with that root cause, that being that incentive, and also a capital management program, capital overlay consistent with the risk and importance of capital delivery, including tech delivery over coming years, and hence looking into the availability, being ready to test it,
But pleasingly, this was an agreed and offered commitment from the entity itself.
Just to answer the quick question comprehensively, Mr. Moncrief, this is not a power. We're not APRA. The imposition of capital charges is a well understood and critical feature of APRA's toolbox. It's not part of our toolbox normally. So the ASIC situation is pretty unusual.
Yeah. Okay. Excellent. I was just changing track a little bit. I was wondering if you could give us a bit of an update on the Financial Services and Credit Panel, how that's going operationally, and especially around the not publishing of the names of the providers, how that's working, whether that's effective.
Yeah, I'll ask Commissioner Kirkland to comment on that. I can't just excuse him.
Certainly. So, Mr. Moncrief, it is now, I guess, a regular part of our regulatory framework, I guess, to have access to the Financial Services and Credit Panel. So by way of a general update, as at 26 February, we had convened, since it commenced, 51 panels, and the FSCP had made 39 decisions, and there are 10 panels with decisions pending. And there were two out of that total where panels lost jurisdiction because the individual ceased to be a relevant provider or a financial advisor. So I think that gives you a sense of the scale of the panel's operation. We, of course, publish all of the decisions on the FSCP Outcomes Register, which is on our website. From my engagement with industry, I guess I would have a few observations that go hopefully to the heart of your question. I think that we see great value in particular matters in having industry peers evaluate the conduct of advisors and express a view on whether that conduct was appropriate, and also to identify what sanctions within the remit of the FSCP might be appropriate. So we see value in having industry peers play that role as members of the panel. But also from our discussions with industry, I know that key people in the industry look closely at the panel decisions, and there's often commentary on the work of the FSCP and some of the outcomes in individual matters in the industry media that particularly services the financial advice industry. So we think it's a really useful part of our framework and continue to support it appropriately and refer matters there as appropriate.
Okay. Okay, that's interesting. So do you think so when they're published, the names aren't published, and is it more useful to have the names not published during the process where they're being worked out than for it's more for the independence of the panel rather than for any legal protections? Is that the main purpose?
I mean, the panel works as established by the law, so that framework was established by the legislation. I would say referral to the panel is one of the range of options that we have available where we investigate a matter and determine that some regulatory action might be appropriate. So at the most serious end of the spectrum, we might take court action and seek orders or declarations in relation to the conduct of a particular advisor. ASIC can also ban advisors, so we can determine that we think it's appropriate to ban an advisor. That's something we do for protective reasons. So if we form a view there's evidence that for the purposes of protecting the public it's appropriate to ban an advisor for a period of time, we can do that. And in terms of how that works internally, we have a panel of delegates that make those decisions. So the matters are referred to them and they make an appropriate decision under the applicable law. And in those cases, if an advisor is banned, that is a public outcome and the advisor is named, and we announce that via media release. So I guess one of the considerations we'll make if we're looking at a matter is how serious is it, what's the most appropriate sanction, and one of the considerations in that will be, to what extent will there then be I guess a public outcome that includes naming the advisor. So the FSCP is just one of the options available to us depending on what we find through our investigations.
Okay, great. Thank you. Just changing track again, thank you for your updates last time we met around the centre pay issues. And I just wondered whether you had any update on any enforcement actions for those businesses. Has there been any update on that since the last
So I think the key actions that we had underway, I'll just, if you can just give me a moment to find the relevant information. I think the key action that we had underway involved matters where we had applied stop orders in relation to particular businesses that were on the centre pay register. They had appealed to the Administrative Review Tribunal, and we were awaiting the hearing and outcome of those reviews. In the meantime, the centre pay reforms have commenced, which have in effect prevented the sorts of activities that we were concerned about continuing to occur as part of the centre pay regime. So in particular, businesses that were using centre pay to finance the purchase of or the sale of household goods are being removed from the register or have been removed. And as a result of following those changes, the appeal proceedings before the ART have been discontinued. So that would be the best update I can give you. And because of the reforms to the centre pay regime that have removed a number of the harmful practices in relation to which we were taking action from the centre pay regime, I would say in general we're less likely to take that form of action in the future because the centre pay reforms have effectively dealt with the cause of the problems that we were seeing.
So do you think that those businesses have been appropriately held to account for their actions before those changes came into effect?
Well, the action that we took in our investigations in these matters didn't focus on whether businesses had breached the law in a way that would mean that we might take action. Our action was very much, our investigations were very much of a protective nature. So they were looking at, and that was really very much informed by the reports that we were getting from financial counsellors, many of them working in remote communities, that there was harm being caused in real time to consumers who were buying goods from these businesses with the cost of those goods being financed out of their Centrelink payments. And so we applied stop orders as a way of trying to immediately prevent that harm. And that was effective for a period of time. But now, of course, the reforms have taken over. But I don't believe we've really, it hasn't been a focus of our work to identify whether there's any contraventions of the law. And that's partly because the particular credit facilities involved here in general don't fall within the Credit Act. So when we take action against credit providers, it's normally because they're providing credit products as defined in the credit legislation. In this case, we were dealing with credit facilities that didn't fall within the Credit Act, but there is another regime called the Design and Distribution Obligation regime that you're aware of, obviously, that imposes certain obligations on businesses, and it's linked to the definition of financial product in the ASIC Act, which is slightly broader. So we were able to take action under the ASIC Act to apply those stop orders, but we wouldn't be able to, in those cases, take the sorts of action we might otherwise take against credit providers under the credit legislation.
Is that something that, sorry, have I still got time? Is that something that you think if a gap like that came up in another setting, do you think that ASIC's got the appropriate powers to deal with that in a comparable setting?
I think, I mean, there have been many reviews of many inquiries, I guess, that have looked at the credit legislation over time. What I would say in general is that we continue to find conduct that seeks to evade the boundaries of the credit legislation, but I would say we're also very active in that space. So we've had a number of actions in recent years that have been for unlicensed credit activity, and we've had a lot of success in that area. So I think it's likely to continue to be an issue that people will seek to offer credit products in ways that try to evade the regime, but they also need to know that we're onto it, and it's a key priority of ASIC to take action in relation to those practices.
Yeah, cool. All right, thank you.
Thank you. Ms. Lawrence, you have the call.
Thank you. And I'd just like to circle back to the IAI questions that the Chair asked earlier. Now, obviously, our regulatory framework is centred around human decision-making. So particularly now in the context of Justice Lee's findings around non-executive directors not breaching their responsibility to act with care and diligence. Who do you think is legally responsible and accountable when companies are deploying AI for decision making and where harm is caused, for example, in finance, credit denial, flawed investment advice, financial market manipulation, algorithmic trading? Like, do you have a view? Or is it the company? Is it the software company? Is it the directors? Like, where will the accountability sit?
No, I think the general principle is we're technology neutral.
Yeah.
So, I mean, AI just affects everything. So I think the starting point is that there's no special law governing how AI is used. We have existing law, a whole range of existing laws that can be adapted to dealing with AI. So if AI creates a problem in the market, well then it's a new mechanism for creating a problem in the market, but there's still a lot of law relating to market abuse and market manipulation and all matters of that nature. So I think my starting point is there's no general law in Australia that's here's the AI Regulation Act. What we use existing laws. So if AI is used in a way that causes harm to consumers, then we have existing laws that can deal with that.
Okay.
Now, Justice Lee, I think, spent some time talking about AI. I haven't had an opportunity to read into that as much as other things he had to say, but my view of what he had to say at the moment is that it was that AI has potential benefits for directors in dealing with the range and amount of material that they're asked to deal with in the discharge of their duties. And I think he mentioned some work the Australian Institute of Company Directors has done in this space. I personally think the AICD's work supporting how directors should approach AI is very good work. I mean,
Sure. So I definitely do see benefits with AI. I'm not trying to be.
Yeah, no, I understand that. I'm just saying from a legal regulatory perspective, we sort of absorb the impact of AI and see whether if it's causing harm that's within our jurisdiction to deal with, then we'll deal with it. Yeah.
So do you feel that boards actually understand how AI systems are being used within the company so they can actually oversee the risks associated with it?
Yeah. Well, we published a report about 18 months ago where we did I think it's a thematic surveillance of the use of AI by Australian financial service licence holders. And I haven't got that in front of me, but we saw a varying standards of governance around the use of AI by licence holders. We're seeing a lot of interest. There's just so much happening in this space. So I did a speech about 6 months ago at the ABA annual conference on the use of AI by the banks, and all the Australian banks are adopting or using AI in ways that are designed to enhance the customer experience.
But has ASIC issued any guidance on when the use of AI could become a material governance
Not in
risk?
particular. It's not where we certainly.
What about on AI washing?
I could be corrected about this, but I don't think we've published any particular guidance or policy or views about it. The AI infects everything. So what I've said, for example, to company boards, is that they all need to be curious about AI and how it affects their business and the opportunities, and vigilant. And if they are going to use AI, they've got to have a proper data governance and protections about using it in a way that doesn't cause harm or lead to odd results. ASIC does not have an official sort of, doesn't direct the market on how to use AI or when to use AI, but it is encouraging the market. And indeed itself, we've just published an AI responsibility statement in accordance with government policy. I don't know if you've seen it a couple of weeks ago, where we talk about how we're using AI.
Yes.
Yeah, and so.
Hopefully we'll get time to come back to understand that a bit further. Should our auditors also be expected to review or test the AI systems as part of their audit process, do you think?
That's a matter between the auditor and the entity it's auditing. I might ask Commissioner O'Rourke to comment on that. the remit of an auditor of an entity, what they look at, it will be determined by the risks or issues that they think ought to be audited for that entity. I might ask Commissioner O'Rourke to talk a bit more about that.
We sort of started to touch on this topic earlier about kind of core responsibilities with respect to verification of the financial information that's published and relied upon as something that is at the kind of heart of that auditor role when they step inside a company. I think to the questions earlier about, well, who did what what did KPMG do in relation to STAR, recognises that sometimes companies ask their auditors to do other work, whether it be in relation to risk management or other services, and then we can set aside anything that's not audit adjacent as an issue that we've canvassed otherwise. But I think that question of what a company's board chooses to ask their auditors to assist with, either their external auditors or indeed their internal auditors, which is another function we haven't really touched on yet, does vary. Look, we see that acceleration of use of AI to the extent we have engagement that's informal. Like the Chair has said, we haven't sort of given directions, but we are very actively interested to see the uses of AI and the acceleration. And we see that part of that is about governance growing to match the use. So the breadth of the use or the customer-facing aspects of use, they're important developments. Yes. And so the matching governance and care and guardrails that are being developed, that was one of the key messages that came out of that report 798 that our Chair referred to earlier, because unless the governance is there, like who's making the decision and who's accountable for decisions, if a tool of AI is used, explainability, those sorts of things, then it's then we're very careful to be watching out for any harms that could occur.
Well, perhaps we might explore that a bit further at the next session then.
Okay, on the 20th.
I've just got a couple more questions before we break that go a little bit more now to your own capability around this space. Firstly, how many staff within ASIC have the technical capability to audit or interrogate AI or algorithmic decision making used by regulated entities?
Well, we have a wide range of skills internally that are designed to be able to investigate effectively whatever it is we're investigating. So we have data analysts, data analytics experts. We built up our intelligence function. Yeah. So I think
So you feel confident that ASIC has the capability, say, to
I think we
detect
do.
market manipulation by AI-driven?
Yeah, well, I think at the moment, for example, we're running a couple of court cases against insurance companies where AI-type technologies are at the bottom of those cases. They're sort of generating renewal notices where we think the underlying algorithm isn't delivering what is promised to consumers. So I think we have my general response to your question, I think we have the capability to conduct investigations that have a component involving AI-type technologies. Now, I should hasten to say that in the market area, for example, the use of algorithms has been going on for years. I mean, the idea of technologies being used in the markets has been going on for years. I think the difference with AI is that it's an enhanced technology that has the prospect of providing predictive capability to traders. There are issues around automation of trading strategies.
Yes, and to that end, I was interested because I've also been particularly looking at what's been happening in the US, and obviously they've been successfully prosecuting cases there of spoofing or something like learning all these new words within the AI context for market trading. But I was certainly concerned where they're warning about the risk that AI trading systems could learn to coordinate and essentially collude. We've got potentially multiple AI trading systems interacting to distort market prices. So just understanding how is
some of that's in the realm of the imagination rather than the realm of reality. There's been a lot of discussion about, well, for a start, reaching agreement about what we mean by the AI technology. I think we need to be very specific.
Yes.
So the use of agentic AI in trading is very much that's very it's very much an idea at the moment rather than actually happening.
There's some comfort.
So I think that we need to be...
So you've assessed the extent to which the Australian market faces that risk?
No, we just need to be careful about what we're talking about, that's all. Yeah, in terms of... what I've noticed in more recent times is a lot of discussion about AI technologies.
I was looking at the Sigma researcher fraud, the AI washing trading one. There was a case I thought was quite interesting.
Right.
Misleading hedge funds and so forth, with the different algorithmic trading models. So I'm just trying to get a sense of how ASIC feels the Australian market can cope with any volatility if there is suddenly, what do they call it, those flash crashes and so forth, and like how robust is our...
No, I think our system, we have a very good reputation for running a stable market with integrity. I think generalised concerns about the use of AI are interesting, but like yesterday, for example, I went to a briefing about the use of technologies, including AI, by a market maker. So there's a lot of controls around that under existing law and practice and market rules. So I don't think, my present thinking on this is that there are a lot of opportunities with the use of AI to increase liquidity, actually increase market resilience, better pricing, matters of that nature. So I think the market participants, I think we should be encouraging innovation in this area. As things stand, of course there's the potential for abuse, but that's always been there. I mean, we've had algorithmic trading and black box issues for the last 20 years. So I think it's interesting that we need to be vigilant, but I think the opportunities for innovation are really significant using AI technology.
So you're satisfied that the Corporations Act provides sufficient surveillance and sufficient tools for ASIC to be able to detect and monitor and ultimately enforce any actions?
Well, I think that I would approach the issue slightly differently. The regulation in markets, for example, we have some prescriptive regulation, but a lot of it's principles-based. And so I'm not calling for any particular new law on regulating AI. What you're more likely to see is the evolution of market conduct rules that we might develop with industry to deal with specific parameters or standards that we'd like to see in how the market actually operates. But I think the existing legal framework is flexible enough to deal with AI, if we're talking about markets regulation. Now, AI, I think it's a bit of a truism. It affects every aspect of our community and our life. And, there are lots of reasonable minds are differing about, whether we need to regulate AI in a different sector of our economy or a different sector of our community. But in terms of markets regulation, I think the current legal and regulatory framework is fit for purpose. What I'm more concerned about is innovation. I mean, I gave a speech yesterday on this very topic, that I think we have an opportunity in Australia to encourage innovation through tokenization, AI technologies, the use of our sandbox. I think that's where the opportunity is. Now, there may be a gap somewhere in our law relating to AI, but I don't think that's the big issue at the moment. I think the issue for us as a country and for ASIC is to encourage innovation and to make sure that we're ahead of these technologies for the development of our markets. I think that's really what the challenge for us at the moment.
Thank you. I would like to explore the tokenisation and innovation ideas a bit further. Perhaps that's after lunch.
Yeah, we're pretty close to lunch. So can I just ask, on notice, we've referred to markets, what about AI and audit? What sort of prophylactic action, if I can put it that way, is being anticipated that you're aware of within the profession and your intersection with that? If I can just close with one quick question, I think. Clearly the ANZ matters, which have been mentioned here this morning, were profoundly important in clarifying appropriate behaviours in the banks. I note Mr Elliott determined to take some action, and that has since ceased. So can I ask, have you had communications with either Mr. Elliott or ANZ around that change of behaviour?
If you're referring to the former CEO's
Correct.
court case in connection with his bonus, is that
Yes.
what we're... Yeah, that's a private matter between Mr. Elliott and the bank. I'm not aware of any communication with ASIC, and I wouldn't expect there to be any communication with that. I think that's an entirely private contractual matter between Mr. Elliott and the bank, and I don't know anything more about it than what's in the press. Yeah.
Going back to consideration of professional responsibilities, once such a matter has been traversed in the public place and settled in such a way, I'm assuming many of the people that we discuss here who have fallen foul of the law in a particular way are people of high skill level, right? Perhaps they've fallen foul of the law in one instance, but their skill set doesn't disappear. What's your view about the rotation of what's declared as independent directors through the corporate sector? Like, what penalty, for example, would Ms. Martin or Mr. Elliott have in terms of reputational risk generally in going on to secure board memberships in the corporate sector of Australia?
You'd like me to have a go at that now or after lunch?
Would you like to
Well,
chew on that thought and come back with an answer after lunch?
Well, very briefly, there's one very brief answer, and that is we'll be seeking disqualification orders against when we next appear before Justice Lee. In light of the findings His Honour has made, we'll be seeking not only a pecuniary penalty but a disqualification order so that she'll be unable to be a director for whatever period of time the court's prepared to ban her. And similarly in the case of Mr. Beckier, and perhaps the balance of my answer we could, if that's okay with you, Chair.
Absolutely,
discuss
yes.
after.
So Mr. Elliott, he's had a quite glowing career until it wasn't, right? And what happens after? After what's happened to Mr. Elliott has occurred, what happens then in terms of eligibility? Have a think about it.
Well, in the case of Mr. Elliott, again, that's a fairly straightforward answer. To the best of my understanding, he can do whatever he wants. If somebody wants to appoint him to a board, that's fine. He had a contractual matter we wanted to raise with the ANZ in court. I gather from press reports, I have no other knowledge, that action has been discontinued. I'm not aware of any settlement. As far as I know from press reports, he simply dropped that case and not taking it any further. But if Mr. Elliott wants to serve on another board,
He could become
that's right. He's
technically described independent director.
He's at liberty to
Because I often hear this is the fix, right? This is the fix. At PwC, they've got independent directors. Who are they? Who's eligible? Who's not eligible? You can have this sort of story and still become an independent director, and the title.
Perhaps the idea of what's independent. We really do need to wait till after lunch.
Right.
Is that a fair?
The committee will suspend and resume at 1:15. Thank you. resume. Thank you for those who are listening. I hope you're finding this a very informative session of oversight of ASIC by the Corporations and Financial Services Committee, the Joint Committee of the Parliament. Mr Longo, just before we parted for lunch, you were going to chew over, literally, not only your lunch, but the concept of the eligibility criteria for people who are declared as independent directors, and how that intersects with the sorts of, at best questionable and probably more commonly shameful behaviours that we've seen that breach all sorts of ethical codes and community expectations, but don't actually breach law as it stands. So what is the situation with regard to directors' responsibilities, directors' duties, given the pool of people who could end up on boards in corporate Australia?
Well, thank you, Chair, for that question. I think the way I'm interpreting your question is the idea of what is an independent director. The Corporations Act is silent on the question of what an independent director is, and so we look to the general law and general practice and codes of conduct to help define what an independent director is. I haven't got in front of me the current edition of the ASX corporate governance.
It's being revisited, remember.
Yeah, it's being revisited.
Under
So the concept of independence is not is a question of fact in the particular circumstances, and the different codes, different situations might lead to different conclusions. But the idea of an independent director is not mandated by law. It's something that boards have to decide for themselves what constitutes independence. I think the ASX has these, I think they're still with the 4th edition, aren't they? The ASX governance principles, which are about to be reviewed by a committee chaired by the former Governor of the Reserve Bank, Dr. Phil Lowe. So I think that's really the long and short of it.
Does it matter, in your view, as the chair of ASIC, Mr Longo, that the people who are serving on our boards, who are governed by the corporations law, have displayed such qualities as we have had cause to consider this morning, revealed in Justice Michael Lee's review of STAR? There have been references to the 4 big auditing companies, PwC, KPMG, Deloitte and EY. There have been references to all of the major banks. Does it keep you up at night, Mr Longo, thinking about, you know, who's out there in these positions of responsibility and what the consequences of a failure to have the right people with respect for the law by in a black letter way as well as in a dispositional way?
Well, that's a very broad question, Chair. We have a wide range of companies in Australia, from the small to the large publicly listed companies. My personal view is that most of the time directors of Australian companies are striving to do the right thing and do the right thing by their companies and by their shareholders. Now, clearly,
I want to be comforted by that, but can I take you to the examples that have been the subject of discussion today? Right? Yeah. We're not talking about backyard operations here. We're talking about large entities.
So am I, Chair. I think the vast majority of directors of companies, large, small and in between, in Australia, are trying to do the right thing. Now, our job, obviously, is to deal with situations where directors have contravened the law or are suspected of contravening the law, but they do not represent, in my view, the general standards of conduct of directors in Australia.
Which is good in the same way I think about we haven't got jails full of every Australian, we've got a few. But nonetheless, we have a few in the jails. We've got a few who are on corporate boards right now who I'm pretty sure, after spending all the years on this committee that I have so far, who are doing the wrong thing. And I'm asking, really, what degree of scrutiny is in place to undertake the necessary protection for Australian consumers and shareholders, that they aren't being exploited by people described, I think, by Mr. Justice Lee. I don't want to verbal him yesterday, but people sitting on boards, handsomely remunerated, who are, and this is the quote, not just tokens or glittering prizes decorating a CV, people who are taking that role seriously.
Well, those remarks were made by the judge in the context of a particular case involving serious issues at a casino. I'm trying to answer your general question about directors in general in Australia, and my answer is directors in general in Australia, from small to large businesses, are trying to do the right thing and comply with the law.
Okay, so let me be specific. Are you confident that the board that's overseeing PwC, that has embedded in it some of the 3,000 registered auditors that you oversee, are you confident that the people who are on that board, whether independent or non-independent, are doing the right thing? And if you're not in charge of that, who's watching and what standards are they going to be held?
I've got no comment to make, either in general or in particular, about that board. I actually think it's an advisory group, isn't it?
Because it's a partnership.
It's a
Not a
partnership.
board.
I don't mean to.
That matters to
I don't
us.
mean to be uncooperative.
No, I know you're not, and I'm
But I think it
pressing.
is an unfair premise to ask the chair of ASIC to comment on the standards of governance of directors of every company in the country when we have over 3 million of them, and the vast majority of entities in Australia are behaving lawfully, and where we see evidence of unlawful behaviour that we think warrants attention and investigation within our resource envelope and in accordance with our enforcement priorities, we will take action. So I just don't think I can take it much further.
No, I don't believe you can. And I thank you for your candour, and I know that what you're stating is true and accurate. Right? However, Australians who are relying on the information flow across corporate Australia don't give a damn or couldn't care to find out about what the difference in a partnership structure is to a company structure. People put themselves out as directors. They don't specify which they belong to. They look to big companies with their signage written all over the skyline of our major cities, and they want to have confidence that no one's gaming it with perceptions that, once you get this title director, that there's something super special about you, and that somebody's watching what you're doing, whatever structure you might be in, because that is our part. We're looking for you for corporations, but our part is, ordinary Australians don't need to understand the ins and outs of every single part of a regulator's role to need to be reassured that the ecosystem is working in their interest. And I put it to you that
Well, I think Australians can have confidence.
PwC, the Star Board, you put it all together, and people are rightly going, who the hell's watching this stuff? How have we got the right people in there? And how do they get away with this is the questions that we get asked. We get asked those questions. So what comfort can you give me, Mr. Longo?
Well, in addition to the responses to the questions.
Is there anything that you can say?
Well, I think Australians can have confidence in the rule of law in this country, the independence of its institutions, its parliament. We all have a role to play in giving ordinary Australians confidence that they're living in a society, in a country where they can go about their lives and move on. So I don't think I can take that question any further with great respect.
Thank you. Ms. Jarrett.
Thank you. Good to see you all again. I'm going to just change tack a little bit and go to auditors, because as you appreciate, audit insurance and the role of auditors is integral to the trust and confidence in our financial markets, and the activities of the auditors is not foreign to this committee in any way. So I read with interest your report that you had published the report in October last year about auditors' compliance with independence and conflict of interest obligations. And I understand that many auditors are not demonstrating, are not in a position or aren't for some whatever reason, or just can't comply with their prescriptive and general independence and conflict of interest obligations. So for the record for people, What are those obligations first of all?
Thank you. I'd be happy to help you, Ms. Jarrett. So, we have actually touched on auditors a couple of times this morning, but not the. And I did make brief reference to this report, but I'm pleased to provide a little bit more information about it. So, for the record, it's Report 817 that we published in October 2025, and it's called "Building Trust: Auditors' Compliance with Independence and Conflict of Interest Obligations." In designing our work on this piece, we started with quite a widespread data matching exercise.
Before you start, though, just for the record, can you explain what those obligations are? Because I think that's important for the context of people listening to really know what we're talking about here.
Yeah, no, thank you. I'm happy to explain those. So the report that I referred to describes on page 9 what those independence requirements are, the legislative and regulatory framework. And I think in your question you acknowledged there's quite specific ones as well as a general independence requirement. So the prescriptive independence requirements go to rotation requirements, and they're contained in Division 5 of Part 2M.4 of the Corporations Act. And then in addition, so that's a requirement to rotate that applies to auditors of particular for particular engagements. The second prescriptive set of independence requirements goes to it's a non-exhaustive list of prohibited relationships. So if you've got former relationships between the auditor and the board, then that can similarly be a breach of the independence requirements. So they're the prescriptive ones. I do need to just clarify one thing in your question. To the extent we found breaches of those, yes, we found some breaches of those for this project, but they were not widespread, and they were the breaches that we did find were in smaller practitioners, in smaller firms of practitioners. On top of that, those two areas of prescriptive requirements for independence, there's a general independence requirement that applies, and that's all reasonable steps to be taken to ensure that the audit activity does not continue in conflict of interest situations. So that's a more general requirement for people to test if in the circumstances there is a conflict of interest, and if so, that they discontinue that audit relationship. So that's an ongoing obligation on auditors to ask themselves at a general level whether there's a problem that's in a conflict. So in relation to that, we saw concerning behaviours across large and small firms. So happy to unpack either of those further, but just you did ask for the specific provisions. Forgive me, that general independence requirement is in Subdivision A of Division 3 of Part 2M.4 of the Corps Act.
And again, for the benefit of those listening, like, why is it important that we have these conflict of interest obligations? Why are they there?
The financial information that auditors are auditing is absolutely essential, or sustainability information, for people to make good decisions when they are engaging with a company, whether they're engaging as an investor or as a supplier or an employee even, or one of the stakeholders. What you hear about the financial position that's included in those reports, you need to be able to rely on it. And relying on that, that the step that we've taken as a society is to say that needs to be independently assured, and it's the auditor who does that assurance that with an independent mind looks at the financial information and says that is, I assure it, I provide.
So it gives confidence, right?
It's confidence, it's trust, it's reliability, and it's around impartial judgment that's brought to bear on that information to achieve that confidence and trust.
So when your report, in your report, you say many auditors, and you've just said it's not, it's more, is it more small? Can you unpack that?
Yeah.
Like who is, where are we seeing this anomaly? Well, I wasn't going to say anomaly, but where are we seeing this happening?
No, thank you. So in the report, we described sort of 3 key finding areas. So the first was with respect to those prescriptive independence requirements, so rotation and relationships. And so I was starting to say we started this work by looking very broadly at auditors and found the data points, both internal and external, that we could match to see if we could see issues with rotation or relationships from different data points, and then kept funneling it down. So we found that there were 9 auditors in that area that were unable to demonstrate how they met the rotation requirement. and then 5 auditors that had relationships that we thought were those that were prohibited under the Corporations Act, and they were from the small to medium-sized audit firms. And so that's the first area of finding, those ones. Would you like me to pause before going on to the general one?
Yes, if I could just ask one question. So in relation to that, like, do we know, because what this creates to me is a risk to investors or to workers or the businesses, so that in terms of their future planning, etc. Do we know, like, how much capital it could potentially be at risk and how many jobs and businesses, etc., because of, I know you say it's small
practices.
Small practices.
And so there were 9 auditors in relation to the audit of 14 listed clients, and 5 auditors in relation to the relationship problem for 6 clients. So in total, 20 clients affected.
And their companies, their businesses?
Oh, yes. Yep. And I could take on notice the size of those entities. Generally, we find smaller practices audit smaller firms, but not exclusively so. There are some circumstances in which a big company could use a smaller auditor, so I'd be happy to try and get some size metrics around that for you so you can calibrate that concern you have around the impact.
Yeah, and we need to, I understand, though, that we do need to keep it in perspective in terms of the overall size of the capital market.
Yes, and I think also the consequence of the breach. So the rotation requirements are such that you need to have 5 of 7 years, like if you've already audited and been the signing auditor of 5 to 7 years, then you need to rotate off.
Yep.
And so in circumstances where a person does a 6th, it's a breach. But does that mean that the financial information is flawed? No, it doesn't mean that.
No,
but
I agree.
I hear you that it's nonetheless that's why we did the work. We are concerned if people aren't complying with these requirements. These ones are quite clear. You know, you've got rules, and we wanted to check if they're being followed.
And are there, like, what are the penalties or not just the penalties, but what happens to these 14 auditors?
Yeah, so the report as well does describe what are the actions that we can take or did take, and some of them we were able to describe at that point in time, and some of them were ongoing then. So I will draw you to, I'm just keen to, sorry, it might be in a separate report where we set out.
Notice,
but yes, when we found breaches where we could take action, relevant enforcement action. So the range of enforcement action that ASIC can take does vary from the Company Auditors Disciplinary Board. It does also court enforceable undertakings. So, sorry, I have found a summary of it here. So we did have 3 court enforceable undertakings relating to registered company auditors. 1 auditor voluntarily cancelled their registration, and we did issue an infringement notice. Those were at the point in time of this October report, and I suspect some of our enforcement activity was ongoing after October. Okay. So if there's additional information, we'll be sure to have it available. We're meeting again on the 20th of March with a focus on audit, so we'll make sure I've got the most up-to-date stats on that enforcement action in relation to independence and otherwise, because there are other issues that we are concerned about as well.
Can I ask a clarifying process question? Do you do a sort of a data scraping exercise to find out who's auditing whom, and if they've complied with internal rotation of staff, etc.? Or is a requirement for reporting on either from the listed companies or from the auditing companies about what they're doing? Because I note that CTM shifted from PwC to Deloitte after 14 years. So that could have been a 7-year and a 7-year rotation with a different head of audit. That would be compliant, but...
Oh, yes. So... So in answer to your question around the data collection and analysis, so in relation to this independence question, independent surveillance, we did a specific data matching piece, like I mentioned at the beginning, where we had both internal and external, and that was around rotation and relationships. And then we did some sort of deeper dives once we narrowed that information, including making inquiries. So,
But there's no, is there a public list, or this was for a specific purpose,
that was for the specific
time-limited,
purpose.
one-off dive?
So listed companies in publishing their annual reports, and indeed public companies when they lodge their financial reports with us, include the statement from their auditor as to the audit. So it's publicly available in the sense that when filed, financial reports have that information on them. And so,
But do you have a system where, you know, that data is regularly updated annually as those reports come in, and you go, okay, trigger warning. Okay, they've been doing this for, well, I think in one case previously it was 75 years. It's had this.
So there's a difference between a firm relationship, as you know, and the person who's signing. The provisions that I'm describing apply to the people, to the individuals, to the registered company auditors.
Yep.
They don't apply at the firm level, an issue that I know
we have
otherwise talked about. But so we've got to, sorry, I should have been more clear on
It's okay.
This applies to the
I just-
people. And I think the direct answer to your question is no.
Okay.
But we do, you know, we separately from that deep dive on independence, we do work on file reviews, on financial reports, on audit files, and in assessing which ones might be appropriate for us to do about the file review piece. We do look at both risk-rated and random elements to choose both the financial reports and the audits. And so it's a little bit different from what you've described in terms of that, but that idea of being...
Answer to my question. Thank you. Back to you, Ms. Jarrett.
Can you elaborate now on the second piece of this?
Sure.
The
no
showing
problem.
general independence?
Yeah, so the second finding that we've described in our report is about the general independence requirement and our observations there that were ones that we were concerned about some auditors taking a narrow approach to that independence, that general independence.
What does that mean?
That what we saw was gaps in what they looked at. So a tick box approach to compliance and to considering threats to potential threats to independence. So it wasn't a comprehensive consideration of what threats to independence might be and how they might together cumulatively raise concerns about perception or a conflict of interest. So auditors could tick the box with respect to the prescriptive ones on the Corps Act, and I should also draw attention to the APES 110, which is a standard that's not part of the Corporations Act. But whether they considered more generally that they weren't, either some facts and circumstances weren't considered, or they were very superficially considered, or not consider how they cumulatively might impact their independence. So there was just disappointing to see some of these very limited focus on independence, a point-in-time consideration rather than over time, an inadequate assessment of safeguards, and a lack of documentation. So they were some of the areas that we've unpacked in the report and how we've then flipped into suggestions about how auditors might address these concerning areas in future.
And do you to what extent were the large accounting firms?
So those findings were across, they weren't just confined to the small firms.
Yeah, okay. So you're seeing them in the Big Four, for instance, or even the mid-tier firms, even after everything that they've been through. Okay. And actions out of that?
Yeah, so, sorry, we've also, in that category, saw gaps in provision of how non-audit services were assessed, so an area I know of ongoing interest, and also limited consideration of long association with clients, even if it's not the prescriptive rotation requirements. That long association can, over time, and in combination with other aspects, lead to genuine questions that we weren't sure people grappled with appropriately. The last of those sort of subset areas to draw to your attention is a narrow focus on relationships with office holders who were ex-partners of the firm. So that goes to some of your concerns. Oh, and then multiple areas giving rise to potential independence threats. I think you were about to ask the next step. So this one is because a general independence requirement has more lack of specificity in relation to it, it's more difficult to draw out a definite breach, like 5 years, 7 years, you can say it's breached or not. In this area, it's a case of being concerned about practices and describing in case studies and in trying to pull out the particular drivers or elements of it, an effort on our part to bring to auditors' attention practices we think that can genuinely jeopardise their independence, with guidance on those. Yep.
So what percentage of the businesses or the auditors that you looked at were actually in breach? And what I'm trying to get at is this just a reflective sample of what's going on in the broader community?
So it's we've been careful to describe the methodology in our report. While we started very broad, we narrowed down the areas, and so to the extent, I described the 9 and the 5, and as they were a proportion of a subset, but that's of 48, but that's not that there's that proportion that's a problem across, because we had narrowed it to ones that we had concerns about. And I'd say similarly, I don't have an equivalent statistic of the numbers of concerns on the general one, and I wouldn't use the word breach because it's harder to be determinative that that is a breach. It's definitely a threat to independence. It's of concern to us, and we've described our findings as disappointing. So, but it's because of that being a general independence requirement, it's harder to reach that next stage.
So do you have a sense like how broad these threats are? Like across the community?
I think the reason why we've called them out the way we have and noted that they were in small firms as well as large firms is that they're sufficiently broad to be of concern to bring them to the auditor's attention, and for this to be an area of focus for us. I think coming back to your initial question about why, this trust, confidence and reliability of the information that our economy trades on is just so important that's why we've been thinking hard about independence. I think it might be a good opportunity to say that there's the question of independence in behaviour, but also more specifically there's questions about independence in actions, for example, on valuation. So an area that we've focused on in private credit, which Simone is expert in, is when we do see auditors going into funds, whether they be the super funds or other managed investment schemes or otherwise, that question of appropriately testing the valuation of the assets that sit within those funds is incredibly important, and it's sometimes very difficult, like there's sometimes not easily accessible information, but for auditors to take that step of trying to independently value it rather than relying on the valuations of either the fund managers themselves or someone else who's got a related party to that situation.
Somebody they used to work with.
In that circumstance, no, it would be more likely to be. But do you want to add in on the independence? So are you interested in that valuations question, or do you want to come back to this report?
I'm happy to actually follow up on that in
a fortnight. Sure, no problem.
Next hearing. Yeah. I just was really trying to understand was how widespread do we think this non-compliant, these concerns around compliance with independence is across the board, because my next question then is, how do we reduce that, right? And are the laws good enough? Is it just a practice thing? Do we need to have more learnings? Do we have to have tougher penalties? Like, if it is endemic and it is a big problem, then what do we need to do about it? And maybe that is one.
Do you want to take that on notice?
Well, I think we are going to have that extended discussion in a fortnight, so perhaps it's an appropriate time to talk more about independence as well as the other elements of discipline and other aspects. Yeah.
And just invited by Commissioner O'Rourke, Simone Constant for hands up. I would just add, just for context, as you go into that discussion, I'd emphasise that point about the importance of this, the financial reporting and audit practices and assurance in and around valuations in this era of rising private markets. So we always say...
Even a darker spot to have a look at.
We always say private markets done well are good for the economy, but to have confidence in private markets these practices are critical, and so Commissioner O'Rourke has started opened that discussion that you'll pick up in a fortnight around that importance when, for example, superannuation investments are made into private markets.
Could I ask you to take on notice, Ms O'Rourke, what action arising from that serious concern that is manifestly obvious in the report, what actions arising from that has ASIC taken?
Sure.
You know, correspondence to, you know, the CEOs of the Big Four, engagement with the representative bodies and the certifying bodies for auditors and accountants, etc. Like, what's happened in that space would be helpful. Thank you. Yeah, I'll give the call now to Senator Scarr.
Thank you very much. If I can turn to the order made against RAMS Financial Group, Pty Ltd. If someone can explain the conduct that RAMS engaged in that was subject to the penalty order.
Yeah, thanks, Senator. The matter was heard before Justice Sharif on liability and penalty on the 21st of October, and judgment was delivered on the 24th of October, and the court ordered RAMS to pay a $20 million penalty after admitting to widespread compliance failures in relation to arranging home loans. The court found that between June 2019 and April 2023, RAMS breached its obligations as an Australian credit licensee and contravened the Credit Act by doing a few things. So firstly, dealing with unlicensed referrers. Secondly, failing to have in place adequate arrangements to ensure that customers were not disadvantaged by any conflicts of interest. Thirdly, failing to supervise RAMS representatives to ensure compliance with credit laws, which included failures to create and enforce adequate policies and procedures, and failures to investigate misconduct. And fourthly, failing to do all things necessary to ensure that the credit activities authorised by the licensees were engaged in an efficient, honest and fair manner. The court held that RAMS failed to have in place effective processes and controls following internal findings of possible misconduct, which included instances of franchisee staff submitting false pay slips from non-existent employers and altering customer liabilities and expenses to ensure loan applications were approved.
Yep. So that issue of false pay slips from non-existent employers being used as part of the loan approval process to secure loans for people is deeply disturbing. That that sort of conduct would be occurring, and I note recent reports that the CBA has recently, and I know self-reported, so hats off to the CBA in that regard, approximately $1 billion in home loans obtained fraudulently, including doctored applications and even false documents created by artificial intelligence, which seems to be along the same lines in some respect as what was occurring at RAMS. So what action is the ASIC currently taking in relation to those issues, in relation to the CBA?
I might hand to Commissioner O'Rourke to start that.
And both the question and for drawing our attention to some of the most recent findings with respect to what appears to be possibly similar conduct there. So I think once we too have had taken notice and had information to us about the concerning areas that you make reference to for CBA and are at the point of making compliance inquiries with respect to those issues, we remain very keen in circumstances where issues are emerging to be connected to fellow regulators. So who may whether it be Austrac, APRA, the police, whoever it might be that are relevant in circumstances where something significant that could have elements that fall under the frameworks that they're regulating, being well joined up, working out if there should be a lead regulator or not, is part of that discussions.
So sorry to interrupt, who's actively leading then that investigation into what CBA has self-reported? Is it ASIC, is it APRA, is it Austrac, or is that still a work in progress?
It's a work in progress.
Okay. When are you expecting to have a resolution in that regard?
I should say, when I respond to it, it's a work in progress. It's not like there's some sort of official process that starts and finishes and there's a declaration of someone. It's a horses for courses as to whether inquiries continue in parallel or in sequence, or depending on the circumstances. So it's not like there needs to be a conclusion at a particular point in time in relation to that.
So do you have a cross-agency group that's working together looking at the CBA issues?
There are existing cross-agency relationships with respect to all of those agencies that we are leveraging that already exist, as they should, because regardless of the entity, these issues do need to be, information sharing is really important. And so to the extent that we've already got existing relationships, forums, and means of communicating, that's available to us.
Was there any immediate action taken as a result of CBA's self-reporting of this $1 billion in home loans it believes were obtained fraudulently?
So I referred earlier to the fact that ASIC is making compliance inquiries, so that's an action that ASIC is taking.
Okay, and have there been reports from other major financial institutions with respect to similar concerns?
I would need to take that on notice.
Or can I just table Westpac and ANZ?
I've seen the press reports.
Correct.
Your question is whether there's been.
Well, that was I was actually.
I beg your pardon. Sorry,
Senator O'Neill stole my thunder.
I'm sorry there.
That's all right. We'll have to liaise and caucus before we start these hearings next time. But there have been press reports in the Australian Financial Review in relation to Westpac and ANZ now reporting similar fraudulent-like practices, and there was approximately $150 million of similar fraudulent practices which National Australia Bank forecast some time ago. So what's ASIC doing in relation to those reports, in particular in relation to Westpac and ANZ?
Yeah, thank you. So I acknowledge the press reports in it. As to that question, also asked about whether there was the self-reporting. That's the part that I'm happy to take on notice, and I think similarly, unless I can be assisted, I'm not aware of that question of compliance inquiries, which is the response that I provided in relation to CBA underway as well. By the end of the meeting, I'll be, this hearing, I'll be able to confirm back to you if those are underway.
Yeah. Yep. Can I just encourage you to provide us an answer today in relation to whether or not
the Westpac and ANZ.
Whether or not Westpac and ANZ are subject to inquiry, active inquiry by ASIC in relation to these recent reports, which have generated quite a deal of interest. Have you seen the movie The Big Short?
I have seen the movie The Big Short.
Do you know
have you seen the movie?
I've even read the book.
That's it. And the scene in the movie when they go to Florida to actually talk to mortgage brokers in terms of the sorts of loans which are being entered into collateralised debt obligations and then on-sold to the market. This is this issue with respect to fraudulent loan applications isn't a new one, is it?
No.
Well, I think that in the Australian context, it's new. I'm not aware of these issues being sort of prominent in what we've had lots of other issues with the banks, but the fraudulent loan applications, I'm not suggesting they don't happen at all, but I would like to think there'd be a pretty immaterial number. These recent reports and I should say, frankly, I haven't got a lot to offer the committee in terms of a lot of information about them at the moment. Suggests something quite different. That maybe this is an emerging issue with the banks at the moment. But until now, I don't think it has been.
Okay. One of the particular aspects of it, which may be different from what was happening in the lead up to the global financial crisis, at least in a US context, is the concern that organised crime is involved, and that it's not so much the financial wherewithal of the potential customer; it's that they're fraudulently creating documents to create the semblance of a commercial structure, which they can then use to actually meet their loan obligations, but in the process wash money. Is ASIC, in terms of its inquiries, actively considering that part of what appears to be the practices or motivation?
I'm sure the team members undertaking those inquiries will be open to hearing what's different or what's new versus what other practices have occurred in the past. But to the extent that element might be there, that would be of more likely interest to AUSTRAC or the police, rather than the market conduct provisions that, or the conduct issues that would be of particular focus for us. But we need to understand the wider factual circumstances in which we're seeing issues to make that sort of a judgment. So yes, of interest, but in that contextual form.
Well, can I ask you this direct question? Is it actively being discussed by ASIC with AUSTRAC in this context?
I mentioned earlier that we're using the existing arrangements that we have for discussion. I don't have notes from those particular ones, and again, if we can, through the course of this hearing, confirm that, I expect that's of discussion, but I don't have that evidence.
If you can confirm it, it's or otherwise, because it is subject of quite a bit of public interest at the moment.
Yep,
I think
it
would provide some reassurance that our regulators are on top of the issue and are taking appropriate conduct.
Thank you.
Okay. Can I turn to the Shield Master Fund in the...
Before you jump off,
give
you some more time, can I just follow up on that? The matter under discussion, and I'll come back to you, Senator Scarr, in just a moment. The two articles that I'm sure were informing the Senator's questions and that I've tabled are from Max Mason, Joy Moulakis, Angira Baradwaj and Simon Evans. And Max Mason, if I cover them all off. One of the interesting conversations that I've had, and I don't know if my colleagues have backed me up on this, people know that money laundering is a really bad thing, but they don't actually understand exactly what it is or how people do it. And I think these articles are important because they actually put into the public place in a document what people are doing, where John Moss from AUSTRAC is quoted here. The banks assessing the market suggested criminals used mortgages obtained through doctored applications, which we've been discussing, to disguise the origins of illicit funds, embedding them into high-value assets such as real estate. So they get the money from perhaps drug dealing or prostitution rackets or modern-day slavery practices in our country, get enough money together, then they doctor up some applications, get a loan, and start to put the money in through this. Now, they've been figuring these out because they've had more than the 5% or the 20% deposit, and they're not behind in their loan payments, so there's no triggers in the system that would normally indicate. It says that by repaying the loans with criminal proceeds, offenders give dirty money the appearance of legitimate outcome. So that's just on the record for what is money laundering. This is a model that's operating currently in the Australian market. But I want to go to the article published, I'm looking for a date here, can't quite find it, one that you've got in front of you, banks calling tax over questionable home loans, that headline. If you go to the page where the timeline is, the first thing I want to know is it concerns me that it's from February 15, the Speak Up program, February 15, 2025. that triggers concern at CBA. But if you look through, we've got July, September, October. It's quite a while before the police get informed. So I guess, when did you find out? Who informed you? What is the line of, we found out this is happening? Who are we supposed to tell? And how quickly do we do it? Because an awful lot of money can be laundered in the space of a year. Although we do have the second tranche of reforms, and now we've got real estate agents who didn't want to be a part of it, now going to have to declare their suspicions. But they're only going to know, I'll put to you, if their accountants think it's their responsibility, and if auditors are going in going, hey, we're looking carefully for this, we've got a directive to watch out for any money laundering, and that becomes a priority for them, for which they might not be haven't been paid previously in their 5 of their 7 years. That hasn't been a real focus for them. Now it is, because we know this is going on. So can I go to the bit that says, bottom of the second column, one person with detailed knowledge of CBA's credit policies said another way criminals were targeting the banks was by buying shell companies that appeared to have been trading for 2 years and using fraudulent income documents to secure loans. The quote is, there is not an actual running business. They use dodgy accountants to show the income. Sometimes they have a website, sometimes they don't. And this is the bit that concerns me about the intersection between the professional knowledge that accountants have, the observation of what accountants are doing by audits, some of which you regulate, some of which you don't, and the large entities that would be in a position as the Big Four partnerships to be observing these sorts of behaviours if they were called to particularly pay attention and alert you and other relevant bodies in a more timely way. So I offer you the opportunity to respond immediately, but I simply putting really that concern on the record. Perhaps that could be part of your consideration going forward. What are the systems? What are the timelines? What are you saying to the accounting bodies? How are accountants who are enabled to do this able to do this?
Yeah, thank you, and we will definitely reflect on that ahead of the discussion, which includes the professional accounting bodies in a fortnight, so I'm sure they would have an interest in exploring this as well. I think we've talked about in prior discussions around the kind of regulatory perimeter that applies whether it to be auditors or accountants, that we have challenges associated with people providing sort of financial services or support in a way that it's not about their professional expertise. It's not that something special about being an accountant, that people who can doctor up financial statements could be beyond that group as well. And
yep,
so
we've been here. We've been here
with
right?
that scale. Oh, sorry, that boundary issue as well. But
so the question is, what has to happen to what needs to change? People are able to use the term. We've already, they can say they're an accountant. Mm-hmm. They don't have to have any qualifications.
That's right.
So is this a problem? Does it concern you? It affects the market. It intersects with what you do.
Facilitating criminals, that's
correct.
Right. And I think that extension of the money laundering requirements to a wider scope of people who have the obligation to report what they see, so conveyancers, real estate agents, accountants and lawyers, is a very significant extension, and I think in part because of their facilitation of commerce, property and other really important commercial transactions where the risks that you've drawn out, that money laundering of using dirty money and then repaying a mortgage, that's exactly the basis on which those extensions, I understand, occurred, to try and improve the visibility of that kind of misconduct.
So I know that you're not a policy-making body. That is up to us. But you can describe the problems and you can potentially offer suggestions about where things might need to be reformed in some way to stop the leakage.
And I think we'd also, encourage that question to be posed to the other parts of the regulatory system as well, like AUSTRAC. I would certainly defer to them on the best ways of thinking about the effectiveness of the framework, including as extended.
Yep. Thank you very much. Thank you, Senator Scarr. Back to you.
Oh, no, no problem.
That doesn't count. Any of that time's all. It's all my time.
I assumed that would be the case. Can I move to Shield Master Fund and First Guardian Master Fund? And Chair Longo, you made the comment about the massive effort that is being made by ASIC in relation to this, and I provide my compliments to everyone involved in the team. This is incredibly important work that's being undertaken. I'm going to ask some questions where I really want to assist in teasing out what is being done to protect the interests to the extent possible of the 12,000 investors who've been impacted, and also what those individuals need to do in order to protect their interests, which I think is incredibly important. And I'll kick the questions off, noting that I understand that ASIC has previously estimated that approximately 12,000 investors were impacted by the collapse of Shield Master Fund and First Guardian Master Fund. But at one stage, the number who'd actually lodged formal complaints with AFCA was only at about 2,000. So I'd be appreciative of knowing what the current update is with respect to those numbers, and as part of that answer, if you could please outline the importance of those complaints being made.
If you want to start.
Certainly, I'll kick off, and then Mr. Savundra may want to add something. So, the last data I have is as at 10 February, AFCA had received a total of 2,162 complaints relating to Shield and First Guardian. We are doing what we can to encourage people who've lost money as a result of the collapse of those funds to make complaints. We have information on our website that we're updating at each stage in the proceedings to let people know what's happened, what action we've taken, and how that may affect their rights. We there provide information about how to make a complaint. We've also met directly with some of the representatives of the key investor groups, which is important for us in terms of understanding I guess how people are responding to the information that we've published and what they understand about their rights, whether they're having any challenges dealing with AFCA, and we've moderated our approach or adapted our approach based on the feedback that we've received. One of the recent things that we've done is provide funding to Super Consumers Australia, which is a not-for-profit advocacy body for superannuation consumers, to stand up a new website that's specifically I guess, intended to assist people to understand what their rights are and how to go about making a complaint, and to try and explain that in very plain terms. And that's partly because we had feedback that people were being given advice from a range of different places, including some of the people that are, some of the entities that are involved in these matters. And they didn't know whose advice to trust, so we thought it was important to provide an independent source of information alongside what we're doing. We've also sent 11 rounds of direct mail letters and email to different categories of investors.
So can I just hold
Yes,
you there?
absolutely.
So you've sent, was it 10 rounds or 11?
11 rounds. Now, they're not necessarily to everyone. Some of them have been targeted to particular groups. So we spent, over the time we've been involved, 11 rounds of direct mail and email to investors.
But how much of that is actually, say, taking this 12,000 figure, and I note your update, the latest report you have is 2,162, which is still, it's less than 20% have made complaints, which is still a disturbingly low figure. How many of the 12,000 have been captured by that correspondence, and to what extent does that correspondence actually practically tell people in simple terms what they should be doing?
So we have, in terms of exactly how many we've reached, I'd have to take that on notice and see what we're able to say. I can, for example, say that our most recent mail out was an information flyer which really focused in on that issue of making a complaint and directed people to that independent website. And with that, we sent out over 13,000 flyers to just over 10,500 Shield and First Guardian investors for whom ASIC has contact details. So one of the key constraints here is whether we actually have contact details for the individuals, but that was also one of the reasons for enabling a new website to be established, in the hope that if it's designed to be specifically for this purpose of providing information to affected investors, some of them might find their way there through other routes if we can't contact them directly. So through doing searches online, it will hopefully come up in search results. They might see posts on social media. So we're trying to do everything we can, as well as, of course, what we do through the mainstream media in talking about these matters and encouraging people to make complaints if they think they've got it right.
Which is one of the reasons I'm asking these questions. Why is it important that someone makes a complaint to AFCA?
So that's a key way in which people who've lost money may get access to compensation. Now, AFCA needs to deal with each of those complaints on its own merits and form an appropriate determination. But if AFCA makes a determination against a firm that is still in existence, then that firm is required to pay that determination. If the firm's, for example, unable to pay the determination or has gone into liquidation, then the consumer may have a right to then lodge a claim with a compensation scheme of last resort.
Right. And in relation to people, and it could well be that some people don't even realise they've got exposure in this regard. They might not realise they have an investment in one of these funds. What's the method by which they can determine whether or not they do?
Well, our advice has been, if in doubt, to make a complaint, because AFCA can then determine whether they've got a right or not. And just to perhaps add to what I've already said, to give you a sense of whether we have some hope that our latest communication efforts will have an impact. So I said that we'd sent out flyers to just over 10,500 investors for whom we had contact details. Most of that was via email, and the email had a 97% delivery rate. So that means that we had confirmation it got through to somebody, and an 80% open rate. So 80% of those recipients actually opened the email. Now, it is, and there have been approximately 5,000 clicks from the email through to the website that I've spoken about. So it's obviously another big step to actually make a complaint to AFCA, but we have some confidence that our messages and sending out messages in different ways is getting through. And then Super Consumers Australia is trying to then help to further bridge the gap to making a complaint by soon publishing templates that people can use to lodge a complaint with AFCA. And we'll also then be considering, alongside Super Consumers Australia, what else we can do. Once we wait and see what happens to the complaint rates or the complaint numbers, what else we can do to raise awareness of that ability to make a complaint and how to go about it.
I just want to clarify what's the internet site people should be going to? What's the actual URL?
So it is called Take Your Super Back, and I actually don't have the URL here, but that will be a question I can easily.
I've got it. It's
takeyoursuperback.com. So
takeyoursuperback.com.
That's right.
Okay, excellent. And I remember the debates with respect to the compensation scheme of last resort, and Treasury put out estimates with respect to the likely draws on the compensation scheme of last resort. I can remember a figure of $20 million a year being discussed. Obviously, we're talking about thousands of people here in this context who have already made complaints to AFCA, and thousands more who may make complaints to AFCA. What estimates does ASIC have? Does ASIC have any estimates with respect to the potential draw on the compensation scheme of last resort arising from these collapses?
So the role of estimating potential demands on the compensation scheme actually sits with the CSLR operator itself, and it has there's a process in the legislation through which it makes an estimate each year, an initial estimate, then a final estimate, and then, as I think you've acknowledged in those comments, there are some caps on annual caps. So one of the caps is a cap of $20 million per subsector per annum, and if the operator considers that it's going to go over that cap in a year, it can then lodge an estimate, a further estimate, which can trigger the minister to consider a special levy. So that's the context in which estimates would be made.
Is the operator of the compensation scheme a last resort in active consultation with ASIC with respect to estimating the potential draw?
So the way I would describe it is that the operator comes to us at each stage as preparing an estimate, and I should say there's actually they engage an actuary that does the
Sure.
work of creating an estimate. It's quite a technical exercise. I mean, we provide information to them as part of regular communications, but they'll come to us with specific information requests. To the extent we can answer them, we do. And they factor that into the actuarial model, which results in the estimate. It is what tends to happen with these really complex matters is the estimates will become better over time, because initially they'll be starting with fairly raw numbers. They may not, at the early stages, they may not have AFCA determinations. And with Shield and First Guardian, I should say, AFCA is working through the process of making what it calls lead determinations, where it identifies matters that are determinations or individual complaints that perhaps are representative or of a broader class, and it will issue a lead determination to send a signal around what the pattern of determinations is likely to be, and they're partway through the process of issuing those lead determinations for Shield and First Guardian. So as the next estimates come out, I think we'll see more in the CSLR operators' estimates around the potential impact of Shield and First Guardian, because we'll just have better data on which they can base those estimations.
Is presumably ASIC's providing cooperation to AFCA in relation to the preparation of those lead determinations?
So where we have information that we can provide, we do. But in a way, at this stage with those matters, there are some matters where we've commenced proceedings, but in a way, AFCA doesn't necessarily need to rely much on data that we can produce. What they'll look at, and in matters that might progress to the CSLR, it would be on the basis that there's been financial advice, personal advice to an individual that's not been appropriate. Or what AFCA would be doing is looking at that advice based on the information that they can get from the advice licensee and the advisor, and making a determination based on those very individual circumstances. So they tend not to need to rely heavily on us for those individual determinations.
Okay. So to what extent, if there needs to be a special levy imposed, what's ASIC's role in that regard, if any?
Our role really is to issue the invoices, to answer in a really precise way. So if there's a special levy required, doesn't necessarily happen. It's up to the minister to determine whether there should be a special levy. That has occurred. So there was an announcement about a special levy in December last year.
Yeah.
But it's a year-by-year process, so there may well be further special levies. In a technical sense, our role, and that, I guess, the advice on the special levy is provided by Treasury, and then
So
our role
trying to determine whether or not ASIC is essentially the post box, if I can put it that way, as opposed to being part of the process or having input as to the fairness, the appropriateness of a special levy being imposed.
So the process of whether there should be a special levy and advising the minister, that really sits with Treasury. Our role is to issue the invoices once the minister has determined that there should be a special levy.
So ASIC doesn't provide any advice as a regulator, as a enforcement agency with respect to whether or not it's appropriate that a whole section of the financial industry should have a levy imposed on them because of the misdoing of a few?
That is really, it's a policy question for government on which Treasury would be the agency providing the advice. If we have data that we can provide that may be helpful, we'd be providing that to Treasury. But really most of that data would actually be fed through to the CSLR operator as part of that estimate process that I've described.
Okay. Can I move on to a particular...
Jump off that? Just if
Sure,
I can.
yeah,
A couple of
go.
questions on Diversa. I know that APRA have a stated intention to increase their intensity of supervisory oversight, and still maintain proportionate regulation. How does that sit with ASIC's strong enforcement action, court-based penalties regime? Are they comparative? Are they complementary? Do you discuss this as once again, an ecosystem of response?
Thanks, Chair. We've got distinct roles, and we're focused on conduct, so contraventions of the law by, in this case, it would be Diversa. As you know, we've commenced proceedings against Diversa, seeking compensation and alleging Diversa failed to conduct adequate due diligence before allowing its members to invest, and it failed to conduct adequate ongoing monitoring, failed to enforce a 50% holding limit imposed for First Guardian, and failed to have systems and processes in place to ensure that there was compliance with the holding limit. That, I think, we would describe it as the work that APRA is doing is being complementary to ours. Obviously, as a prudential regulator, they are looking to ensure that the operations of Diversa are prudent. So we do consult, and we have consulted in relation to the recent work that APRA has undertaken in relation to Diversa, and obviously prior to commencing and during the commencing the action against Diversa, we engaged and will continue to engage with APRA in relation to the progress of our proceeding.
Okay. So I understand that ASIC and APRA have a Twin Peak MOU. Is that correct? A Memorandum of Understanding. I'm not seeking to ask you to divulge communications, but could you give me a sense of when APRA raised concerns regarding Diversa through that MOU with you, noting that they first imposed licence conditions on Diversa in January 2023?
Chair, it'll just take me a little while to find that, so I'm not sure whether you wanted to move on, and I'll come back to that.
Yes, absolutely. Back to you for a couple more questions, Senator Scarr, and then I'm going to rotate the call.
The line group. Who can I ask questions about the line group? Lucky you. So I understand from previous questions asked in estimates that ASIC had some investigations occurring in relation to the Lion Group, and the Lion Property Group, I should say, the Victorian Supreme Court has now issued orders that the group be wound up, and there were scathing comments made by Her Honour Justice Patricia Matthews with respect to the management of the Lion Property Group. And I just want to put to you some propositions and give you an opportunity to give us insights from ASIC's point of view. I understand that ASIC did receive a report of misconduct in April 2020, commenced a preliminary investigation in July 2020, began a formal investigation in September 2021, but concluded that investigation in June 2024 without, to my knowledge, and you might be able to correct me, any action being taken, and yet in 2025 the Victorian Supreme Court took the action to wind up the Lion Property Group, and in doing so they said that they put aside the issue of insolvency and said, based on the conduct of those responsible for the management of the company, that was an appropriate order. So could you explain what the misconduct investigated by ASIC was in relation to, and whether or not there was any connection between that misconduct and the matters which led the Victorian Supreme Court to order the winding up of the company.
So, Senator, I might just start with your chronology. Unfortunately, I don't have the exact dates in front of me, but based off my recollection, I think the dates you provided are broadly correct, as in we concluded our investigation of the matter in June of 2024.
Yep.
I'm somewhat limited in what I can say because just bear with me, I'll just get the date.
And just whilst you're looking for the dates, one of the comments that Her Honour made was one of the reasons why the group should be wound up wasn't just to protect the assets and the position or the position of the existing investors, but was also to mitigate the risk of losses by new investors. So that was actually an active consideration Her Honour had.
I understand that, Senator. So why I think I need to be a little limited in what I say is that I think it was either late September or early October ASIC commenced a new investigation in light of...
In 2025.
So we have a current investigation on foot.
Right.
So I'm just wanting to navigate carefully in a way that I don't prejudice the current investigation, despite the fact that we concluded the original investigation.
And if at any stage we need to go in camera,
We can do that.
We can also do that.
For sure. So, ASIC quite often waits to commence an investigation where there is an insolvency until the relevant liquidators report. Once a company goes into liquidation, liquidators are appointed. They have a statutory obligation to investigate and report misconduct to us. In many respects, because they are or become the controllers of the company, they are very well placed and in some respects better placed than ASIC to get to the bottom of misconduct. So they can sometimes see misconduct more easily than we can when we're engaging with the operators of the company to obtain information prior to it going into liquidation.
Having said that,
Yep.
and you know this as well as anyone, ASIC has a toolkit of regulatory actions, enforcement actions it can take, which include, say, freezing orders or other actions to try and at least hold the position, hold the ground for investors, if I can put it that way, to make sure their position isn't further deteriorated prior to liquidators being appointed. So
we do that, and we do it often, but we are selective, and we need to make choices. So without disclosing too much about the original investigation, we did do a thorough investigation looking at potential harm, and what I'm talking about is a legal harm, so that money was being misappropriated, rather than what the judicial finding that the court made was that they were operating a managed investment scheme and it was unregistered.
Okay, so the obvious question, and you can probably anticipate the obvious question, but if you're investigating a entity like this in relation to possible misappropriation, I would have thought that raises a red flag for governance issues across the board, including possible unregistered managed investment schemes and whatever else. So surely as part of an investigation such as this, you would look at the entity in in a broader context for other possible non-compliance.
And the answer to that, Senator, is no, we don't. We are selective in, not always, but we are selective in what we look for. The context in which this occurs is the Lion Property Group did not hold an Australian financial services licence. What the court has found is it was operating an unregistered managed investment scheme. And in those circumstances, we are looking to see, in quite a narrow way, whether there is obvious misconduct that is occurring.
But surely, if you're looking, I really want to tease this out, right? So, surely, if you're looking at possible misappropriation, etc., you, as part of your investigation, you'll get a sense as to what the company is doing, and there are all sorts of obvious indicators of managed investment schemes in terms of contributions from investors being invested common purpose, the definitions. You don't just go in, presumably you don't go in blinkered as to the narrow focus of investigation. You're going to look at things from at least from that perspective, which I would have thought's a somewhat obvious one.
Again, without going into too much detail, what we did is a detailed tracing exercise. We wanted to see where the money was going, and we do narrow our focus particularly on investments which are outside of the regulated space.
Okay. My last question on this, and I'll discuss with the chair as to whether or not we should have an in-camera hearing in relation to this as a bit of a case study at some stage.
Even if we put some stuff in notice to inform that might be the way to go as well.
But has, given the findings of Her Honour, has ASIC engaged in an active debriefing process looking back at what ASIC did from the time when it got the first reports of misconduct and asked whether or not maybe we could have approached things a bit differently? And I won't ask you to answer that now. I take that on notice because it's, I think you've heard the tenor of my questioning, and I think investors will have their own concerns.
Well, I think it goes to an issue of the level of expectation of those investors about the degree of protection ASIC will afford them, which I think certainly happy to have a conversation about that. It's fair to say we invest more heavily in the protection of investors within clearly regulated space. That doesn't mean we ignore people who invest outside of the regulated space, but it means that when it comes to the level of investigation we undertake, it means we will, just from a resourcing perspective, have a narrower focus.
But at the same time, it raises a question in our minds as to thinking about those investors who invested into that entity, into that enterprise, from the point in time when a red flag was raised with ASIC to the point in time when it goes under.
Understand. And then in relation to the current investigation, you know, that is examining new information that's arisen through information that the liquidator has reported to us.
Chair has something to offer. Nothing. Useful or likely to be welcome. Okay. All right, fair enough.
Okay, thank you very much. We've got a block of questions now for Ms. Lawrence, which will take us through till a little later than indicated in the program. So at 2:50, we'll break for an afternoon tea break.
Right, lovely. Thank you, Chair. Chair Longo, in your address, I think as recently as yesterday and certainly last year too at the National Press Club, you spoke on tokenised securities and its potential to fundamentally change the capital markets. I just would appreciate if you just could give a minute or two to how you think it would indeed do that. And then before we go to any risks discussions, I'd love just to hear about where you see the opportunities for Australians in moving this path.
Well, tokenisation is a process where what are regarded as real-world assets, whether they're physical or intangible, are turned into digital tokens on a blockchain. And so it's a totally different way of thinking about how we trade. And so the technology bridges traditional finance with decentralised finance, enabling fractional ownership and increasing liquidity. So this is a rapidly developing field with encouraging innovation in this area in Australia, as are other parts of Asia, in particular Hong Kong and Singapore and in the US. So I think the broad sort of story here is whether we're doing enough to encourage innovation. And and ASIC's position is we'll do everything we can to help startups to navigate our regulatory framework in a way that's safe. So in yesterday's speech, that's what I was getting at with the sandbox. And of course, we're also working with RBA over Project Acacia. This is all in the speech. And so it's really this whole idea of really encouraging everyone to think about what the economy would look like, what markets would look like 5 or 10 years from now.
And so from those examples, Singapore, I think Switzerland, you've referenced about the 6 digital exchange with their digital bonds issuance, already exceeding over $3 billion. Are you seeing productivity gains, faster settlement times? Is it more transparencies with the permanent record? Like, what are the things that
I think, as the speech says, there's a lot of experimentation going on, but certainly in Australia, none of this is happening at scale. But if we want it to happen at scale, well, then we've got to encourage it and have trial and error, and that's how innovation happens. People have a go. Sometimes it works, sometimes it doesn't. Sometimes it's regarded as commercially viable, sometimes it isn't. But I'm convinced from my own conversation I've had and from my foreign travel, talking to foreign regulators and asset managers and market participants, that this is the area we need to be thinking about and focused on.
And in those, in your travels, are you seeing the focus just on tokenised assets, or are you looking at the distributed ledger infrastructure as well?
Well, tokenisation is on DLT. That's how it works.
Or it could potentially work alongside, I presume, like after the chess failure, for example. Would you?
It's a different technology. Distributed ledger technology is a different technology to what I understand the chess replacement is going to look like. So that's the issue. It's being able to harness DLT at scale and achieve things like atomic settlements. At the moment in Australia, we have T+2. We're actually, in practical terms, T+1.5. In other words, settlement happens within 2 business days of the transaction. In some parts of the world, like US, they've achieved T+1. There's been a lot of work being done in Australia as to the appetite for the investment required to go from T+2 to T+1. But my overall message
so can I just ask
is openness to innovation. There are no instant results.
Sure.
But that's what we're playing for.
So where you describe like the T+1, is that suggesting that the US? But is that suggesting the US is still using some conventional clearinghouse models?
No, it's suggesting that we're T+2 at the moment.
Yeah, sure.
The US does T+1. The ASX, which is it's the primary entity responsible for clearing and settlement, has spoken to market participants and consulted about whether the cost benefit of investing in going from T+2 to T+1. That I think it may have suggested some confusion. It's got nothing to do with tokenisation.
No.
Yeah, but the promise of tokenisation is resilience, efficiency, productivity, and so-called atomic settlement. So things that happen instantly.
And
I think Australia needs to be part of that.
Sure. Look, I think I'm certainly was very buoyed by your enthusiasm for innovation. Like, I think it is exciting, and I liked the challenge you put down.
With respect, enthusiasm's the easy part.
I know, but
it's just a lot of work has to be done. A lot of policymakers, government, regulators, private and public sector. You know, has to come together to make this happen.
Yeah.
Because the investment required is huge. And secondly, the competitive forces are huge as well. So there's no, this requires a whole of government effort. I think that maybe Commissioner Constant can help me there.
I was just going to add to just give depth to what the Chair spoke about yesterday and your line of interest and question. Absolutely. So you called out innovation descent. So we continue to say we support responsible innovation and facilitating it, not just observing it. So we're observing the same trends you're picking up on, and Chair Longo mentioned. There's increasing amounts of research and analysis to suggest tokenisation could be the disruptor in financial markets. It could be. The question is, and this is where Chair Longo was going, I think just then, is the scalability of tokenisation versus traditional models. So Chair Longo just mentioned US market and the move to T+1. That's traditional models, so traditional models infrastructure. But it does apply that tension, and the accelerating pace of change and development and tokenisation's application means that with each year that passes, we need to not just be paying attention to the application of tokenisation potentially, and I'll talk a little bit about what we are doing now and what we will be doing, but also the expectation for approaching real-time settlement. I am not signalling that this is ASIC saying we expect real-time settlement or that that's the key priority right now. But as tokenisation grows and other disruption, T+2 each year will be seeing more pressure to think about whether that's appropriate. A couple of things, just because you did allow us to anticipate the question, I just thought I'd put down some thoughts about what we are doing. And we're conscious that there's a lot of research about the sort of tens of billions of dollars of potential here and the international focus. So we're very conscious of what Chair Longo was noting, that the advisory group, participants, every markets panel that I convene, they'll tell us right now, focus on CHESS. So number one right now when it comes to clearing and settlement, the stability of the implementation of CHESS. That said, it doesn't mean, as you can hear from our posture, that we're ignoring the opportunity and the potential of tokenisation and other technologies. We are technology agnostic. So just a few things we've done. We licensed FCX, so that was last year, I think, for private companies and funds. Now, this is small, but there's potential. This is disruption, and it's one of the world's first tokenised markets with that atomic settlement. We absolutely are informing ourselves, so that's why the Chair was talking about this yesterday, participated in OECD roundtables, in subgroups to understand where we're up to. We're convening the industry roundtable in May, which will touch on this application of financial markets infrastructure and more, and my colleagues can talk about some of them more. And we've actually already commissioned some research for testing the legal and regulatory barriers. So are there things we're doing that are imposing friction and not showing that?
And is that being tested in the project Acacia?
I'll let Commissioner Kirkland talk about Acacia, but that's more generally for understanding what the frictions are. And then I just want to circle back to right now, though, we absolutely are aware that the market participants, everyone has said, prioritise CHESS right now as we lean into April. This work is going on in the background, and in May, if you think about the roundtable anticipating being through the first release and some adjacent work in Acacia coming through, we will be in a good position when we're next with you to talk more about this. And I don't know, Commissioner Kirkland, if you wanted to talk anything about Project Acacia.
Just at a high level, we can always come back with more detail, but we are obviously supporting Project Acacia, sort of led by the Reserve Bank, but also with the Digital Finance Cooperative Research Centre. ASIC's role has been, I guess, to be part of the discussions around design from the very beginning, but in particular to grant regulatory relief for some of the participants to allow them to, I guess, test certain applications of some of the technology we've been talking about. And that project was a sort of time-limited project due to wrap up soon, and the RBA, I understand, will be issuing a report on what the outcomes have been, what their observations are, and what some of the potential implications are, and to the extent some of those implications are relevant to how we approach our work, either individually or alongside the RBA, we will be thinking about those and having more to say, I think, over the course of the next year.
So,
Just one one last forum in which these issues are being really actively considered is the current statutory review of the enhanced regulatory sandbox, which ASIC administers. So there is a sandbox that is in relation to financial services relief, so particular aspects of relief are given so people can come in, and that had a statutory review that's underway at the moment, and the reviewer, Ms Maha El-Damiki, is taking a very wide view about what sort of sandboxes or regulatory arrangements more generally, rather than just is this one got exactly the right specs, do really enable innovation, the testing, the coordination, the convening in ways that I think is really nice wide thinking. Like, we've really appreciated that, her lens, and looking forward to hearing her conclusions that sit alongside things like next steps after Acacia as well. So there's lots of different enthusiasm and opportunity and discussions that are getting granular. Just
I do
wanted
feel
to
like I'm
mention
probably a
that as
little
well.
early with these questions. I feel I need to wait.
Oh, well, no, there's plenty happening right now, but yeah, there'll be even more to say.
I guess just from your experience within the sandbox and the safeguards, perhaps you've had to test within it, but also looking to see how Singapore, Hong Kong, Switzerland, US have managed things to date. My understanding is tokenism, the tokenization promotes decentralisation, but of course we're in the business with financial regulation to have clear, responsible entities. So I'm wanting to understand what's ASIC's perspective on how it's going to manage a decentralised model. Like, who's going to be accountable if something goes wrong, whether it be a fraud or a mistaken transaction? Where will the accountability sit?
So to the extent that any entity is issuing a financial product or providing a financial service or providing a market, they will need to be appropriately licensed or authorised. So we look at it through the lens of who are the Australian entity, the entities operating in Australia that are performing one of those roles that we regulate, and they'll still be subject to the same obligations regardless of the technology that they're relying on to deliver those services. So
I think it's less in application to tokenisation specifically, but the wider question that you're asking has also played out in relation to payments. So technology has permitted a very significant kind of fragmentation of payments chains. What used to be done entirely within one entity is now, by virtue of technology, being able to have really, specialised players that play a really important role, but only a specific role. And so the reforms that are being currently consulted on in relation to payments actually recognise that, and it's switching from sort of an entity-based framework to an activity-based one. So that idea of being a payment service provider, doesn't matter what else you do in your business, if you fall within that activity, you'll now need to get, if the law passes, but subject to that being a successful new regulatory framework, its premise is based on that idea of activity rather than just assuming a type of entity.
So do you see that we, as a government, will be required to introduce legislation so that tokens are regarded as a legally valid record? Like, is there change, of ownership? Is there something there that you think will be required to do in order to better facilitate?
Well, the government's approach has been to identify specific activities, I think, that aren't adequately captured by the current law. And so as a result of so under the digital asset reforms that are currently making their way through Parliament and the payments reforms that are at a slightly earlier stage, there are some new definitions that are being introduced which will require entities that provide those particular products or services to be appropriately licensed. And I imagine if there's a need for further reform along the way, that may well be considered. But there are many activities that, because our current law is technologically neutral, there are many products and services that are, some of which are being provided at a smaller scale today, some of which could be potentially provided in the future, that involve blockchain technology, may involve tokenisation, but can be adequately captured by existing financial service and product definitions. But as I said, the reforms seek to then bring a few additional types of activities in that have been identified as needing to be regulated.
And without preempting the outcome of the report, are you thinking, given obviously there's some loss of confidence with the ASIC's capacity around the CHESS program, would you be suggesting we start and trial, or not trial, but start first like in private markets and venture capital and digital bonds rather than trying to do a big wholesale change?
I might be a better place to take that, and as you say, we can come back to this when we've completed some of the current work. But actually, that is the approach we're taking. Whether Commissioner Kirkland would have talked to what he's been, the area he's focused on, or Commissioner O'Rourke, it's the same in markets. So in financial markets, that licensing of FCX that I mentioned, that's the approach that's been taken. So the challenge, though, of course, is going from, let's not call those pilots because they're up and running businesses and initiatives, and we're really encouraging of those. That's that enthusiasm. The challenge now is taking these smaller approaches and within those guardrails and making them scalable to see. But that innovation is encouraging for keeping that challenge for competition.
And my last question, I guess, is around the capability of ASIC. What would need to change to ensure there was 24/7 monitoring, potentially of a global market, of trading in tokens? What would need to change within ASIC in terms of skills, for monitoring? And
there is nothing today that I would identify, certainly for my part and for what I see. Indeed, this is the kind of capability we continue to invest in and adapt. It's a good question to take on notice for the broader discussion in May. And we have these things, we've talked today about our enhanced and refreshed supervisory approach, for example, with respect to ASX, but that's also financial markets infrastructure generally, right alongside the RBA. We don't need to have all the capability. We work alongside RBA, but we're continuing to invest in and develop ours. That's something we're doing right now. We're always doing that, but it's actually a core focus at the moment. And as I said, it's not just because we want to see these commitments delivered by ASX. It's not just because we want to see CHESS delivered safely. It's because we want to be able to use those powers that we have to facilitate competition, and competition through innovation and understanding the global pace, the global place we have, and the accelerating pace of change and the tension that provides.
Thank you. I look forward to unpacking this further the next time.
Excuse me, Chair, just before we break, there were 3 questions in relation to the earlier discussion on loan fraud that I just wanted to quickly come back. I think one on what do we do about accountants facilitating. We agreed to take on notice, but the other 2 posed by Senator Scarr were about whether inquiries or issues in relation to loan fraud were being raised with banks beyond CDA, and I can say yes, and also whether ASIC and AUSTRAC had joined up in relation to the issues discussed, yes. So I just said I'd come back to you during the day. Yeah.
And maybe some detail that on those 2 things on notice, if possible. Mr. Savandra, did you want to close the loop on the APRA ASIC MOU?
Chair, if I could, I've not been able to. I've got a lot of information in front of me, but I've not been able to get the information to answer your query, which I think is about the APRA 2023 licence conditions.
The timing.
The timing of that. So if I could take that on notice, I'd be grateful.
Sure. And I'll put the other one with you. Could you compare the differences ASIC's found in its investigations and actions in comparison with the Diversa APRA investigation and actions made? Again, a bit of a compare and contrast would help me understand what different parts the 2 regulators are working with to get the shape of that particular problem.
For sure.
Thank you very much. The committee will will break for a short period of time. It's been 2:52. We'll return at 3:07. How's that sound? 3:07. We'll kick off. we'll resume with a block of questions from Ms. Lawrence.
No, I've been done.
Oh, you've been done. Sorry, from Ms. Jarrett. Thank you. Final stretch, everybody. Hang in there. So my questions are going to scams, and I raise this quite often when I'm with regulators. It's a big issue in my electorate, and I'm always having people come up and talk to me about this. So back in, I think, 2003, 23 and 24, you did reviews of the banks in relation to prevention, detection and responses to scams. Has there been any recent data that you've collected that tells us how many, what's the financial value of scams? First of all, let's just keep it to the banks, your area. Yeah.
So in general, that role around collecting data on scams sits with the National Anti-Scam Centre, which is part of the ACCC, and they do break it down by types of scams, and we can always go to some of that data. We've done two pieces of work that have looked at the bank's responses. The first one was the one you mentioned that looked at the response of the 4 major banks to scams and some of the outcomes for people who made complaints about scams. And then the second one was where we went and looked at a range of smaller banks or not small, but non-major banks and their responses. And as part of that, we then updated the data on at the same point in time on what the latest data was in relation to the 4 major banks. So that we've just done.
Are you seeing an increase? Like, have you got data from the ACCC that shows any changes at this point, or am I jumping the gun?
So the ACCC,
ACCC. Who did you say it is? ACCC.
Yeah, that's right. It's the ACCC, and the NASC, which is part of the ACCC. But I guess in terms of overall scam losses, the data for the first 9 months of 2025 showed a 16% increase compared to the same period last year, and consistent with the previous data, investment scams were the highest category of overall scams. So in that last data that was released, there had been a bit of an uptick.
And is that uptick in numbers or in financial value?
That's in total financial value as reported by individuals to the ACCC.
So more people are losing money, or the same number of people are losing more money as a result of scams at the moment. So, okay, so with that, looking at that then, your report in 23 or 24 showed that those who had succumbed to scams, I think less than 5% or a very low percent had actually received, is it compensation or been reimbursed? It's a very, very, very low, the reimbursement is very low. And my question is that improving or not?
I'm just finding, actually I've got the...
Some of them said, I think one of your reports said 2 to 5%, then there's one that said roughly 11%. I don't care if it's 2 to 5 or 11, regardless. It's a very, very small number of people, mums, dads, grandmas, aunts and aunties who are being scammed and getting anything back as a result.
So when we went back and did that further work, what we found was, so the initial report had found a reimbursement rate. So that was a rate of reimbursement relative to people who'd complained. It had been 4% in the 2021-22 financial year from the 4 major banks. When we did that further piece of work that I mentioned that includes some non-major banks, and we updated the data on the 4 major banks, the reimbursement rate had increased to 7% in 2022-23, and then had fallen slightly to 6% in 2023-24. So I guess it had improved over the initial period that we'd done that work, but still relatively low in reimbursement rates. But in the meantime, of course, the Scams Prevention Framework legislation has been introduced, and that will be progressively put in place over the next few years.
Yeah, and that rolls out, I think, compliance for the banks has to start at the 30th of June this year, correct? So
the government has announced its intention for there to be a mandatory code applying to the banking sector to commence around the middle of this year.
Yeah. And, is there a reason why, from your perspective, you're sitting up here, this is all happening here,
Like, why is it that the reimbursement is so low?
I don't. That's not something we specifically looked at in our work.
Is it in your remit?
Well, at the moment, one of the reasons the scams prevention framework has been introduced, I think, is that there are no specific obligations for banks in relation to scams in the law. So we're sort of falling back on sort of general law, and for the banks, they're determining those in the absence of any really specific obligations about how they respond to scams. Obviously, the scams prevention framework will change that. It also introduces or extends access to dispute resolution in relation to scams. It'll also bring other entities that are involved in scams into the dispute resolution framework administered by AFCA, so digital platforms most notably. Also telcos will have specific obligations. So I think we'll see a range of changes that we would hope would see an increase in reimbursement rate where that's appropriate. The other thing I should mention is one of the challenges for customers getting reimbursement at the moment when they go to AFCA has been that AFCA hasn't had the jurisdiction to determine complaints in relation to what's termed the receiving bank. So if somebody has been scammed and they've been tricked into sending money to somebody else and it's gone to another bank, AFCA hasn't been able to look at what that other bank has done. We've recently approved changes to the AFCA rules, which will start soon, which will allow AFCA to look at what the receiving bank has done. So that may also have an impact on rates of reimbursement.
Can I just jump back to one thing you said? You said there is no obligation in the laws. Is that a policy setting issue for us to be thinking about?
Well, I was referring to the situation before the introduction of the scams prevention framework legislation. So, and that was the basis on which we did that previous work. So, really, banks would have to deal with scam complaints, and AFCA would, just based on the general obligations of banks. But the scams prevention framework will change that because it's the government's intention to introduce a mandatory code to apply to banks, which will have specific obligations.
And is that going to be overseen by ASIC, or?
It is intended, so it'll be a multi-regulator model, but it's intended that ASIC will be the primary regulator of the mandatory code in relation to banks.
Okay, and so the repercussions for bad behaviour by the banks that result in fraud or negligent behaviour, is that, and pardon my ignorance, is that being developed now, and are you having input into that, or is that already set?
So my understanding is Treasury is working on developing that mandatory code. I mean, any questions about that would best be directed to Treasury at an appropriate time. But around this whole framework, given our role and our previous work, we have had regular conversations with Treasury.
But yep.
To the extent there's been some issues where we've had to rely on general law, there are circumstances where we've decided to take action in relation to that. So we do have commenced proceedings in relation against HSBC in relation to scams. So there's some, as well as the surveillance work that was referred to earlier, that's underway.
Okay, I'm just sort of trying to put all the pieces together, but I do get that. So in terms of, I know the code of practice is coming in. Are those the repercussions? Is that where does that get spelled out? Does that get spelled out in the corporations law? Does it get spelled out in the code of practice? Like, where will we see that?
So there are some general principles-based obligations that sit in the relevant Act, and they'll in general be overseen by the ACCC. But then the Act creates a power for the Minister to designate particular sectors and declare and to establish a mandatory code in relation to those sectors. And so the mandatory code for banks we will be the regulator for that. And so if a bank, if we receive a report of misconduct about a bank having breached one of those specific obligations in the code, we can consider investigating that and can consider taking enforcement action once that's in place.
Okay, and just in terms of your everyday activities in relation to the banks, are you seeing them getting ready for the implementation of the code? And where are you seeing changes? Is it in their governance, their technology, their customer engagement? Can you give us a bit of an indication of what's changing?
Ms O'Rourke can probably
no,
answer.
thank you. There is a current voluntary, I think it's called the Scams Accord, is that right?
Yep,
That
yep,
banks and the ABA have worked on, which has been an effort on a voluntary basis to change internal practices and external engagement in relation to the issue. We are yet to see the proposed or the code that will be developed is still in development, but it'd be surprising if it didn't encompass some of the practices that are already included in those voluntary efforts that have already been commenced at a lot of the organisations. So I don't think the banks are sort of waiting until then before they start. There's definitely, we understand, actions underway to uplift protections and responses, including because of the surveillance work and the actions that ASIC has been taking. And I think the banks recognise how important it is for scams to be stopped and for them to respond appropriately. So I'm not sure if there's a specific area you're interested to inquire in, but we've seen a very high level of interest in scams and a high level of interest in the framework and the code and the steps that will be expected, and as well as Mr. Kirkland referred to, that question of dispute resolution, which is going to be a very important part of the new framework.
Yeah, I guess what I'm, where I'm coming from is how do we talk to consumers who are really concerned about scams and say the framework's coming in? Is there a message to the banks? Like, are you giving a message to the banks that you've got a benchmark of improvement that you want to see in terms of A, the number, and B, let's bring that 2 to 5, 11% up a bit higher? Like, how are you thinking about measures of success, right?
In circumstances where a new legislative framework has been created and a code that will sit underneath it is in active development, I understand it would be unusual for us to set something separate and to front run that. So, having said that, the reports that Mr. Kirkland referred to were pretty clear about areas of concern. And actions that we take, including enforcement action, are a very clear signal as well. So, we haven't not set milestones or benchmarks or something separate from, but we do recognise the importance of the codes because that's the sort of place in which it will appropriately set out what those expectations are, and we hope that they're available really soon.
Our message to consumers now is if they're affected, they should still make a complaint to AFCA. Despite some of those limitations of the current framework I've spoken about, people are making complaints to AFCA now, and some of those people are getting outcomes, and AFCA's powers will progressively increase over the next year or so. So we do encourage people to make a complaint if they've lost money as a result of a scam.
Good to hear. Thank you. Thank you, Chair.
Thank you very much. I might take a dedicated turn now with a couple of questions, if I can, on ASX. Just extensions from this morning. We've already discussed the change to the capital charge and what we think that might do. Are there any specific governance or cultural changes that the ASX should prioritise first to regain market confidence, in your view?
Yeah, I'll ask Commissioner Constant.
Thank you.
So specifically with regard to governance changes, absolutely there was a governance change that was identified. That was the Independence of Clearing and Settlement Board. So something that was identified in the inquiry's interim report was the importance of governance and driving the right culture and the incentives. Yep. And the ASX have already moved to make that change so that the clearing and settlement boards only have independent directors. And the second part of your question?
That word again, those independent directors that we started with this morning, right? So there's concerns about that. And I guess that's what the purpose of my question is, because I've been following closely and I'm aware of the change, the recommendations and the change. You're observing it. Is all well with the cultural piece of change? That is what gives life to the governance reframing.
Yeah, that's the second part of your question, which I think is a more complete question, isn't it, about the cultural change? I think was your question, Senator. Is there something with the culture that needs to change?
Yeah, well, what degree of confidence do you have that that's happening, and what is sufficient being done to regain market confidence?
I'll start with the tail of the question there, which is market confidence, because that's where we've started with our work in terms of with the inquiry and indeed even with the commitments reset and the reset that's underway. Confidence is paramount. So our expectation of ASX, and I did reference the Chair's public remarks on the 27th of February, not our Chair, the Chair of ASX, where he acknowledged and accepted the findings of the inquiry's interim report and acknowledged where they're starting from. Our expectation, and he used these words also, is that the ASX will move to an aspirational culture that focuses on their role as stewards of critical national markets infrastructure. If you work backwards from that as an aspirational goal and an understanding of the purpose and place as a culture, working backwards from that, then the other elements follow in terms of the degree, breadth, importance and style of reset and refresh that's required, and that goes throughout the organisation.
So do you believe that is underway, and how is the market talking about this? What are people saying in the market? Are they confident that the change is already implemented and bedded down, or is it a work in progress that's just begun, or are we seeing some fruit of this aspiration?
So a simple answer is it has indeed only just begun with this reset. So the full report of the inquiry, the panel of inquiry, isn't due until the end of this month, and we'll be considering and responding, and that's the complete response and report. The interim report is only the beginning. So as mentioned in response to Senator Scarr's questions also this morning, having done so much work and understood the importance of the role and the need for that confidence, both the inquiry panel came forth with the interim report and we responded at the end of last year to move forward on some of the initiatives because it was time and it was possible, and that is all about that confidence, giving the market confidence that we've had a panel that's come and worked with us to understand the governance, risk management, capability challenges and how they relate to that culture that needs that aspiration around critical national markets infrastructure. That's the beginning. That's the beginning of this refresh and reset journey.
So the first bit is acceptance that change needs to occur. Change has been accepted. Things are underway. What's the process of communicating what you observe as cultural change into the marketplace? Or is it going to be by a series of whispers across the sector?
I think you've just put it perfectly. So the first step is the acceptance of the need for cultural change, and indeed the acceptance of the need to meet that aspiration and fulfil that role, and the primacy of that in how ASX from board down through the organisation think about their role and place. The reason I referenced the public statements on 27 February, which were consistent with the public remarks at the time of signing the commitments letter, is it is the first starting place, however, that ASX have publicly recognised that's where they are. And I think their own words about sometimes falling short, the accepting the findings of the panel and the need for the reset, and they've publicly talked about the need for the circuit breaker. That is the starting point. Now, you've asked, can we give assurance that we're well underway and that change is happening? No, we can give assurance that we've seen the start of this part of the journey, and we've seen that in the commitments letter which we've published. We've seen that in those public remarks. We see it in the engagement at the moment as we're engaging with them closely around delivery of just received the plan for a plan is how I describe it, around how we work through Accelerate over coming months. And we see it in the engagement that supports that, but it is the beginning of that journey. As to market confidence, we can assure you of our commitment to market confidence, including the purpose of bringing forth inquiry, the responses in December, the responses you'll see when we see the final report. We can't give you the assurance about confidence of the market in ASX. We can assure you that that's paramount for us, and indeed that's what the panel have also expressed to us, and that's why we're moving swiftly and making this a priority, and that's why we're holding them to account against this very comprehensive package of commitments in the interim report.
So change management is one of the most complex things to ever undertake. It's okay to put a system in place that deals with, numbers, but humans are complicated, and somewhere in the gap between guilty and ashamed, having admitted mistakes, being powerless when you're shamed and unable to respond to that is where change might begin. So I think we need to continue to regularly ask you questions about what you're observing, and I don't know if you could, in your compare and contrast that you're going to provide me, what would it look like? What could the committee interrogate to assure ourselves that confidence is returning to the proper functioning of the ASX in the broader market. So they're just for on notice. If I could go to the outages, so the 2016-2020, what steps has ASIC taken to ensure investors can still access auctions when one exchange experiences a failure? Because it's not the only exchange, is it?
See that? So you're going to the resilience of the market and the outage. So I think we've probably talked before at this committee about the outage itself. The important element of your question, though, is that resilience and that concept of redundancy. Primarily, the primary focus, because the bulk of the Australian market, in terms of equities listed market, for example, clearing through ASX, primarily our focus is on the work with regard to that critical national markets infrastructure role of ASX, including this reset. So,
but can I ask you to consider it in terms of the competition efforts, right, and the alternative structures that exist in terms of redundancy capacity? So, can investors still access auctions in one exchange when the other one fails?
There's not the element of redundancy that would allow me to blanket answer yes to that question. So, and that is not what we saw, however. That's not what we saw in terms of the outage that we saw at December a year and a half ago. That wasn't the nature of the outage, but that resilience and that redundancy capability is not, we cannot blanket say that all services can be rerouted and provided. We can say that when we consider our role with promoting competition in clearing and settlement, we can say that, and I won't speak for the RBA because RBA are the resolution authority when it comes to clearing and settlement, and they are the lead resilience authority, and they have the financial system standards responsibility. But we can say, I'm sure I can say for them, that when they fulfil that role also, the resilience and the need for redundancy and for cutover is something that is informing the way we think about competition and the way we think about the potential to license if there's alternative providers, because of course that is the best way to think about if there is an ultimate failover for a duration that requires that redundancy.
So we do know that CIPO have, I think, a new CEO and things are changing there, and they've changed their decisions about engaging in the Australian market. But I hope that we'll still have the element of competition that has brought in. So my questions go to acknowledging that, where we are at the moment. Is it correct that the ASX 200 benchmark currently excludes transactions executed on the CIBO Australia platform?
So that's a very specific question. I think you're going to interoperability.
Yes.
Yep. So interoperability is a work in progress in the new CHESS, in the reset of CHESS and the implementation of CHESS, and part of the benefit of Release 1 and Release 2 of CHESS is actually the enhanced interoperability standards. Now, this is the role that, I think the premise of the question is about the role that CIBO provides in competition and in actually encouraging not just interoperability on ASX, but providers, participants, to continue to format their systems to allow the CIBO access. That is something that is in focus for us at the moment.
Okay.
And I would also say we would agree that the role and future of CIBO or alternative providers is really important in the resilience story.
Yes.
Didn't specifically draw that out in answer to your first question because of the nature of your second question, that CIBO is in a sale process at the moment. Yep. I think ASIC's commitment to competition, whether it's CIBO or not, but let's talk about CIBO, should be clear from the licensing, for example, giving them the license with respect to the listings last year and being supportive of that, and actually our engagements with many market participants, both when we have our regular individual engagements and also through our markets panel on why our participants, if there are frictions or if there's some slowness in participants, signing up and getting their platforms.
So you're anticipating my next question, which really goes to, can a company listed on CIBO but not on the ASX be included in the S&P ASX 200?
I think it's probably not a question for me to answer, but I think the nature of your question is why are participants? Are you getting to why are participants not formatting? And so
you know, we've talked about cultural practices
yeah,
at the ASX. There will be systems resistance to
Yes.
change.
Yeah.
There can be cultural resistance to change, particularly when culture is, I think Mr. Longo described, you know, driven by the shareholders' remittances over other concerns. So what's going on with regard to the listings and the exclusion of some listings? Can you help me understand that? Because I think if you're going to have a competitor,
yeah.
most Australians would think that that they're going to come on a reasonably even field, but this doesn't appear to me to be that.
So the two key parts there's three parts to competitiveness. One is us continuing to use the powers we've got to license competitors and to work with them, be open to innovation. Innovation may be a competitive provider. So we've talked about SIBO, who faces in on, say, 10 to 20% of transactions. It's ebbed and flowed. We could also talk about the competition that alternative technology may represent, and that was the nature of Ms. Lawrence's questions before the break.
Yep.
So it may be that in 3 to 5 years' time we have a more global international markets infrastructure space, and that's perhaps beyond my imagining today, but you can see the pace of change accelerating, and it may be that some of these questions we jump a couple of steps in terms of competitive technology that actually, you know, breaks elements of dominance. I won't say monopoly, but let's say dominance of incumbent technology. That's the part that we play in this facilitating of competition directly. Where else do we participate? Well, we, in ASX and their mindset in terms of commitment to competition and critical national markets infrastructure, we have a role with respect to enforcing current standards and that those expectations, including around interoperability, including in design of the new system. So when CHESS comes in, release 1 and release 2, the changes to interoperability. The third part of your question is with regard to engaging with market participants. Now, there we are very respectful that market participants they're businesses, they have their own prioritisation, they have their own strategies to fulfil. That said, when we engage with them individually, some of the larger participants, for example, when we engage collectively in terms of through the markets panel, for example, that I chair, we have been consistently asking them what are the challenges that that may be stopping you from prioritising, from connecting, for example, with regard to ETF flow or other ways of participating where they can access the SIBO business. Actually, we get no resistance in terms of those discussions, in terms of mindset and commitment to competition. I would say that the Australian financial markets participants are welcoming and looking for. You went to confidence, to have confidence through supporting competition. We are respectful, though, that this involves IT configurations at a time when there are, at the moment, if you were to think about this week, they're navigating a lot of volatility. We also have the CHESS Release 1 in the background, and they have their own priorities. And I just must also note that these are the same platforms that in other ways we are raising or focusing on our expectations on them about what products they have on their platforms are, for example, made available in choice versions, for example, to superannuants. And we've been talking already today about sort of the superannuation system and choice platforms. So there's a lot that they have to digest and do, but I think the nature of your question was like culturally in Australia, what is the commitment to competition in markets infrastructure, and is my view that, or our view, that all the different participants understand their role in that, including ourselves, and I think can answer positively in that regard.
So if I go to brokers and platforms currently being able to offer product, do you have a role in ensuring that brokers and platforms can offer investors the same products listed on the ASX, on the SIBO platform?
We have a role in ensuring they are confident that we will support, for example, SIBO in their role, so that because there's an element of expense and risk and prioritisation for a participant to do that.
So this is the business decisions that you're referring to.
Yeah, the business decisions, And
So what if I put it to you that I've actually heard that some of it's not business decisions, some of it is, you know, old relationships,
okay.
cultural practice, mates of mates of mates keeping things going the way they've always been as a form of resistance. Would that be a shock to you, Ms. Constant?
That would be really disappointing because it's not consistent with discussions that we've had directly, as is appropriate in the normal course with the large entities we engage with. And if there's something you'd like us to take on notice in that regard, of course we will.
Finally, if I could ask on this one, and then I'll share the call to Senator Scarr. Even though it hasn't delivered, and I still don't understand why a company that's listed on CBO but not on the ASX, or on the ASX but not on CBO, can't be involved with the S&P. So if you want to help me understand the S&P index and its intersection with CBO as opposed to the ASX, that would be helpful for me.
There's some simple parts to that. I don't want to go beyond into my technical knowledge.
Yeah.
But the S&P index doesn't include trading from CBO, which is what you're...
Yeah, why not? Because it does in the US, doesn't it?
Well, we are engaging with S&P about that right now. So when I reference...
Because that seems it might be one of the structural barriers
when I
to
reference
your businesses that are resisting as well.
Yeah, so when I referenced engagements that we're having with participants, that includes the S&P index element and not just the Australian platforms. So that is something that, as I said, we can take on notice, including if that's part of your reference to what you see in terms of cultural resistance.
Yeah. We haven't sort of got to where we would hope in terms of CBO, ASX, open and a flourishing competition. There are breaks, clearly.
Yeah, and we would agree that being included in the index will be an important part of the many steps in the journey to opening up competition.
So there's been some policy gains, though, despite, that stickiness there. There's been, how are you going to make sure that any potential purchaser of CBO doesn't slip back? How do we keep the change going, and how do we have you engaged in speeding that process up? Do you have a role to play?
Well, that's a commercial matter for the first point is to achieve a sale, and then among the questions that will arise as to what technology they'll use, what platform they'll use. We'll just have to wait and see how that plays out. That'll be a commercial matter. But we will do whatever we reasonably can to facilitate an orderly sale, and that one that promotes competition and gives the new owner time to do what it needs to do.
And then ultimately they will apply to us. So for any entity or legal person that's acquiring more than 20%, they will of course ultimately need to apply to us in terms of the licence to do so. And as Chair Longo has said, and I think we've previously given evidence, we're staffed up, capable, focused on this and what those criteria are to be efficient and effective in supporting that.
So your eyes will be over this when it advances?
Absolutely.
Yeah.
So absolutely, the national interest and ASIC's interest we can see in a smooth, orderly, successful transition to a buyer that has absolute commitment to the role of CBO in the Australian financial markets infrastructure. And I've been conscious of acknowledging the different business considerations of participants in the various responsibilities they have. That said, we look to see alignment in that commitment to competition because that's good for them.
Ultimately.
In
the long term, perhaps in the short term.
That's what will drive the medium to long term.
Correct. Okay, thank you very much. Senator Scarr.
Thank you, Chair. I've been reading your annual report with interest, and I like a good annual report, and compliment everyone involved in preparing the annual report. I think it's a very, very useful document and helped me get up to speed pretty quickly with where you're up to. There are a few things that struck me, which I might just ask some questions about. The first is you prepared this very helpful Appendix 11 5-year summary of key stakeholder data. And I note it's quite extraordinary in many ways. 2020-21, we had 2.9 million registered companies in Australia, and that's now grown over the course of just 5 years to 3.6 million, which is it's quite a phenomenal number, 24% increase. At the same time, the number of registered company auditors has decreased from 3,553 to 3,073. So there's been a 24% increase in the number of companies registered, but a 14% decrease in the number of auditors. And I know, wearing my previous cap during my 9 months in my previous career before I rejoined the committee, that the issue with respect to shortages in the auditing profession, accounting profession, has been raised consistently. So I'm wondering have you got any observation with respect to the criticality of that issue of making sure Australia has enough registered company auditors, and indeed enough registered liquidators, noting there that the figures 649, 2020-21, it's only increased by 9 over the last 5 years, and that is an issue this committee previously looked at in terms of our inquiry into insolvency laws and what was happening in relation to insolvency, and it was raised then in relation to the number of registered liquidators.
Thank you, and thank you for very much for making it to page 245 of our annual report. That's quite
in March 2026.
Yeah, but thank you for drawing attention to the stats and what it speaks to about the health of some of the really important parts of our economic system, including auditors and liquidators. We've spoken a little bit today about some of the issues, but their numbers matter as well, like just how many there are and the health of them as a population. The companies number includes companies who are private companies and public companies, and it's only in relation to but I think it's a fair proxy. There's been a growth of, I suspect haven't broken it out, but I suspect it would be a similar proportion of companies that need to have their financial statements, that they lodge them with us, the audited financials. But to your specific question about the number of auditors, we are conscious of the numbers not either stabilising or dropping, or actually I guess they're dropping in circumstances where the number of companies and those that need their services are increasing. The other point to make is that we're relying on auditors as well for the substantial new responsibilities in relation to sustainability reports as well. So that's at this point just that group one. It's not that large by number of companies, but they're large companies, so they're going to have quite complex reports to provide assurance in relation to. It's an issue that when we meet informally with the professional accounting bodies and some of the firms that they raise, that question of attraction and retention of people who are working in this space. I don't have any particular insights into either the drivers or the solutions to it, but I can certainly assure you that we're aware of the issue and we agree that it's an important trend to be watching. In relation to the liquidators, which, it's a smaller change there, working closely with ARITA to help understand if there's blockages to people becoming qualified as registered liquidators. For example, we've been thinking through the licensing process that we administer, ASIC helps administer the registration process, whether the number of hours that need to be served, that's a statutory.
So, Ms O'Rourke, that was a specific issue that was raised with us during our insolvency inquiry.
The number of hours in
terms of the number of hours, and in particular the impact that might have on women.
Mm-hmm. Yeah, so that's the question of accruing the statutory number of hours within the period of time. And I'm pleased, I take from your question that's an area of concern. I am pleased to report that to the extent committees have been considering that issue, there has been in the committee decision to take registration a willingness to consider alternative ways of satisfying the equivalent level of expertise that are different from the strict this number of hours to accommodate exactly the sort of issues that your concern identifies. So we have seen decisions and have indeed taken steps to make sure the profession's aware of them so that others too can feel confident to apply with a set of circumstances that differently but nonetheless demonstrate their expertise and their suitable qualification to be a registered liquidator.
Okay. In relation to the grants programs, and these are the programs where ASIC actually pays or commits to pay money to liquidators so they can actually take important proceedings, and these can relate to director banning reports, as I understand it, asset recovery actions. So really important steps for liquidators to take in terms of, to use the chair's term, corporate hygiene, if I can put it that way, to hold people accountable and to protect the market, protect the public against those who shouldn't be directors.
So that's what we call our assetless administration fund. So that process.
How do you work out the money that's dedicated to that program, right? So obviously there needs to be a cost benefit analysis done, I presume. You've just, as the chair noted, ASIC's had this huge success in terms of civil penalties, and it does beg the question as to whether or not there's a capacity to provide additional funds to liquidators to make sure people are held to account, and in particular directors who shouldn't be directors are banned, so they can't be involved in new companies that are incorporated and be involved in the failure of those corporations providing, leading to debts and unpaid bills through mum and dad small businesses, etc., etc.
Exactly.
I might start and then pass to Mr. Savundra for anything additional. So to the extent ASIC's successful in achieving civil penalty outcomes, that's not something that then gets put into the same or any. It's a question of I think you can from the SMARC and
it goes in the consolidated revenue.
Yeah.
But I would have thought it's by whoever makes the decision in terms of ASIC funding. To me, it begs the question as to, okay, well, if you can actually achieve more outcomes, better outcomes with additional money going into the system, maybe that's to the common good, right? Anyway,
that's right.
that's not your decision. I understand that.
No, that's right. But I think the question of the administration, I think, is your second question there.
Yeah.
What's the total that we use under? And I'm not sure with the Assetless Administration Fund whether we've got a total amount that's then allocated.
Take it on notice.
Could you take that on notice, maybe? Note 7, you deal with your contingent assets and liabilities, and there's a reference to quantifiable contingencies.
Sorry, note 7.
Yeah.
Are we in the appendix?
So this is page 179
Okay, thank you.
of the report.
Scott, you might need to jump in.
And I'm just wondering if you've got any update with respect to what the result has been. So ASIC has estimated this matter, and there's a reference to a particular matter where ASIC had costs awarded against it. ASIC has estimated this matter represents a payable of 2.69 million. 2024 it was 1.8 million. I'm wondering have you got any update with respect to any of those matters? Presumably are legal fees or
Costs
they're adverse cost orders.
Yes.
So happy to provide details if
you want to take that on notice.
Yep.
I was curious how one went from 1.8 million. Is that the aggregate figure, the 1.8?
It would be the
It's
aggregate.
an aggregate figure, right. Okay, that explains that. Page 93, you've got a very useful comparative table with respect to outcomes in terms of enforcement and compliance, and I should say they're all very positive when you compare them year on year. One thing the one that stood out to me, and I suspect there's an impact from large matters, the average total time to complete an investigation and reach a court decision in months, 2023-24 it was 56, 2024-25 it was 70. Any reason for the material increase in time? And we're talking about months, so this is 56 months to 70 months.
I think that measures to the conclusion of the court matter.
Yeah.
Yeah, so obviously that's not all within
It's not all within
ASIC's control.
It's not all. I understand that.
And a lot of variables go into
Understand
it.
that. Do you want to take that on notice and just if you've got any observations with respect to any particular reason it increased by 14 months year on year? And it may well be there's a number of decisions which are still outstanding, reserved, and you're waiting for those.
Happy to.
I do note that civil litigation completed successfully as a percentage improved 82%. It was still pretty high. 2023-24 went up to 95%. So that stood out. Any comment on that?
You don't want it to be too high. Equally, you don't want it to be too low. Hopefully, just right.
What's the sweet spot?
I think 75.
100%. But it's a serious question. We can't be too risk averse. No, you can't. You can't.
The critical thing is that we run cases that ought to be run in the public interest, and we're not going to win them all.
So how do you assess a decision like Star then, where you've been successful in part, unsuccessful in part? Do you look at how's that get assessed for those purposes?
I'm not entirely sure. It may well be by a defendant. So, but again, even by a defendant, we can be partially.
Well, that wouldn't necessarily do you justice, I'd just say, but I'll leave that for you.
Okay.
ASIC's Money Smart website. So users visiting ASIC's Money Smart website, 11.7 million. It's quite extraordinary. And I've visited the site myself. Are they independent users, or would that include a single user potentially visiting, say, 10 times?
So that would be, that's unique users. So based on the analytics software provided by Google, that identifies unique users. Now, it is, I think, under that theoretically possible that if somebody has, say, is logged in as under a different identity on Google, they might perhaps be counted twice. But in general, the definition of that metric is unique users. So it's a reasonable indication. It should be close to that number, the number of actual individual Australians visiting.
So that's been hugely successful.
It has, and we continue to invest in trying to grow it because we think it's got such an important role to play.
Yep. Okay, very good. Page 164, I'm back in the notes. Note 4, there's supervisory cost recovery levies receivable taxation, supervisory cost recovery levies receivable non-taxation. How do you draw the line between the taxation and the non-taxation?
So that we use the tax office guidelines. They're quite explicit about how you make that differentiation. So it's quite a technical exercise, but we use that definition.
Does that go to the cost recovery question, or?
Well, it's involved in that process. That's right.
Okay. So 73 million of the total supervisory cost recovery levies receivables are considered tax. Is that correct? Is that how I read that?
That's correct. Using those guidelines.
Yeah. Okay. So that means they're over and above, in general terms, they're over and above what it costs to provide the service, if I can put it that way.
It comes down to the methodology in terms of calculating it, and whether it relates to the service or product in question, or a flatter fee. That's the basic concepts used.
Right. Did you have something to say, Rob? No? Okay. You don't want to enter into that discussion? No. Okay. All right. And just my last area, Chair, and this is an issue we've talked about before in this place. So, and we considered it during our insolvency review, and that is the obligation on liquidators, etc., to make reports to ASIC. So you get thousands and thousands of these reports from a whole range of licensees, Australian financial services licensees, liquidators, etc. And then we have to consider what action ASIC takes, having received that tsunami of reports. What was the term His Honour used? From Gulliver's Travels?
Oh, Rob Dingnanian.
Yeah. So I know
Twice in one day.
from page 219 of the report, you received. I thought you'd fallen asleep.
No, sorry.
He's young.
I wouldn't blame you. Oh dear. You received reports from Australian credit licensees about so-called breach reports, reportable situations, reports from auditors. It says you received 24,895 reportable situation form lodgements from licensees, 212 licensees reporting about another licensee. And then in the table below, table 25, oh, sorry, this is 218 and 219.
Thank you. Yeah, I'm with you.
You've got, I'm just trying to connect the 24,895 figure with the number in the table. The tables. So total breach reports finalised 2,849. Is that a subset of the 24,895 total received? Or is that something different?
Sorry, the first, what was your denominator? Sorry, your numerator?
So in the text, it refers to 24,895.
Reportable situation forms, yes.
And then it says you assess 224 AFS and ACL licensee notifications. So how do we bring that back to the 24,895? What do you do with 24,895 reports? How are you sifting through them and choosing which ones to progress, which ones not to progress?
It's a really important question and one we're thinking hard about. So we get the reportable situations are where companies, it's like what we used to call breach reports. And alongside that, we get reports of misconduct from others. Some of the reportable situations, that 24,000 number, are the ones which are about someone else. So if they've seen from another licensee an issue, we also have IDR and EDR data. And so how to best kind of bring the insights we can across those is something that we're continuing to evolve. We've got more long-standing processes associated with our reports of misconduct because we're receiving those for a lot longer. With our reportable situations, including with such a high number of those, we have got different analytical tools and ways of sorting them. We've also been thinking about sharing composite data about that information by sector and otherwise. So, sorry, I think the specific answer to your question is I think that it is a subset of that number, but if there's something about that subset or something more about the analytics that we apply to reportable situations that we can help you with, I'd be pleased to.
If you could you take that on notice? I'm just interested to know how you physically process, because then we look at the audited breach reports that are referred to in the table, reportable situations by type and outcome. Auditor breach reports 2,456, and that's a subset of the total breach reports finalised. So you finalised 2,456, and only 4% were referred for action by ASIC. Now, does that mean that 96% that were analysed and assessed for no further action, the 96% were found that there was no breach, or that you only have the capacity to deal with a percentage?
To assess even, yeah. No, thank you. And are you particularly, I suspect the answer is it's because it is such a high proportion of them that you've called out the auditor breach reports.
Correct.
Yeah. So I will need to take it on notice to understand exactly what that category covers, given it's a subset of reportable situations.
Yeah, sure.
And then I will do that. And the second question is, how do we get to 4? Like, why is that number low? Is it because we're not looking at some of the 96, or we've looked at all 96? And I understand your question.
So to the extent there's a breakdown as to that it was found there was no breach, that's one reason you might not pursue. To the extent it was minor and no further action was warranted, that might be an answer. I'm more concerned about the context of there was something that you
don't have resources.
You don't have the resources to pursue it. Okay,
No,
so happy for you to take that on.
And you'll appreciate when the numbers are getting to the 24,000, we are needing to think about triaging.
No, I
and what is
understand.
the right way of appropriately
Yeah,
dividing
I
our
understand.
resources. Yeah.
And then if we go to the next table, just on this same point, table 26, which is the statutory reports from registered liquidators. And this, and I'm sure you've heard this from...
And we've made changes in response to the feedback.
Oh, okay.
Yeah.
All right.
So this is a report that's prepared for 24-25, and over the course of the 25 calendar year, we undertook work in engaging with registered liquidators about the provision of both those initial statutory reports, but most importantly, in terms of what we ended up changing, the supplementary statutory reports. Both are statutory, as their title shows, like they're set as things that the Corporations Act requires. But we had heard loud and clear, as I'm sure you did as well, frustrations associated with lack of clarity about why a supplementary was requested, and that also that immediacy in most circumstances of when it was provided of a thanks but no thanks, kind of an immediate kind of automated, we're not going to take that any further, thank you. So we did do a consultation process, and from 11 April 2025 actually stopped issuing those automatic responses based on the initial statutory reports for the supplementary ones, and we've replaced that with a different model of receiving that we can still, and we still very much welcome those supplementary, the second reports, but it's based on the professional judgment of the liquidators. There's an open phone, an email, well, there's email available, and we're trying to make ourselves much more available by phone as well, for people in their, when they see something that they're worried about, to be in touch proactively with us, rather than it sort of being an automated and frustrating process that they're experienced. And we have received positive feedback about those changes. We also, in relation to those initial statutory reports, issued a guide, because some of the way that the form was set up through the portal that's there was very frustrating. People didn't know what information was going to be sought later in the process. They didn't know how the fields are related. And again, that guide has alleviated some of the concerns that were expressed to us. We've also taken out some of the questions from the form. So that's some of the steps that we've taken to try and improve how we work effectively with registered liquidators. As you pointed out in your opening question, they're providing us really valuable information about, I think you used the word corporate hygiene. And so we did want to improve how we were getting that information, because it is important.
Okay.
So going back to your
the
question
feedback
about
at the moment is
figures,
very positive. Have you got any preliminary figures you could give us in terms of the percentage of matters requiring now supplementary reports? Or
so in terms of requiring, in terms of an automation, automatically requiring, the number is now 0, because we've turned off that automation. So then it's a question of how many are being provided to us, and I can say it's a much lower number than these, but I'll find out what that number is, and I suspect it's really become much more focused on one's big areas of big concern in a particular insolvency, or those assetless administration funded actions by those liquidators. But you're happy to give you some more information about that.
Thank you.
And we're doing some other things that we'll share with you as well to try and to continue to improve those channels of communication.
Yeah. Okay. Thank you. Thanks, Chair.
Thank you very much. And I'll give the call now to Ms Lawrence.
Thank you. And in my block, I want to cover a few different areas, and my apologies because I appreciate it's the end of the day. You must be quite fatigued. So in the context, and I don't have this fact checked, but I have it on, I think, good authority from the Secretariat, that since 2001, the Corporation Act has doubled in length, now spanning over 4,000 pages, 800,000 words, and apparently longer than Leo Tolstoy's War and Peace. What recommendations or suggestions does ASIC have to the committee in terms of reforming the Act?
I don't think there's enough time between now and the end of my term to answer that question. The short answer is there have been multiple inquiries and reports that have tried to tackle that issue. And as I've said publicly many times, we're not good at this. We're not good at law reform. We're very good at, with good intentions, creating new laws, always well-intentioned.
I'm framing it with this because my next questions are to the new laws and powers that you're seeking.
So there's no doubt we have a regulatory complexity problem in Australia. It's a wicked problem. There's a lot of blame to go around for where we are now. So the Australian Law Reform Commission, after 3 years of Labor, produced 3 interim reports, imaginatively called A, B and C. And then they came out with a final report with recommendations that I think a couple of years ago now. As far as I know, there's been no official government response to those recommendations. That report focused on Chapter 7 of the Corporations Act, which focuses on financial services and is widely believed to be essentially broken. It's very complex and impenetrable. So look, I think from my perspective, there are lots of ideas about what could be done to simplify and amend the legislation. But it does require, if I may say so with great respect to the Parliament, a parliamentary will to tackle that. In the meantime, I think the approach ASIC has taken, and what I've said publicly and privately, is that simplification starts at home. And so over the last 18 months, ASIC has been doing, I think, some really excellent work trying to make the interaction with ASIC more seamless, a better experience for people. I haven't got the stats at my fingertips, but literally thousands of Australians either directly or indirectly interact with us. I think Senator Scarr talked about those 3.6 million companies. We get lots of inquiries and issues dealing with the administration of the company registry, among other things. We've tried to review the way we do regulatory guidance. One of the things the Australian Law Reform pointed out, which is regrettably true, is that a lot of our statutory instruments are hard to find on our website.
And what do you see? Do you see
there's a whole lot of work
AI being able to help to simplify?
Yeah,
the
a lot of people mention that to me. I think there is definitely a role
too optimistic
for AI, but I think there's a lot we can do without AI. I'll ask Commissioner O'Rourke to talk about this because she's actually done a lot of work on the committee or group that I set up, or the ASIC set up on this very issue. I think there is a role for AI, but there's a lot of work that can be done productively without the AI. And secondly, that actually requires a big investment. You're going to spend some money to simplify things. But, Kate, did you want to...
Just 2 extra points on that in relation to that AI question, specifically about it being a tool to kind of overcome complexity or some of the challenges of it. I think one of the things that people talk about is the quality of the data from which the AI is drawing its conclusions, and so we've been live to that and have thought that's been part of the impetus for what we've done is a big clean-up of our website. The web content included a lot of superseded pages as well as current pages, and so we got rid of 9,000 web pages, but the superseded parts of it, just so that then when people are using AI, that what they find from an ASIC website is current information, not superseded or incomplete or old information. So I think that wider point around using AI wherever you are, does come back to the quality of data, the foundations of it. And so that's one point to make on AI. The second is our chair referred to some of the work that we've been doing in different categories, and one was on regulatory guidance. And we did some work in that space, and we really, and it sort of probably sounds self-evident, but we're made very much aware that there's very distinct audiences for ASIC's content. And so we've got people who want the unbelievably detailed, specific, technical, depths of Chapter 7 technical guidance on those provisions, but we also have people who want a snapshot or a sense of an issue, or so whether it be kind of corporate leaders or parliamentarians or people who want to understand the why, the policies, the outline, or not outline's the wrong word, a short, concise understanding of an issue. Or there's also a category of audience, say small business, who are much more about what do I do? I just need to want to do what I have to do. Tell me what I need to do and help me do it, which is a different category. So I think, our understanding of how people are starting to think about using AI in relation to our content or any regulatory content is a bit audience dependent. And someone who's wanting really specific, because they're giving legal advice on it, is less likely to go there. But a small business person, if they're trying to work out renewing their ASIC, their annual review for their company or something like that, those tools might be more, that might be a more effective use in that situation. But it will vary, and I think our wider efforts in relation to simplification, either the stuff that we're doing at home or contributing to the wider debates about law reform, which is where you started, which Treasury takes the lead on, is done with AI awareness that, there's going to be tools of looking at things or synthesising things or communicating things that are changing. So we need to be live to those.
I imagine where there might be duplication, for example, you could get AI to identify where those are and then agrees to whether it can be consolidated
that's
and
right,
simplified. Lovely, thank you. And I guess in contrast, your submission notes that Australia's managed investment scheme regime is relatively open and liberal by international standards, and that Treasury is currently consulting on enhancing the oversight and the governance of the MIS. So again, just wondering if you can just give a bit of historical policy context or intent that led to Australia having a relatively liberal approach to the regulation of the MIS.
You want to have a go?
Well, I think that's probably a question for successive past governments in a sense, but our observation about the regime and the Chair's been quite clear about this on a number of occasions in public as well, is it is in some aspects quite a light touch regime. So registering a managed investment scheme that's available to retail investors in Australia is relatively simple. In fact, ASIC is required to register a scheme if the entity submitting for registration satisfies a few fairly basic requirements, such as having a constitution, having a compliance plan. In contrast to other jurisdictions, there are no real restrictions on what managed investment schemes can invest in, what types of assets. Other jurisdictions have limitations to try to reduce the risk to retail investors. Once schemes are established, they can change their constitution, they can change their investment strategy without any requirement to notify us. And as a regulator, we don't have the power to require them to give us data on a recurring basis. So there are a few of the key elements of the scheme that we see as being... We spent a lot of time thinking and talking about this, Chair. But that's because it is an issue of concern to us, and it's closely linked to the Shield and First Guardian matters that we've talked about earlier today. We think that there are a range of areas where we think there are regulatory gaps, but one key theme within that is the regulation of managed investment schemes, and that's why we're very supportive of the consultation that's underway at the moment in terms of strengthening governance and oversight, and that includes proposals that would give us the ability to gather some more data.
It's also closely linked with our work on private markets. So in our public and private markets work, we've also identified there's a lot of adjacency and indeed overlap, but the need for enhanced managed funds data reporting through adjacent law reform. In that regard, anything that's additional to what Commissioner Kirkland's mentioned We're working on a pilot with a sector of the funds management space in Australia to make sure we're really conscious of the commitment from government about not gathering data that we don't need and we aren't going to use. So that's why we're taking the pilot approach. But we're looking to test the feasibility of that in the next financial year in terms of enhanced data gathering through that pilot approach.
I think I recall a conversation around this matter in Canberra when you were there, Senator Scarr. We were concerned about this Liberal managed investment scheme, and I think it was made very clear on that occasion that there was no requirement for any indication of even liquidity, and there's certainly no assessment of the offering. And I think you quipped that in the US it would never get up. That there was a comment there. There's a different model of accountability before a product could be established, which is quite a different way of thinking about the products that we put in. So I think this is a very interesting space in terms of where the protections lie. We're dealing with a big claim.
I think also, Chair, one of the issues that was raised, and Chair Longo, I remember this from the Sterling inquiry we had, is promoters will say it's a registered managed investment scheme, and consumers will see that and think it's totemic of a safe investment because ASIC has gone in and signed off on everything, whereas as Commissioner Kirkland's advised, that's simply not the case.
We certainly see examples of promoters actively promoting the fact that a scheme is registered with ASIC, which creates an impression which we think is out of step with the nature of the regime.
Correct. Yeah.
So, in the context of the powers you have available, in particular Section 601 FF and Section 912E, where's the shortcoming in the availability of the powers under the Act presently in terms of the additional powers you're seeking for MIS? So
just to step through, I guess, some of the issues that I mentioned earlier. The fact that schemes can change their constitution and change their investment mix means that we don't have any ability to understand where there might be a sudden shift in risk to investors. So if a scheme has shifted towards high-risk property investment, which is where we commonly see problems, we won't necessarily be alert to that.
So it's about the change as opposed, because at the moment you can check whether they're complying with the scheme's constitution, but it's the fact that they can change it without presumably that notification of the fact that it's moving investors' funds into higher risk.
So that's right. They can change their constitution. They can change their investment mix without us being in any way alert to that. We can't require them to give us data on a regular basis. Another example in terms of data is we can't see if there's been a sudden flow of funds into a particular managed investment scheme that might indicate there's actually a chain of lead generators and financial advisors channeling people in there, which could be another indicator of risk. We just don't get that data at the moment, nor can we require it on a recurring basis. So that's a key gap in the regime at the moment.
And I think it's really important to keep reminding ourselves that we have no supervisory or monitoring role over a managed investment scheme. We don't even see the product disclosure statements. So a lot of money gets invested in this sector, and in fairness, a lot of it is fine. We only hear about the ones that become very problematic, and unfortunately, when that happens, a lot of people tend to be affected. But it's very important people understand we have no ongoing monitoring or supervisory role of managed investment schemes. We don't get any data. We don't get the product disclosure statements. The other aspect of this, which hasn't come up yet, but I feel bound to raise, is the number of people deemed to be wholesale investors has grown enormously, and that is a problem we have chosen to have. While the retail wholesale investor test remains almost 25 years out of date, we will continue to have these losses, and they will happen again and again and again, and ASIC will be expected again and again and again to pick up the pieces. In my respectful judgment, it's just not a reasonable expectation of the regulator, and it's not how the system was designed to work. So,
can I just do an ad for the day of inquiry that Senator Starr and I did with regard to wholesale investors, and that there were some, I think, timely points made about changes to our economy, need for innovation, funds that are going into innovation, intersection with private markets, public markets, sophisticated, not sophisticated, wholesale, retail, that this space is very, very rich for serious policy consideration.
Right.
And I think that report stands as a descriptor of the challenges without really signalling a clear path forward. It needs more investment of energy.
we are a risk-taking nation. The system
Served us well. It's the greatest country in the world.
So, but with risk comes occasional losses, and I think that. I think I need to be very frank with the committee about this. There's a financial literacy issue in Australia.
Agreed.
We want to encourage risk-taking, but with great respect to a lot of people who invest money in a whole range of things, they don't really understand risk, and some of those matters were mentioned today, and they've lost their money. And the critical question is, how do we think about that from a policy perspective? But if we're trying to encourage risk-taking, then we have to accept that people will have losses, and that's not something that the government or the taxpayer can always, be there to pick up the pieces. So this whole, I personally think the Money Smart website's done some excellent work. I keep getting positive feedback about it from a range of people. It really is something we want to continue to invest in. And I think it's actually doing a lot of good work, particularly explaining to people how superannuation works.
That's where I do a plug again for Terrigal Pub. Every time you mention Money Smart, I remind people that I heard two men at the bar settle their debate about financial product
By going to
Money Smart while they're standing at the bar at Terrigal Pub. Great place to have a drink and get some financial discussion with your mate.
So this whole question of financial literacy, I think, is an issue for all of us.
Yeah.
And we'll do the best we can to
Do you think the
invest.
cooling off periods will support,
You're talking about super switching? No.
Correct, yeah, just in the super
That's
switching.
there's been some discussion about super switching for some time now, which I think I might have started. But I will ask Commissioner Kirkland to give us the latest on that, because I know you've been doing a lot of work with Treasury on it.
So it is something that the government said that it intends to consult on in the coming months as part of another package. So I understand there'll be several consultations on several different packages of reforms. We've talked about the managed investment schemes one. I think there's another one coming in relation to a range of potential changes or options for changes in relation to superannuation switching. And we think it is worth at least considering inserting some more friction in that switching process, because what we see particularly through our investigations on Shield and First Guardian, is that after what's often a really long and persuasive series of phone conversations with a lead generator and potentially a financial advisor, there is then pressure on somebody to sign a statement of advice for them to switch their super, and then that switch at the moment has to happen very quickly. It's worth considering whether we can slow down that process, create some more opportunities to get information, independent information and advice to people in that interim period, because, as I say in all the media interviews I do on this, switching your super is one of the biggest financial transactions you could ever make, besides perhaps buying a house, and people need to see it with that level of significance.
Thank you for that. Do you think it would have had an impact in the Shield First Guardian situation?
Our view is no single reform is likely to be effective in stopping that sort of harm happening in the future, but we think there's a range of regulatory gaps, and a carefully crafted set of reforms nothing will completely prevent these sorts of things happening to some people in the future, but we think we can significantly reduce the risk and the scale at which we might see those sorts of problems in the future. So, so we've talked about mis-regulation, we've talked about super switching. Another key one is lead generation, which is where a lot of this harm starts. So the telemarketing and advertising firms essentially find the victims in the first place.
And the survey, don't forget the survey on social media, right? Because that's really the one that got a lot of people that had no idea that they were giving permission. as they just filled in a little bit of an interesting survey.
Indeed.
And just two more. So again, following the Shield and First Guardian matters, will ASIC publish guidance to platform operators on how they present investment products and costs to retail investors?
We're not proposing any changes
we're
to our
not-
guidance at this
At this
stage.
stage.
Actually, we're not proposing any changes because that isn't really at the heart of the ASIC's role within the issue. So
Just for earlier, Commissioner O'Rourke was talking about, providing information
Yeah.
in
we have.
guidance and so forth. Would this be an area where you might consider it?
We have very detailed guidance which goes to, for example, disclosure of fees, how fees should be disclosed when it comes to superannuation. So Regulatory Guide 97, as an example, it gets a lot of discussion and debate and a lot of focus. We will be, I should say though, we will be refreshing Regulatory Guide 97 in the coming financial year. It's a very comprehensive and time-consuming process, and we'll be putting that time in, and we'll take into account changes, learnings, and of course stakeholder consultation and feedback. When it comes to investment governance, I think, which is where your question was going, very respectful. APRA is the lead agency when it comes to investment governance. That said, the only final points I'd make are we have done work and will continue to do work in and around, for example, observations by super trustees of advisor behaviour, where they can see members, customers being advised into different options. So through screening flags, for example, they might see that there is a lot of money being paid to a particular advisor, or suddenly there's a lot, or trustees should be sampling statements of advice to make sure the advice is there. We've published work in terms of that 2 years ago. We're refreshing it. We have also published work in the past and are refreshing it around choices on platforms. So it's a slight adjacency which goes to the fact ASIC has always said, as APRA would, decisions should not be made and information given to members to make choices simply on fees and costs. It needs to be performance-based. Is the product doing what it said it would do, including in terms of if a trustee is offering it on the platform and putting it forward, are they assessing, is it performing and returning, which goes to the trustee's responsibilities to members. I just wanted to complete the answer,
Sure, no,
although
appreciate
APRA
that.
has the lead on investment governance.
That's excellent, thank you. And I guess just to close, in the context of your earlier remarks, Commissioner Kirkland, about these are all various tools to, that we've been describing here, and to perhaps go back to where we perhaps started around culture this morning. And I just want to go back about a decade, where your former chair, Greg Medcraft, spoke of the poor oversight at that time around the bank culture, which encouraged financial planners to act in self-interest, which obviously we saw result in the loss of millions of dollars to clients. And at the time, he was saying ASIC thinks culture is a major risk to investor trust and confidence, and to fairly orderly and transparent operations of our markets. So with that in mind, I was just reflecting, and thanks to Google, an old article where he had pointed to laws that allow companies to be charged with being an accessory to a crime if the company's culture encouraged or tolerated breaches of law. And under Section 12.2 of the Commonwealth Criminal Code, a company can be held responsible as an accessory for a breach of certain Commonwealth laws by its employees if the company's culture encouraged or tolerated a breach. So just in the context of everything we've talked about today, with the outcome of Star Casino through to, where we've got these different platforms who are knowingly taking money through these cold calling activities, what can we do around culture to really
Part 2.5 of the Commonwealth Criminal Code has been very disappointing. There hasn't been not a single successful prosecution of a corporate entity under Part 2.5 of the Commonwealth Criminal Code, which took effect from 2001. I mentioned the Australian Law Reform Commission report earlier. The one before that was on corporate criminal responsibility, and a lot of that report was devoted to 2.5 of the Criminal Code. And that code, which is the law in Australia, is a Commonwealth Criminal Code. It hasn't been replicated at any state criminal code. I think the Northern Territory has adopted the federal criminal code, and it does attempt to define corporate culture as a mechanism for criminalising corporate conduct, but there's never been a successful prosecution under it. So I think the premise is correct, though. I think obviously culture is enormously important to the success of any institution, including corporations. But regrettably, the Commonwealth Criminal Code simply hasn't worked in that respect.
Perhaps
Many legal minds,
what it might need
yes.
to look like.
Exactly.
Pardon?
We've got some
Perhaps you
great
could take
legal
on
minds.
notice what it might need to look like if it
Well,
were
I
to
think
be
I
effective.
don't need to take that question on notice. With great respect, I would simply refer the committee to the Australian Law Reform Commission report on this
Recommendations.
topic. That's right. I can't do better.
They've certainly invested a bit of energy in putting it
They
together.
did over 18 months.
Yeah. Thank you. Thank you. Ms. Jarrett. I have a number of questions, but a couple I'm going to leave until the next hearing because they're not urgent, but it is International Women's Day on Sunday. So I thought I should ask a question in relation to gender, and there's a couple of issues that have come up in my electorate, and this really is a question about the culture and conduct of ASIC as opposed to laws and regulations and policies at the moment, because I'm very conscious that the Chair reminded me of the financial abuse report and the large number of recommendations for potential policy changes out of that. And that's obviously work in progress. But looking at your culture and how you prepare your frontline teams, your backline teams in relation to managing some of these issues, do you feel that your group, your people really understand and manage those situations well? And I'll give you an example. I had somebody talk to me, she was an insolvency creditor. She was a creditor for her partner's business. It became an insolvency case. And she felt like she had to continue to explain things, that maybe instead of having alerts in the insolvency space, it might be better to have, regulatory guidance issued, things like that. So my question really is just a broad one around your approach to victims of domestic violence and how you're tracking that with your own internal data.
I think there's a number of different elements to your question.
There is.
I might see if our CEO wants to talk about that internal cultural piece, which is of great significance to us.
It's a big operations piece, yeah.
In terms of that, but then to the extent that extends to your second part of your question around coerced directorships or dealing with violence in the regulatory or enforcement work that we do, Mr. Kirkland and I might be able to supplement. But yeah, did you want to start?
I'm pleased to start. Ms. Jarrett, Scott Gregson, the CEO at ASIC. Issues of equity, inclusion are core cultural aspects at ASIC. There's certainly matters that existed before my arrival at ASIC 12 months ago, but ones that I've certainly taken as core components of my responsibility as a CEO. And that's not just in relation to gender, equity and inclusion, but across all cohorts and areas. We do a number of things to encourage and support that, including our support for International Women's Day. We held an event actually just yesterday that Commissioner Constant supported, and we actually spoke about and had speakers talking about the concept of and the issues associated with domestic violence and economic coercion. We have a number of strategies and policies that seek to provide and support those issues of inclusion and equity, including in relation to gender. We have just published our latest pay gap reports, and we very much participate in the WGEA framework. And we've just made commitments as we're required to under the WGEA framework, including setting targets for the continued erosion of the pay gap, making sure we're doing analysis and reporting on that, and looking to provide equal representation or more balanced representation across all our cohorts. So it's something that we take very seriously and is very much part of my KPIs.
I might just add, as the Commissioner who sponsors women at ASIC and having facilitated the event yesterday, but also late last year an event around White Ribbon Day that focused on domestic violence and actually violence in all its forms and coercion in all its forms. A statistic, I know you're looking for data and indicators. I think in the event last year where we profiled the work in and around financial abuse and also domestic violence, including the training for our own people to be on the front lines there,
what I'm really getting
and
at,
the
yes.
awareness, but also the importance of all of us as colleagues, where in a way with our colleagues we're also on the front lines, because you never know what's going on with your own colleagues. I think the event we ran late last year, for example, had almost 1,000 people joining. And we were hearing from experts in empowerment and how to identify, and also in what responses can look like. So this is something that is, and it was the same yesterday. Yesterday, actually, our guest speaker was about economic control, financial coercion and economic control. So there's training within the training programs for the different divisions in their roles. There's also actually an organisational wide, not just commitment to diversity and awareness and of support for our own people, but of what this means, how to identify it. And just one important follow-on from that, for example, is the statistic you may well be aware of, that if you ask women whether they've been subject to financial coercion, economic control, I think the statistic at the moment is it's around 14% will identify. If you then show them what it actually is, the number who identify as being victims of such are around doubles. So different numbers, but around doubles, because it's not even well understood what that is. So one of the reasons to run discussions like yesterday, we had an expert, the CEO of the institute that is expert in this, is to educate our people in how to identify this and what this is.
Yeah.
And then I'll let others talk about the sort of external.
Can I just say that's actually really good to hear, because it's not something that just comes naturally to people.
That's part of the problem. That's part of the problem. We're really committed to that, and in the next 12 months, as part of Women in ASIC and just generally commitment to culture and us understanding our customer service and frontline roles and responsibilities, and in understanding the work that's been done, for example, through this committee on financial abuse and our role there, this is something we're quite committed to continuing with. And the take-up and the Q&A that followed from yesterday is testament to the fact that people don't understand it, they want to understand it, and of course we have a core role. And one final thing before I hand to others is, quite proudly we could talk about the work we've done. For example, we've talked about Money Smart a bit today. We're all a bit proud of Money Smart. We have I think the title is Getting Away Quickly or Get Away Quickly, Quick Exit.
Quick exit.
Literally, because understanding when people are in these circumstances, first they've got to understand this is right, they're right, this is not appropriate, they're under an element of coercion, control, potential abuse. Then what do you do? So when we talk about frontline, it's not just people on phones or receiving inquiries, it's also those 11 million unique visitors to that site.
How many?
We spoke earlier. Over 11 million unique visitors to Money Smart.
Yeah.
So it's a really important tool, and that's a way of interfacing as well.
Yeah, thank you.
Others want to add?
Nothing to add on the training point, no.
No, it's really just your internal culture, etc. The external and everything, that's a whole bigger discussion. Yeah. Thank you.
Wonderful, thank you. Can I indicate that there will be quite a number of questions on notice? The Secretariat has been doing an excellent job in preparing a pack for us. I just want to close with one short session on, won't surprise you, auditor independence.
Can I ask one follow-up question?
Please go.
Just to close it out,
ahead.
please.
Send us go.
And Commissioner O'Rourke, you mentioned ASIC liaising with Austrac in relation to the CBA matter of fraudulent loan applications. Is APRA part of that group, and to what extent, what falls within ASIC's domain and what falls in APRA's domain?
Thank you. I think when we were discussing that issue earlier, you asked whether there were kind of special groups or existing relationships, and so I did want to come back and confirm. My initial response was to confirm that we do have open lines of communication between people at Austrac and people at ASIC, and similarly, of course, with APRA as well. To this more second question, and then just before the break, because I wasn't sure earlier, has this issue in relation to bank fraud been something that's been the subject of those channels of communication? And I was able to confirm it has been. I'm sorry, to the extent I got that confirmation, I didn't hear whether the APRA folk were in those meetings as well or not. So I'll have to take that second part on notice. I'm sorry.
And your comment with respect to Austrac was with respect to all of CBA, Westpac and ANZ, or just in relation to CBA?
I had understood when we had that discussion, it was a little bit earlier, and we were just talking about CBA. So that was the.
So if you could take that on notice as well.
Yeah.
Wonderful. Thank you very much. So we had some discussion about auditor independence, conflicts of interest and conflict management a little earlier. I'd like to go to the ANAO audit of ASIC's regulation of registered company auditors. So the 4 recommendations to ASIC, as I understand it, are quite significant and accord with concerns that have been raised a number of times by this committee over the years. Developing measures to report on the performance of regulatory outcomes for registered company directors, company auditors, to ASIC to report publicly on the timelines of processing registered company auditor resignations and removal applications. Review and improve ASIC surveillance activities related to registered company auditors, including reviewing the allocation of resources between individual audit file surveillances and thematic surveillances, and monitor and report on whether registered company auditors undertake the remedial action they commit to in response to ASIC audit surveillance, and implement the procedures to use ASIC's audit deficiency powers. Now, I'm led to believe that there's some progress in the implementation of those recommendations. So some questions I have arising from that is, as a result of ASIC's inquiries during the 24-25 surveillance period, what are your key areas of concern regarding financial reporting?
Oh, okay, thank you. Yep, so the key areas of concern in relation to financial reporting from that period of time were described in some length in Report 819, which is our report of ASIC's Oversight of Financial Reporting and Audit 24-25, which was published in October 2025. So I think, was your question particularly on financial reporting rather than audit? Yep, no problem. So in our section 1 of that report, which starts on page 9, that sets out the financial reporting surveillance that we undertook. So we reviewed 254 company financial reports and conducted surveillances, so additional inquiries in relation to 22 of those. So the 5 main areas of concern, the first was the operating and financial review. So as you'll know, in a financial report, that's where there's an opportunity to discuss what the figures really mean, and we were particularly concerned about the absence of information about material business risks in operating and financial reviews. The second, and that was the area of concern that was most prevalent. The second area is impairment and asset values that we had some concerns around. The third was non-IFRS profit information. So the IFRS has quite specific rules about what can be presented as profit, and when people use other presentations of profit, it can be confusing, and that occurred in a couple of the cases that we saw. Revenue recognition was another, and then debt classification. So they were the main areas of concern on financial reporting in 24-25.
Okay. With poor reporting, there is very likely material impact. Is that possible?
It's if you think, for example, about the absence of material business risk information, it's hard to know whether or not it will have impact or not.
But it should certainly be reported.
Omission of information is really important. That's why we've called it out.
Yep.
But will that mean the actual business risks being faced are bigger or smaller or will manifest or not? It's a little bit hypothetical. We think it's so important that those operating and financial review sections of financial reports are complete. And so we have taken this year, so we do enforcement priorities as well as strategic priorities. And for 2026, a new enforcement priority is in relation to financial reporting misconduct. We've already got one in relation to auditor misconduct, but the new one in relation to financial reporting misconduct particularly calls out the failure to file financial reports at all. So that's, before you even get to how good's your OFR, you have a report. Yeah. So look, that's a development in 2026, and you're asking about 24, 25. So sorry to mix my years.
No, that's okay, because you've covered off a couple of questions there, but there might be a little bit more interrogation. The recommendations that the ANA have made, I just spoke to.
Yeah, sure.
What were your thoughts when you got that feedback from them?
Thank you. No, we, with reviews like these, it is an opportunity. So it's an opportunity both to sort of showcase the work that we've done and that we are doing. As you know, we've been talking about a lot. We've evolved our work on auditors over the last 3 years quite distinctly. So being able to just describe what we've changed, why we've done so, but also say, and what could we do better? It's an opportunity to continue to improve the work that we do. So we, as you can see from the fact that from the report we've accepted all of the recommendations, we think they're valuable, and we're working to implement them. As you've said, some of them are a little bit more straightforward. So that third one around publishing the timeliness of processing RCA resignations and removals. We already had a target, so publishing it is quite straightforward. So that one is quite, it's a sort of a question of when we do it and where we do it, but it's not a more difficult one. And then some of the others, we're thinking about doing them carefully, but we're absolutely committed to them. So, getting that performance metric, the first one that you referred to, then it's more about the reporting on the performance of auditors rather than a PGPA Act performance metric, which I'm sure you understand is quite a different thing. So this is really thinking about, okay, so we do an annual review of annual report. I've just been reading from number 819 for 24-25. How do we best incorporate in there these measures about performance in a way that's going to be sustainable and measurable over time and really help change behaviours? Yeah. So that one is all of them were underway, but that one is a little bit more complicated than the first one that I mentioned. Unless there's others that you particularly wanted to drill into, we're thinking about all of them.
Okay,
and
great.
Implementing all of them. Yeah.
Could I just ask a follow-up? Given your travels, talking to other regulators, are others doing that, like looking at the performance of auditors?
Do you mean in other countries?
Yeah, in other countries. Yeah.
I'm sure that we have quite different structures. So in other jurisdictions, they have standalone auditor regulators.
Yeah.
And so that provides a different scenario than somewhere like us. We've got, if you look at our industry funding model, I think we've got 51 or 54 classes of entities that we regulate. So, it's not like we can have a performance measure that applies, we can't have 54 of them. So what do we do specially there? And I understand your question is, but what do other people do? Yeah. That is we're part of international federations of IOSCO and other, I think in relation to regulators, it's a little bit different because they're not generally securities regulators. But I take your point that it's valuable to look at how other people have done that, and I'm very confident the team's doing that.
Yeah. Okay. Good.
We started with Star. I want to finish with Star.
Before we finish, I just want to confirm, I've just checked that I can confirm. I wanted to confirm something earlier. We have communicated to CIBO our support for their auction-based routing proposal, which I think you're referring to. I just had to check whether we had confirmed that, so just to close that out.
Thank you very much. In an article in Accountants Daily, who might have some knowledge about the pressure that accountants and auditors are under, they talked about the Star Casino
issues with regard to hostility to internal audits. I don't know if you recall this article, but it's quite revealing in a way that most people wouldn't ever sort of see what happens to an accountant when they're in there trying to do this. I do remember some questions along this line with regard to EY and CPS 230 maybe a long time ago. Pressure put on them to edit and edit and edit and edit until they until the purchaser got the product that they wanted from the internal auditor. I was concerned then, and this really brings to bear some of my concerns now. It's September the 15th, 2022. It's by Philip King and Accountants Daily. And he said, this particular incident shines a light on widespread problem of management hostility to unfavourable reports by internal auditors. He goes on to say, Peter Jones, the main issue we would like to raise is these problems by no means unique to this particular organisation. Similar failings were recognised by the Royal Hague Commission. So that reference back there to this cultural practices that are applied by boards if they get to see original documents, but certainly by management, perhaps prior to the information getting to the board. Mr Jones asserts that in any organisation, the first line of assurance is line management, second compliance and risk, the third and final is internal audit. According to the report, the in-house internal audit team engaged KPMG to carry out an independent review of the AML CTF program. This is in line with our best practice recommendations. However, failures came to senior management's reaction. The report was not given to the audit committee until the day before their meeting in late May 2018. And the message from the CEOs that there were a number of problems and inaccuracies within the report. The audit committee didn't have time to go through it properly. And it's asserted that KPMG was pressured by senior management to change a number of findings within the report. The internal audit team and other management were given a clear message that bad news was unwelcome. The report was erroneously treated as legally privileged and was subsequently held back from the regulators, Austrac, for around 2 years. So it does go back to those initial problems that we're talking about. How aware are those who are working in internal audit? How aware are you of those working in internal audit being subject to this kind of pressure, which is material? You know, if they don't do as they're told, they potentially lose their client, and there's a financial cost to them and a reputational hit to them as not being a tough enough player to, play the game that is internal audit as a, consultancy basically to sign off on a clean bill of health. Where's the pressure in the system? What's your role in terms of making sure this cultural practice can't exist?
I think the short answer is we don't have a role in relation to internal audit, in the sense that that's not something that's completed by a registered company auditor or something that's signed. Internal audit practices really vary across different...
Can I just say, though, that the partners who are doing this are in partnership with the registered company auditors that you are looking after, and they're jointly responsible inside the partnership for this. So clearly they must know that this is going on, and it's part of a business model that's operating.
I think, in this particular circumstances, you can see that there is KPMG, one of the large firms who's been hired to do internal audit work, and in other places internal audit work is done by employed staff of an organisation, and other places it's a combination of both, or depending on the different circumstances. So there is quite a high level of variety, I understand, in terms of how internal audit is resourced, and I'd say probably a variety in terms of the risks that you've called out. I can't help but...
We do deal with the Institute of Internal Auditors, which is effectively a professional body, and we see them as an important stakeholder and regularly speak at their conferences, and I spoke at their conference, I think, last year. And my sense is that they're the people that work in that area take great pride in their work and understand the value that it can provide, and we have absolutely reinforced that we think that they can play a key role in seeing things perhaps before we see them or before they're reported to us, and indeed they can play a key role in bringing those things to light through things like speak up programs or whistleblower protection. So we've really tried to reinforce that role through our engagement with the profession.
Can I restate that they are partners in a business model with the people who are registered with you? So I don't know how they can continue to be separated out from one another. The businesses that they're operating in which they have a partnership role and are joint and severally liable, are implicated by the challenges that exist for the internal auditors with whom they share profit annually. I just want to point that out. And to have this evidence that Mr. Becker, who we commenced with this morning, sat down, turning pages of the report, essentially berating us for the whole entire time of that meeting, is something I think most Australians would be pretty shocked by. You know, you sort of have a very proper sense of what an internal audit team would go in, get the documentation, provide the report, walk away. Star shows that absolutely that was not what was happening. And sadly, too many other whistleblowers are telling me what we've just described there, what manifests itself in the judgment of Justice Bell yesterday, is all too common. All too common. And your registered auditors are in companies that are impacted by this, and they have some responsibility for the internal audit that then ultimately impacts the whole audit sector. So I just want to talk, I want to get something from you thoughtful on the record later, perhaps on notice, about how you consider that intersectionality and where we can press on that for better outcomes for the cultural reform that's necessary.
Okay.
Thank you, Chair.
Thank you. An easy one at the end, hey? Can I just thank you so much for the endurance throughout the day. It's a long, long day, and we did have to cancel the December hearing. So I really appreciate that we've covered an awful lot of ground today. We'll see you again soon in May. Can I just thank my colleagues who have been here today to undertake this questioning on behalf of the Australian people. That concludes today's hearing. Thank you to all the witnesses who appeared, to Hansard and Broadcasting for their assistance. Thank you to the Secretariat for all your work in supporting the committee, as usual. And again today, I advise witnesses that responses to any questions taken on notice should be provided to the Secretariat by the 2nd of April 2026, and the committee stands adjourned. Thank you.